Morning, colleagues.
Morning, CJ.
Morning.
Morning.
Morning, Chief
Let
Justice.
me take. Thank you so much. Thank you. Let me take this opportunity to welcome the Judge President of the Western Cape Division of the High Court, Judge President Sope. Good morning, JP.
Good morning, Chief Justice. Thank you so much.
And thank you, sir. I also take this opportunity to welcome the Honorable Premier of the Western Cape Province, Honorable Premier Venda. Good morning, Premier.
Morning, Chief Justice. Thank you very much. Good to be here. Morning to you and colleagues.
Thank you. Before we start, let me just make this announcement. Commissioner Barnard has recused himself from participating in these interviews. Unfortunately, he only got to inform his alternate, stand to be corrected, either late yesterday or this morning, Mr. Nokesi, who is unfortunately committed already. And it is for that reason that none of them will be here to represent the body that they were here to represent. Apart from that, it's all systems go, and we should be ready now to start with the first candidate. Good morning, Mr. Francis.
Good morning, Chief Justice.
How are you, sir?
I'm well, thanks.
It's not always easy to be the first candidate, so I'll have a slow start with you. And once I'm happy that you are settled and comfortable, we can then move with high speed. You hold a BA and BA honors and Master of Arts degrees, all in political science. Am I right?
That's correct, Chief Justice.
And you were a lecturer and all the way up to being a senior lecturer at the University of Natal some years back.
That's also correct, Chief Justice.
And then you acquired the Bachelor of Laws degree, and amazingly, you got it cum laude.
Fortunately, thank you. Yes, that is so.
Yes. Since when have you been an attorney? For how many years?
For 28 years, I was admitted in February 1993. So it's 28 years.
And I take it that you've been doing well.
Sorry.
I take it that you've been doing well in practice.
I would like to believe so. I run a fairly successful practice.
And you also have a postgraduate diploma in environmental law.
That's correct. I initially started with a master's degree in environmental law. That's whilst I was lecturing. I completed the coursework component, but then had to return to private practice. And that master's was then converted to a postgraduate diploma.
And you've acted several times as a judge of the High Court.
That's correct, Chief Justice. I've in fact acted for 8 complete terms.
And was it a difficult transition from practicing as an attorney to acting as a judge, or was it not difficult at all?
Well, fortunately, there was a great deal of help from colleagues on the bench. I found it quite an exciting challenge. During my practice, I did chair many quasi-judicial tribunals, so it wasn't an entirely strange experience, but it was a very sharp learning curve.
And for how long would you say you've kept a judgment reserved to the point where you became uncomfortable? What is the longest?
The longest was exactly 3 months. It was a very difficult matter that ended up in the Constitutional Court. But generally, I hand down my judgments within 3 weeks to a month. There are some judgments that require a great deal more reflection and thought, and but in fact, in every case, it's definitely
Yes.
within 2 months.
Just to clear this one before questions are put to you, as I did with another candidate, I noticed that you've been a branch member of the African National Congress from 1992 until now. Are you a Kakeri member?
I must confess that I am not a member in good standing. I have not paid my dues. I have not actively participated in the ANC for the last 10 to 15 years. So no, I'm not an active member at all.
So are you a member at heart, or what is the position?
It's yes, I consider myself to be a member of the ANC, but not an active member at all. And if appointed,
Okay.
I would have no difficulty resigning from the organization.
Okay, all right. Before I call on the JP and the Premier, colleagues, may I have the names of those who have questions for Mr. Francis, please?
I do, Chief Justice. It's Jenny Kane, and good morning to everybody.
Nyambi,
Thank you.
Muimang,
Schlemmer.
Dodovu, Makwanisha.
CJ, I said Tepe. I spoke at the same time.
I've got you here, ma'am. I've got
Thank
you
you.
here.
Thank you, CJ.
After you, it was who? There was somebody after Honorable Dodovu and Commissioner Tsepe.
Anisha.
I think it was Mr. Magwanisha, Chief Justice.
Lamola.
And Breitenbach.
Thank you, Honorable President.
Singh.
And Honorable Singh.
Yes.
Thank you.
Maya.
Sorry, who?
Maya, CJ.
Oh, okay, President. Okay. Honorable JP, over to you, sir.
Thank you very much, Chief Justice and honorable commissioners. It is customary, that's my understanding, for commissioners to disclose. I have known Mr. Francis for a very long time, for a period in excess of 30 years. In fact, he was my student at the University of Natal in Pietermaritzburg. I taught him labor law and I think administrative law. He's one of the brightest students I've taught in a very long time. I also taught his late wife, Brenda. So I know him very, very well indeed, and I would like to disclose that. At this point in time, Chief Justice, I don't have any questions for the candidate. Thank you very much.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice, and thank you for the opportunity to Mr. Francis. Thank you very much. It is for me an honor to be here on this panel, and for that point, I'd like to bring to you my first question. I am new to this commission, and I must say that I've watched a couple of commissions online. I have also participated in my first commission meeting earlier this week. And as a very proud South African, I'm specifically proud of our constitution. I am proud of our system of having a separation of executive and parliamentary processes to judiciary and judicial processes. And I must say that post my meeting on earlier this week, I was wondering about this specific commission and the processes that we go through. And I was wondering, in my opinion, that whether there's a blurring of the lines between independence of the judiciary and our political sphere and the executive and parliamentary processes in our country. And I was wondering what your thoughts would be on that. Do you see any blurring of these lines, or do you think that we are still on a good course of having that separation of power?
Well, the separation of powers is a democratic principle. It's actually one of the founding principles in the Constitution, and it's designed to ensure that there are checks and balances between the three components of the state. And it's premised on dividing state power amongst those three components so that no one component dominates the other. That's really the reason for having the separation of powers doctrine. And the judiciary obviously plays a very, very important part in that. I think we must also realize that South Africa is an infant in the world or the global stage. It's really a democracy that's not matured. It's still in transition. And one would expect that in societies undergoing transition, that you would have dislocations, problems of the sort. It's a question of how you actually deal with it. But I'm fairly confident, looking from the outside, that each of the three components do stay within their lane, so to speak. So I have a great confidence in the system.
Thank you. Thank you very much, Chief Justice. Can I ask a second question?
Yes, please.
Thank you very much. My second question goes to the environment we find ourselves in now, wearing masks and in the middle of COVID-19. And obviously, during this period, I know that in government, we found many innovative ways of doing things differently, of actually changing the way that we operate as government, and in many ways found efficiencies. In your mind, what do you think is the future of hearings? Do you think hearings online will continue? Do you see an evolution and change in our system of courts and how that process is going to? Do you think there's going to be innovation coming in? And I ask that specifically because so many times we seem to find that I think cases pile up, and we see many years of many cases taking to come to fruition.
Yes. I think one of the more positive aspects of COVID-19 is just to bring to the fore how dependent we are on technology. Often we've spoken about the fourth industrial revolution. It's on us. And I think, as I said, a positive aspect is that we now engaging with having to do things differently. So in the court system, certainly where I practice, there have been innovations where cases are heard online, and it has made a tremendous difference. There's going to be a digitization, it's already rolled out in some of the divisions, the digitization of process and the like. So we cannot go back. So I see a bright future as well in the area of the technological transformation of the provision of judicial services.
Thank you, and thank you, Chief Justice.
Chief Justice.
Thank you very much, Honorable Premier. Advocate Kane,
Chief Justice, I beg your indulgence.
Oh, is there a follow-up?
Yeah, it's a follow-up on the first question.
Is it
Honorable Dodovu?
Okay, Honorable.
Yes, I didn't want
I think
to.
you must do everything there. Do everything, please.
Yes, I'll do so.
I want to scratch you here.
Yes,
Yeah.
I didn't want to inconvenience the Premier because he was delivering his maiden question, and my question is based on the first question that he asked about the separation of powers. As you know, this is an old theory developed over centuries by the French philosopher Montesquieu to balance government. What happens in an instance where any of the arms of government is weak? What are its implications to the whole system of government?
Thank you, Commissioner. It's really a subject which I've been particularly interested in. In fact, I started my PhD looking at this particular matter. Unfortunately, I haven't proceeded that very, very far. But I think the starting point is the Constitution, which we do have, and we've got to live with that Constitution. But one of the challenges I think we face is to reimagine the state. in the type of situation that we have, the economic situation we have, often the constitution, as I see it, is based on a conception and perhaps underpinnings of a democracy in an advanced capitalist society. We're not that type of society. There's a mixture of first, second, and third world components. So we have to reimagine the state. And if one reimagines the state, one has to reimagine how the courts would approach issues such as judicial review, for example, the issue of constitutionalism and its impact on our jurisprudence in approaching the state. So it's quite a wide topic, but I think it's a topic that one has to debate and give a great deal of thought to.
Lately, if the judiciary, or there seemed to be a perception that the judiciary sometimes encroaches on the other arm of government, and they say it's judicial overreach. In your own observation, do you see judicial overreach happening quite often?
I certainly, from my experience, I think judicial overreach, there may well be criticisms leveled against particular courts, but courts really and judges really just apply the law in many instances. And I just want to address the issue generally rather than looking at particular courts.
That's fine, yes.
Often there's a temptation in societies undergoing transition where there's a dominant party and a weak opposition, and I mean weak in terms of numbers, for the judiciary then to act almost like an informal opposition. One should in fact hesitate not to go that way, because as I think a philosopher Hart once said, hard decisions make for bad law. So while you might try to address a problem now, in a few years' time, the political parties might change, but you're still stuck with that hard law, and it'll be difficult then to move against it.
All right, thank you very much. Thank you, Chief Justice.
Thank you, Honorable Dodovu. Advocate KNSC.
Thank you, Chief Justice. Good morning, Mr. Francis.
Good morning, Commissioner.
We are permitted to ask 2 questions each. Mine are 2 totally different topics. But the first is to ask you, please, to give us an indication of how you intend to face the challenges, if you're appointed, of there being hostility inter alia between the judge president and the deputy judge president of the Western Cape Division of the High Court.
Well, you know, there are processes in place that I understand, and these processes are unfolding and will deal with the situation. But, you know, having acted in the division for the last 2 years, one often, if you weren't actively participating, you'll think the division's about to crumble. But that's not the case. There's almost a shrill hysteria about that division. The division operates like any other division. Cases are dealt with timelessly. I've never had a difficulty at all in fulfilling my judicial functions, and the courts are running effectively. Problems between the DJP and the JP, as I said, there are processes in place. They must unfold and take their times and take their course. But the courts are operating effectively and efficiently. And perhaps some of the detractors need to come and visit the courts and see for themselves what's going on. But yeah, the courts aren't about to crumble, certainly from my experience.
Thank you. Then, if I could move on to my second question, I'm asking you to postulate a situation where you are sitting in a case and you are yet to hand down your judgment, and then you are privately approached by another judge who's not sitting in the matter. That judge then gives you an indication of a preference she may have as to how it's determined. I would like to know how you would react to such conduct.
Well, judges take an oath to act independently, to dispense justice without fear or favor. And if someone approaches me, and of course it all depends on what the approach is. If it's an obvious approach to say, you will determine this matter in a particular way, then obviously that I'd be offended for one, and I would take the necessary steps to refer it to the Judicial Services Commission. So a lot depends on context, and we know context matters. So, and my experience is there is no difficulty with discussing cases with judges. As an acting judge for myself, I found great comfort in being able to approach fellow judges and to toss around ideas and to perhaps, to talk about matters. Talking about a matter and determining and deciding a decision, that's two totally different things. So, yeah, it will all depend on the context.
Chief Justice, may I just follow up, please, with one more question?
Please go ahead, Advocate Kane.
Thank you. I would like you to then confirm, Mr. Francis, that really the dividing line you're drawing between discussions and an attempt to influence is whether you perceive that there's any attempt to influence your independence, and that you would, in the latter case, in an attempt to influence your independent decision, you would hold firm.
Absolutely.
Yes, thank you very much.
I think that goes without saying. Any judicial officer exercising their functions must do so independently and without fear or favor. They should be impervious to external influence. That goes without saying for any judicial officer.
Thank you, Chief Justice.
Follow up, CJ.
Please go ahead, sir.
Given your relationship with JP, your long history with JP, if he comes to you and say you're going to decide this matter in this way, what will you do about it?
Absolutely, I would report the matter to JSC. I wouldn't have any hesitation on that if there's an attempt to improperly influence. But as I said, context matters.
Thank you.
Honorable Nyambi.
Thank you, CJ. Morning, Mr. Francis.
Morning.
When responding to CJ and in going through the questionnaire from the GCP, it's clear that you deliver your judgments timeously. Why is that important for a judge to deliver judgment timeously?
Well, justice delays is justice denied. I've been a practitioner for, as I said, 28 years now, and I know what agony it is to wait for a judgment, what impact judgments have to litigants, particularly in the public sector. They need to regulate and structure their future behavior depending on the judgment. So it has critical consequences for the litigants and more generally. So it's only absolutely necessary that justice is served timeously, judgments handed down timeously.
Thank you. My last question to you, given the response you gave to Commissioner Kane about the challenges in the division, if you can share with us the attributes, 2 attributes of a good judge, and share with us those that you think you'll possess that will come handy to assist you to make sure that that division is functioning effectively, efficient, and at optimal level.
Well, I think there are many attributes that a judge must display. If you only want 2, I think it's integrity would be right on top. And I think a healthy dose of common sense is also very important. Often we as individuals try to overanalyze and overthink things. We should just take a step back, take a deep breath, and see things for what they are. And often issues which seems highly complicated would seem less so if you just take a step back. So I think common sense is very important, is a very important judicial attribute.
Do you possess all of them?
Well, we're all human. I'd like to think I possess some of them, and I strive to possess all of them. Thanks.
Thank you, Mr. Francis. Thank you, CJ.
Thank you, Honorable Nyambi. Advocate Madonsela C.
Thank you, Chief Justice. Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
Mr. Francis, your qualifications straddle between politics and law.
That's correct.
And indeed, your practice as an attorney, and now in KZN, your firm is regularly seen in cases in that sphere of law, politics and law, like local government, provincial law, provincial and procurement law.
Yes.
Firstly, why did you not apply or make yourself available in KZN and you going to Cape Town? Are you hating KZN?
Yes, there are a number of reasons why. I've always wanted to relocate to Cape Town. It's been a desire of mine. I do have a practice which is based in Pietermaritzburg. It has a branch in Johannesburg, but it has a national footprint. My practice in particular, my personal practice, has taken me throughout the country, and I litigate often in the Eastern Cape, in Gauteng, and in this division as well, in the Western Cape. I'm also no stranger to the Western Cape. My first 2 degrees were obtained at the University of the Western Cape, and my 3rd degree was started at UCT. I have many friends and family in the Western Cape, and quite frankly, I like the Cape.
Yes, happily your firm has briefed me on occasions, but that's besides the point. The second aspect of my question relates to the jurisprudence that has been produced over the years in relation to this field, which I think you specialize in. We have seen a lot of judgments coming, particularly from the Western Cape, that sought to carve out a particular jurisprudence in relation to the appropriation of powers between national, provincial, and local government spheres. Do you think the jurisprudence that has been produced thus far, particularly from the Western Cape, that deals with functional areas of provinces versus local government, is sufficient to demarcate lines of operational space for the 2 spheres of government?
Yes. You know, the Constitution is a source document. The Schedules 4 and 5 set out expressly what the powers of the various levels of government are. And it's really a question of looking at those schedules, interpreting them in the light of the constitutional principles as well. I would imagine that in the hurly-burly of politics, there'll always be an attempt for legislative creep, so to speak. But judges should guard against that. The Constitution is fairly clear on the division of powers. So I think an activist judiciary is important to ensure that those principles and the law enshrined in the Constitution are in fact complied with.
This is a follow-up. Do you think that the contest on functional areas between the various spheres of government is an incident of politics or law?
It would have to be a combination of both. You know, particularly, I suppose South Africa is somewhat peculiar because you have the ANC dominating most of the provinces, with just the Western Cape being controlled by the DA. So there is going to be problems at a political level, but that's not unusual. In fact, it's healthy to have political competition. When it comes to the courts, however, the courts have a document in which to try to resolve those political disputes, and hopefully it will do so in relation to the Constitution and the law that has emerged in relation thereto. But competition, political competition, it's not unusual, it's healthy. It's how it's managed.
Chief Justice, I've exceeded my question time. Thank you. And thank you for allowing me.
Thank you, sir. Let me just do a quick follow-up, Mr. Francis. my interaction with colleagues at the German Judicial Academy opened up my eyes to something that we don't do in the South African Judicial Education Institute, and that is part of the induction they give to judges is on economics, communication, and politics. And I said to them, why are you giving an orientation to judicial officers in politics? They said, no, so that when they deal with political matters, they have a fair appreciation of the dynamics around politics and the implications of dealing with political matters in whatever way you're going to deal with them, the implications of dealing with economic matters in whichever way you are minded to deal with them. Now, as an expert in politics or political science, do you think that would benefit South African judicial officers, or would that orientation somehow be inappropriate for the South African judiciary at such a level?
I would actually support such an initiative. I think the more judges or all judicial officers, the more knowledge they have about the system and the structures within which they have to operate, they probably will dispense justice a lot more appropriately. Many lawyers, I would imagine, and many judges would have studied constitutional law at universities, which may have touched to some extent on political systems. But, and I can just speak for myself, having studied political science, I have a far better understanding of the structures of power, how power is articulated through state organizations. And it gives me a much better sense when I deal with matters such as local government or administrative law, or just societal problems in general. I think it would really be of assistance to judges, and it has nothing to do with judicial independence. No matter how much learning and how much teaching you have, at the end of the day, you sit with facts before you, and you've got to exercise your judgment in relation to those facts before you. But I think, as I always say, context is good, and the better you understand that context, the better the output is going to be.
So you believe it would help in, for instance, IEC-related contestations and challenges or disputes within a party or one political party against another? It would give a better perspective there.
I think absolutely, and it just doesn't have to, the education, with due respect, doesn't only have to deal with economics and with politics. It has to deal with also GBV violence. For instance, I would like personally to go through a course of diversity on femicide to try to understand we know theoretically South Africa is still a very patriarchal society where power relations are heavily skewed in favor of males. We need to know how these power relations in fact affect our decision making and how we actually confront it. So I think the more education judges and judicial officers have in a wide variety of aspects, the better judgments they will ultimately produce. And I would imagine also the better people they would be as well. It would sensitize them to various issues that confront us on a daily basis in the courts.
Thank you, sir. Honorable Mwima.
Thank you, Chief Justice. Good morning, Judge Francis.
Honorable Mwima, you're just too soft. It's difficult to hear you, sir. I think the mic might have been a bit far from you.
Am I audible enough, Chief Justice?
Yes, sir. Thank you so much.
Thank you, Chief Justice. Morning, Mr. Francis.
Morning, Commissioner.
I note that on your question under section 2, 2.2 and 2.3,
And 2.4 makes the case that indeed you are more familiar with the local government regime.
I would like to think so, yes.
From your understanding, do you think that there is enough separation of powers at local government between the executive arm and the legislative arm of a municipal council? And the second point, can you just give a brief outline in terms of what is the difference between a sphere and a tier? Is a local government a sphere of government, or is it a tier of government?
Yes, thank you.
Thank you.
Prior to 1994, local governments were in fact tiers of government. They had no independent powers of their own. They existed at the whim of provincial and national government. Post 1994, local governments are independent legislative spheres on its own. They operate exactly the same as a national or provincial government. They are independent and they have a great deal of power. That doesn't appear to seem to have seeped down through the local level. They do operate as independent legislative arms. They have particular duties and functions as development mini states, as it were. They've got a great deal of power. Sometimes it's not recognized, sometimes not understood, and sometimes they just don't exercise those powers, I think, given the structure of power at the national level. But yes, I mean, I'm fascinated with local government, actually. Most of my studies have been in local government, and it really does hold out the promise of if properly conceived, of actually improving the lives of individuals. I really think it can. Often the problem in South Africa is not so much that we don't have good legislation and policies. It's just the problem comes in the implementation. We have in fact, our constitution is probably one of the best in the world. Our system of procurement is probably one of the best in the world as well. The problem is implementation. That's where the problem is.
So you agree that these three spheres of government are distinct, are independent, but interdependent?
Absolutely. You know, I think it's section 41 of the Constitution provides for cooperative government, and that's the level where you cooperate. But apart from that, the three spheres of government operate independently. They have distinct functions, and local government plays a particularly important role in society as a whole.
Thank you, Mr. Francis. Thank you, Chief Justice.
Thank you very much, Honorable Muima. Professor Schlemmer.
Thank you, Chief Justice. Good morning, sir.
Morning, Commissioner.
Could you share with us your judicial philosophy? What is...
Prof, it's difficult to hear you. Please bring it closer.
I'll try my best. Is that better? Could you...
That's much better, Prof.
Okay. Could you share your judicial philosophy with us, please?
Thank you, Professor. Conventionally conceived, the philosophical approach to judicial decision-making has generally been categorized as conservative, moderate, or liberal. I don't particularly buy into those type of categories. If I had to define or categorize my approach to judicial decision-making, it would be judicial activism, where the Constitution and the promotion of the principles of the Constitution are central to the decision-making project.
And in your interpretation of legislation, how far will judicial activism then go?
Well, you know, there is the idea of constitutionalism. I think that might be. Constitutionalism is really a political philosophy which says that power must be constrained, and that the function of judges is to in fact ensure that that happens. I think judicial activism, when you're interpreting legislation, must always be done in the context of the Constitution. I mentioned, to me, the Constitution is both aspirational and inspirational, particularly aspirational. And when you interpret legislation, I think it's incumbent on judges to try to progressively realize those rights that are inherent in the Bill of Rights. So I think legislation and interpretation of legislation should have that as a basic premise, the progressive realization of rights.
Chief Justice, if I may have another follow-up?
Please go ahead, Prof.
And in connection with the common law and customary law, how far should judicial activism go there? In line, obviously, with the Constitution. But what I would like to know from you is, to what extent do you have to research the principles of common law and customary law before you can apply your judicial activism then?
Well, judges have an obligation to develop the common law and to develop customary law in line with constitutional principles. So, yes, one would have to actively do so.
Thank you, sir. Thank you, Chief Justice.
Chief Justice, may I have a follow-up on that?
Yes, Advocate Madonsela, go ahead, sir.
In relation to the questions posed by the professor, to what extent what is your take on the view that the power of the court to strike down a legislative instrument, like a legislation, and so to speak, to countermand legislative acts, will give rise to a counter-majoritarian dilemma?
Well, if a court's going to strike down a legislation, there must be good cause, and the reason for doing so would have to find its source in the Constitution. It wouldn't necessarily be anti-majoritarian. It would just be all power, all exercise of public power must have some source in law. And if that legislation is contrary to the Constitution, it must be struck down, and an appropriate remedy must then be fashioned. I don't think inherently that it's anti-majoritarian.
Well, given the fact that judges who are not elected and the legislature is an elected body, surely the voice of the representatives of the majority in the legislature are a majority, as opposed to the unelected courts. That's the argument that raises the counter-majoritarian dilemma sharply. What's your view on that?
Well, we have a constitutional democracy, and we all have to subscribe to it, whether we like the Constitution or not. That is our guiding document. And if the legislature does not comply with provisions in the Constitution, there's no reason, in my view, why a court should not say so. It actually goes down to the heart of the principle of legality.
Thank you, Chief Justice.
Thank you very much, SC. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
I have two questions. The first question is, over and above your acting stints in the High Court, what other adjudicative experience do you have that you believe is relevant for the role as a judge? And why do you think that experience will be relevant and help you in settling in to the role of a judge were you to be appointed?
Yes. I've acted at quasi-judicial bodies. I've presided over a number, but perhaps the most important is the Provincial Bid Appeals Tribunal. This is a tribunal which is established in KwaZulu-Natal, and it's quite a unique structure. It adjudicates all procurement-related or objections to procurement-related decisions in province. And it operates as a court without the formal trappings of a court. And I presided over that body for 8 years. In fact, I helped develop the practice and procedures in that court. And when I ran that tribunal, I made sure that it was accessible to the layperson. Often we had senior counsel appearing before us, but we also had laypersons appearing before us. We treated all the same. And the practices that I evolved and developed in that particular tribunal was such that it made the atmosphere or the system such that people could come and present their cases. And often we had laypersons coming to present their cases. I also made sure that judgments, or sorry, not judgment, but decisions were handed down within 5 working days. And very importantly, also, I insisted that decisions were no longer than 10 pages. It wasn't always possible, but that was it. So decisions handed down timelessly in an accessible manner without technical jargon and the like. I did it, and that practice developed because I was conscious of the fact that people need a voice. They need to object. It's one of the principles of fairness. However, one must also not forget that underlying every procurement decision is the need for service delivery. So I think you could actually match the twin objectives of fairness and service delivery in the way you, in fact, develop your procedures.
Thank you, Mr. Francis. Can I go to the second question? In the feedbacks we received from law bodies, there is a comments about your relationship with the JP, particularly in the dispute between the JP and the DJP, yes, and that you were appointed because you are a friend to the JP. I just wanted your comment on that so that when we do deliberate, we have your view on that matter. The advocates for transformation raised that, and they say you have you've managed to clear your name. But I just wanted to give you an opportunity to deal with that in this forum.
Thank you very much, Commissioner, and thank you for allowing me an opportunity to address this issue. Now, as a JP mentioned, I was a student of his in labor law. I think he lectured me in 1989 in labor law and a part of administrative law. I still remember his lecture on legitimate expectation. But after 88, 89, I hadn't had any contact with the JP until about, I think it was about 1997, 98, when he called me. And he called me within the context of asking me whether I would like to participate in the redraft of Lawrence Baxter's administrative law. Now, for all lawyers would know that that is in fact the key textbook, the seminal textbook on administrative law in South Africa. I had in fact been appointed by Juters and Lawrence Baxter to revise administrative law whilst I was an academic. But unfortunately, when I returned to practice, I had to reluctantly give up that assignment. So the JP phoned me and asked me whether I'd be willing to participate in the redraft of the section on constitutional law. But for the same reason that I had to give up the assignment, I had to reluctantly also decline being involved in that particular project. So that was about 8 to 10 years after being a student. The next time I saw the JP was in 2018, so probably 10 years later. So I hadn't seen him at all, had no contact with him, nothing. I saw him for the first time in 2018 at the High Court in the Western Cape. And I went to go and see him because I had a matter at court on that day, and I thought, let me go and pay my respects to him. I hadn't seen him for decades. And fortunately, he was available to see me. I knocked on his door. He opened the door. He didn't recognize me. Believe it or not, but when I was a student, I had a huge afro, and he also had an afro, and he couldn't recognize me. But after a few seconds, we exchanged pleasantries, and he asked me what I was doing. I told him. I also mentioned that I intended to relocate to the Western Cape at some stage, and he asked me whether I'd be willing to put my name forward. I didn't respond. I said I hadn't thought about it. About 6 weeks later, I contacted him and said, yes, I had thought about it. Perhaps I'd like to put my application to be considered. And that's how it actually started, me being appointed. So I had no contact with the JP for many, many years. He wasn't a friend of mine then. Since being appointed, he has become a friend of mine, and I value the friendship of the judge president. But allegations of nepotism and the like, absolutely, quite frankly, it's insulting. Nepotism assumes that you need a leg up, that you're appointed properly, that you cannot do it on your own merits. But with respect, I'd like to believe that my CV, my experience, well, they speak for themselves. Thank you.
Thank you, Mr. Francis. Thank you, CJ.
Including cum laude speaks for itself.
Thank you, Commissioner Tsepe.
CJ, can I follow up on Commissioner Steppen's first question?
Yes, please, Commissioner Matela Datu.
Thank you, CJ. And
CJ.
Is that you, Honorable Malem, or is that
No,
Commissioner Sigogo?
No, it's me. I wanted to tell him that he forgot to mention cum laude.
You forgot to mention?
Cum laude.
Thank you, CJ, and good morning, Mr. Francis. I just want to follow up on Commissioner Tsepe's first question regarding your experience in quasi-judicial adjudications. I just wanted to, in sitting in quasi-judicial tribunals, I want to tap on you regarding the issue of mediation. In your view, where do you think we should introduce mediation, taking into consideration that our matters take very long, and people, that's why communities are actually not understanding our system. Where do we introduce mediation? And secondly, in what matters do you think mediation can actually fast track the court processes?
Yes, I think all alternative dispute resolution mechanisms should be explored so that the courts can deal with, in inverted commas, proper matters. I think mediation is not suitable for matters that are highly conflictual and highly contested. But I would imagine in more family law related type matters, mediation might be more suitable, especially where the parties are going to have an ongoing relationship. You don't want them fighting in courts, which I think might in fact just exacerbate the problems. So to me, immediately that comes to mind is family law type matters. I think the amendment to Rule 37A might expedite matters. But yes, mediation, I think, is an important part of the arsenal which judges ought to have, and of course get training in mediation as well, because that is a specialist skill that one has to acquire.
Thank you, CJ, and thank you, Mr.
Thank you very much, Commissioner. Honorable Mogwanishe.
Thank you very much, CJ. Good morning, Mr. Francis.
Morning, Commissioner.
My question is based on your qualification in environmental law. In an era of rapid industrialization, do you think the polluter pay principle is effective at all? Given the fact that polluters, some of them have got deep pockets, what do you think must be done to find the balance?
Yes. Commissioner, thank you. I think environmental and the degradation of the environment, particularly climate change, is one of the greatest existential crises which we face, not only in South Africa, not only as individuals, but globally. So we need to, in fact, give or arm the enforcement authorities to make them better prepared to meet the challenges. The polluter pays principle is a principle it's contained in NEMA, for example, and it's a widely held principle The problem with environmental law cases is one of proof often, because the damage is so dispersed and there may be so many causes of damage. So one of the biggest problems is actually to determine what was the effective cause of the damage. So maybe one has to look at legislation for strict liability, maybe make strict liability a principle. Obviously, there's constitutional issues with it, but I think the legislation needs to perhaps be tightened up because of the existential crisis that we all face.
Thank you, CJ. Thank you, Mr. Francis.
Thank you, Honorable Maganish. Honorable Minister.
CJ, I'm covered. I wanted to ask the question in relation to the complaints by the law bodies. Thank you.
Thank you, sir. Honorable Breitenbach.
Thank you, Chief Justice. Good morning, Mr. Francis.
Morning, Commissioner.
In South Africa, our constitution is paramount. It binds this body, amongst others, to uphold and protect the constitution, and it's clearly set out in section 165 of the constitution. When a judge president of a division operates under the serious cloud of being found guilty of gross misconduct linked to underlying dishonesty, how, in your view, does this serve this injunction? And is it, in your view, desirable?
Sorry, I couldn't quite get the last part of your question, Commissioner.
Said, how, in your view, does this situation serve this injunction to protect and uphold the Constitution? And is it, in your view, desirable?
Well, I'm not sure whether it's my place to address issues
Chief
which
Justice, Chief Justice, it seems to me, with respect, that's a question that falls for this commission to decide in its deliberations, not one that can be answered by a candidate. With respect,
I think the candidate was handling it very well, Advocate Madonsela. He was in the process of answering.
Oh, yes.
Yes. Please go ahead, sir.
Thank you, Chief Justice. Yeah, I really don't think it's my place to comment on the situation as it presently exists, and I would respectfully decline to do so.
May I follow up, Mr. Chief Justice?
Absolutely, Honorable Breitenbach.
Thank you. I'm not asking you to decide the matter, Mr. Francis. I'm asking for your view. You have impressive qualifications and experience in constitutional law. Is this type of situation desirable, and does it serve this injunction? It's not a difficult question. I'm not asking you to decide anything.
Chief Justice, the candidate has declined to answer that question. He has declined.
Let's leave it. Yes, Honorable Malema, I think let's leave it to the candidate. I'm just trying to avoid a situation where colleagues would be stepping in either on a point of order or one point or another. I think the candidate is well able to handle the situation.
Yes, I've made myself clear. I don't think I'd really want to comment on the specifics because there are bodies dealing with this matter. But if I could perhaps just make a general comment, I think every citizen, including judges, they can avail themselves of the rights in the Constitution. One of those rights is to be treated with dignity, regardless of what you may think about them and how you might try to characterize their conduct. But dignity is an essential foundational principle in our Constitution. And I would just hope that those principles are observed as well. Thank you.
Thank you, Chief Justice. My second question, Francis, is I'm pleased you spoke about dignity. It's very important. I agree that everybody be treated with dignity. So I would then ask you, given your general comment, in general, does this type of situation impart dignity to the other members of the Western Cape Division of the High Court?
What situation you refer to with respect, Commissioner?
The situation where the Judge President of the Division has been found guilty by the Judicial conduct tribunal of gross misconduct, does this impart dignity, the dignity you speak of, to the other members of that division?
Commissioner, the fact that charges may be leveled justly or justly against a particular individual doesn't affect any other judge. They continue to execute their tasks faithfully and diligently. I think they also believe in the rules of natural justice, that people must be given a fair opportunity to say their say and to have their say. And they also believe in the principles of the Constitution, which allows people to, to a fair trial and everything that in fact implies. They must be given an opportunity to defend themselves in an appropriate forum. So that's a separate issue to how judges at the Western Cape, and I can't speak on behalf of all of them, but certainly I can speak on behalf of myself, that how I conduct myself, the fact that the judge president might be facing charges of misconduct has absolutely no effect on me and how I perform and execute my functions. And I would imagine it doesn't affect any other judge as well. Process must be followed. Respect must be given to the rights of individual to challenge if they so desire. And that's a constitutional right that we all enjoy. We can't apply the Constitution selectively.
Thank you.
Thank you, Honorable Breitenbach. Honorable Singh.
Thank you very much, Chief Justice. Good morning to you and to the Premier, JP, and all commissioners, admin staff, and Mr. Francis. Mr. Francis, I note that in your questionnaire under address, you give a particular address, which I shall not repeat, but it's an address in Cape Town. Now, I've come across some mutterings that perhaps that particular unit, the state is covering the tab for that accommodation. Can you tell us whether there's any truth in those allegations, and when did you either acquire for lease or ownership that particular apartment? Thank you.
Thank you, Commissioner. And thank you for actually raising this issue, because it's often raised in the context that my acting appointment has been at great expense to the state or astronomical expense to the state. I can assure this commission that I have not claimed and do not intend claiming any single cent for accommodation. I've actually footed the bill out of my own pocket. I have not claimed any accommodation expense throughout my 2 years acting on the bench. As far as traveling is concerned, as you may well know, certainly in terms of the Act and the regulations governing the benefits of acting judges, I'm entitled to use a pool car or to claim a traveling allowance during my tenure as a judge. I've only used a pool vehicle for the first term, and that was only because I did not have my own vehicle in Maritzburg. But as soon as it became apparent that my tenure would be extended, I used my own car. I, in fact, prefer using my own car. And I've never claimed a single cent in travel allowance. As far as flights is concerned, and I've calculated the number of flights that an acting judge would be entitled to, who acted for 2 years, and I don't want to go into the calculation, but believe you me, it amounts to roughly 54 flights over a 2-year period. I have in fact flown 3 times. So by any stretch of the imagination, that cannot be considered to be at great expense to the state, and certainly not astronomical expense. So allegations to that effect are quite plainly false. And the department that I am living in, I've rented it for probably the last 9 months at my own expense.
No, thank you for clearing that, Mr. Francis, publicly clearing that. My second question relates to your directorships that you hold. And I see that you have indicated that you've resigned from most of them. You will resign from the other 2 except for your family trust, which is understandable. I'd just like to know what activities were these two entities involved in? Fukaka and the Gulhle and Real Associates.
The first company, I was approached by a black entrepreneur. In fact, he was a material scientist who wanted some legal advice. He had a very innovative product. He produced pallets that were biodegradable and environmentally friendly. As you know, pallets are generally made of wood or plastic. Both are no-nos right now. And he asked me whether I'd be interested in not only providing advice, but also startup capital. It was a fantastic project, a good business venture, and of course, it was helping a black entrepreneur. And I did get involved in that. That company, due to COVID, has unfortunately fallen by the wayside, and I don't have any active involvement in it. And if appointed, I will obviously resign. The other company is Real Associates, is a property development company that I was involved in as took part as a property developer. And it's still an active company, but it's a company that I have no difficulty in withdrawing as it's about to, in fact, complete its usefulness. The project that it was involved in is about to come to an end.
All right. And lastly, just as a follow-up, I'm still not too clear on your membership of the ANC. In your questionnaire, you say 1992 to now branch member, but you're not in good standing and you will resign. Now, if you're not a member, there's no need to resign. So, but anyway, we'll leave that one at that. I think you gave us an explanation, unless you want to expand a bit further on that.
No, I think I've given an explanation. Thanks.
Thank you, Chief Justice.
Thank you, Honorable Singh. Honorable President.
Thank you, Chief Justice. Good morning, Mr. Francis.
Good morning, President.
As you would know, the JSC has since its inception been concerned with the transformation of the judiciary so that it conforms with Section 1742 of the Constitution. Now, within that context, would you please tell me what you understand gender equality and gender transformation to mean?
I think
gender equality and gender transformation. What do those concepts mean for you? Well, not for you in terms of the Constitution.
I think in terms of, I think it's 170. I think it's imperative on the JSC when making a decision on a candidate to consider gender representativity and race when making this decision. And I personally am all for transformation and have, through my practice and through my life, have firmly tried to advance the cause of transformation. I think transformation, as far as gender is concerned, it's not only a numbers game, it's an attitude. It's trying to understand the, as I indicated earlier, structures of power and how they actually manifest themselves in society. So it's actually changes of attitude as well. From my own perspective, I am fully conscious of the patriarchal nature of society, of the fact or of the effects of these power relations on women in practice. And certainly the way I handle my courtroom is to ensure that the constitutional values of dignity and respect for people pervades the courtroom. Whether it's senior counsel and how they interact with junior counsel, how males interact with females, how the litigants or counsel interact with court staff, all those factors are taken into account when I manage that courtroom. So transformation only does, it's, as I said, it's not just a numbers game, it's transformation of the mind as well. I think many of us seem to forget just what a devastating impact apartheid has had on our psyche, both as oppressed and oppressors, and we're still trying to overcome those type of divisions right now. 1994 just didn't do away with some of the past that we had.
What are your thoughts, if any, on the fact that out of the 23 members of the JSC, only 8 are women? Now, I've heard you, and I agree with you to some extent that transformation is not just about numbers. Do you believe that a body that is itself insufficiently populated by women can effectively implement gender transformation, or does that not matter since it's not a numbers game?
I think strides have been made, strides will be made. I always believe that one has to take a fairly long-term view of society. I also believe that the Constitution is aspirational. There's lots of things in that Constitution which we still have to strive to achieve. Equality is one. You know, we may have formal equality, procedural equality, but substantive equality is still lacking. But I think we're still a young society. Great strides have been made in many areas, also just like gender equality. And I have no doubt that with commitment and fortitude, that many of these issues can be resolved in time. All we need is time and commitment.
Well, in the interest of time, I'll leave it here, CJ. Thank you very much. Thank you, Mr. Francis.
Thank you, President. Thank you, Mr. Francis. Your excuse.
Thank you, Chief Justice. Thank you, Commissioners.
Colleagues, before I proceed with the candidate, let me just mention something in passing that we can thrash out when we are alone regarding the question that was put by Honorable Breitenbach to the previous candidate and why I allowed it. We may disagree, but we can thrash it out later. Let it be ever abiding in our minds that we are testing candidates for, among other things, the ability to judge. They therefore have to be able to tell whether, or to judge, whether this is a question to respond to, and if so, how best to respond to it. That's part of the test. They have to be able to protect the rights of others. Now, if they don't even know how to protect their own rights, it will be a challenge for them to convince anybody that they would be able to protect the rights of others. So there is that thin line. As I said, we can talk about it later, but that was the motivation behind, I beg your pardon, my approach. I apologize that I saw no other opportunity to mention it, but now, but let's proceed. Good morning, Advocate Heck.
Good morning, Chief Justice. Good morning, Minister. Good morning.
How are you, sir?
Very well, thank you. Yourself?
I'm very well, thank you. I think you need to be helped to settle down a bit, am I right?
I apologize. I didn't hear you.
I was saying, I think that you need to be assisted to settle down comfortably a bit, or are you ready for anything from the beginning?
I will gratefully take any assistance to settle down. Thank you.
Okay, all right. You have been an advocate for about 27 years, am I right?
Yes, well, 25 years. To get there, and it has been there for the fulfillment of a dream.
You know, one of the reasons why I was protesting when people wanted me to become a judge was that I wanted to be senior counsel first. You know, I wanted that SC behind my name. Why do you not seem to have had a desire for that status, as it is referred to?
I fully respect that. I fully respect both your reasons and everyone else who has taken silk. I was in the commercial world for 15 years. I have a paid up home. I have a paid up car. I have felt that part of the legacy that I can have and provide is access to justice, and it has been a concern to mine that if I do take silk, I will remove myself out of the briefs that I've been able to take, because I will be perceived to be out of a fee bracket, and I prefer not. And that is the very simple answer. I respect the role of silk. I believe it has a valid role to play in the profession.
Well, that makes me feel better because I never rose to that level. I didn't stay long enough to rise to that level. You've acted as a judge, have you not?
I must apologize again. I didn't hear you.
You have acted as a judge.
Yes, I believe, again, I hope my maths isn't wrong, that I've done 9 terms.
And did you enjoy it?
Yes, I have.
What is the longest it has taken you to produce a reserved judgment?
To the best of my recollection, it was approximately 8 months.
And before questions are put to you, would you like to explain how it came about?
It was a particularly difficult matter. It was a matter that I felt I wanted to make my own views heard, but at the same token, I had to take account of the fact of remaining judicious. And so I did have a number of drafts, and I put them aside for a week or so. And it really was quite simply my process. And yes, I accept it was too long. And I do know that the record has shown, I believe, that I have increased the pace of delivery of my judgments, and I currently only have 1 outstanding.
As leaders or head, sorry, sir, carry on.
When I say outstanding, it's it was reserved on the 19th of March.
Yes. As leaders or heads of court, we have decided or reminded each other that it was necessary for each head of court to keep a record of reserved judgments, part-head matters, so that it never happens that a judgment is reserved and the head of court is unaware of it. I take it that you were reminded by the head of court, or you informed the head of court that you had that reserved judgment. It was not without his knowledge.
Yes, I did advise the head of court.
Yes. And I take it that you are ready, otherwise you wouldn't be here for the High Court. You're ready for the High Court.
I feel that my record has shown, my judgment specifically shows that I do believe I am ready, yes.
Thank you. Colleagues, let me have the names of those who have questions for Advocate Hack.
Sorry, Klaba.
Lamola. Nyambi.
Schlemmer.
Tepe.
Singh.
Reichenbach, please, Chief Justice.
Jenny Kane.
JP, over to you, my brother.
Thank you very much, Chief Justice and fellow commissioners. At this point in time, I would like to disclose that I have known Advocate Brian Heck for a very long time. I first met him, I think it was in 1995 or 1996, when he appeared before me. He came to chambers, as is customary, to introduce himself with his fellow opponent. Fast forward, I think about 12 years ago, I wrote to the Cape Bar asking the bar to forward the names of possible candidates to come to act on the bench. His name was included on that list. At that time, I did not invite him because I had enough advocates to come and act, but that was about 12 years ago. Fast forward, 8 years ago, I met my wife, who is a judge in the division, Judge Sally Hlophe. I subsequently discovered that she had been briefing Advocate Brian Heck for years, and they knew each other. 6 years later, it is a fact, I married my wife, and Advocate Heck was present at the wedding. He was invited. By the way, he's not the only one who was present at the wedding. There were other people present at the wedding. So after that, through my wife, he became a family friend. I have no questions for this candidate at this point in time. Thank you very much, Chief Justice. But I thought I should...
Thank you, Honorable JP. Thank you, sir. Honorable Premier.
Thank you very much, Chief Justice, and good morning, Advocate Hack.
Good morning, Premier.
Can I think in the process of fairness, I'm going to ask you, first of all, the same question that I've asked previous candidates, and that is, we have a system in South Africa, which I'm very proud of, our constitution, and then, of course, we have the executive, the legislative, and the judicial. And my question to you is, do you think that the lines of separation of power are still holding? Or do you think that there is, and it wasn't my words in the first question that I asked, but it came up in subsequent follow-ups, which I thought was nicely put by one of my colleagues here, one of the commissioners, about judicial overreach. Do you think, what do you think about that separation of powers in our system at the moment, and do you think it is holding firm?
The simple answer is, I do believe it is. I have presided over various matters that have concerned institutions that are wholly owned by the state, institutions that are under the control of the executive, and I have certainly approached those matters with due deference to the need to maintain the separation of powers between the two, and I believe it is being sustained.
Thank you, Chief Justice. If I may follow up.
Please go ahead, Premier.
So perhaps just to follow up on that question and your reflection on a body like this, do you think that the balance is right with political seats as well as other seats represented on a body like the JSE?
I accept that it's very difficult to ensure universally in any country in the world that the judiciary is independently appointed. In my view, the system has worked for many years. I am obviously aware that there are detractors, but in my view, it is necessary to ensure that both judicial and political office bearers are part of the process. And at the end of the day, it would be for the legislature to make any changes. I wouldn't want to, and I don't have any criticism at this point in time of the institution.
Thank you, Advocate Hack. Chief Justice, if I can ask one more question.
Go ahead, Premier.
Thank you, Chief Justice. Advocate Hack, my question here really goes to give you an opportunity to talk about something that is in the public domain mentioned, and that is specifically around an issue where you yourself appeared on behalf of Judge Hlophe's wife, and the question of your being appointed as an acting judge at the same time, and whether there was a contravention of 14.3b of the Judicial Code of Conduct. We have deliberated it, but I also would like to hear from you, what your feeling is, and of course your side, or what you'd like to put on the table here for us.
Yes, certainly, and thank you for that opportunity. I have written a letter to the Legal Practices Council as a response to the referral or the report of the incident to them, and I've set out in detail my response there, but not to take up too much time, just in brief summary. I, as the Judge President has said, have been a friend of Hayat Salih Hlophe, the judge, and the attorney before she became a judge for many years. I've been a closely related friend, without wanting to be in any way sentimental. I was at her home when her youngest daughter was 2 weeks old and held her in my arms. Mrs. Samuels, as she then was, when she briefed me, was a very strong attorney. She represented women in particular who were on the fringes of society, or alternatively had suffered domestic violence or had been abused. And she was strong in that regard. And I have her blessing to say this, that in the course of our relationship and working together, she revealed to me that she herself was in an abusive relationship. And I believe, in fact, I'm certain, she will verify that I gave her the independent source of strength to stand up to the situation and to move out of the situation. Unfortunately, there has been ongoing problems in that relationship, problems in regard to maintenance of her children. And I was actively involved throughout that process, particularly in litigation, in maintenance court, in magistrates court, and in the High Court, to ensure the maintenance of her children. I've set it out in detail in my response. There was an order made in December last year. I participated in it. I was not acting at the time, and I represented her. An order was made that would give her ex-spouse an opportunity to remedy what was a breach of a court order. He did not, and the matter was then set down, and was set down on a very urgent basis, because the children were returning to school. School fees had not been paid. They faced the risk of being prevented from going to school. And I was asked, because I was so familiar with the history, whether I could possibly attend the matter. Judge President was approached. He informed me quite categorically and quite clearly that I could have the leave of the day. This is obviously while I was acting. I could have the leave of the day that he had written to the minister, and his words were everything was in order. I do understand it's possible that there was a delay in the letters reaching and or coming back, but I relied on his representation. I firmly believe that I was entitled to do so, and I therefore have made the submission that I've done no wrong and that I've not breached any of the regulations. As it turned out, I didn't physically have to appear, but yes, it is true. I was in chambers to remotely be available to deal with the matter if a hearing was required. It was ultimately not required, and an order, as we were seeking, was made. And I am very comfortable that I did not breach any ethical rules or any other rules of any description.
Thank you very much, Advocate Hack, and thank you, Chief Justice.
Follow up, Chief Justice.
Thank you, Premier. Is there I thought I heard a voice, was a colleague asking to follow up?
Madonsela.
Yes, Advocate Madonsela, see.
Mr. Hack, good morning.
Morning, Commissioner.
Don't you think your relationship or your relationship with the JP's wife, and the extent to which, and your familiarity with that family, the extent to which you have gone out of your way to make yourself available to assist them in their affairs so much that it had to give rise to a complaint of you taking time out of your acting position to assist them, is such a clumsy affair that it should dissuade us from appointing you as a judge permanently?
The simple, honest answer is no. I believe it was my duty to appear on that day for those two children whose lives were in peril. It was not something that I did lightly. It was not something that was frivolous with respect. It was something that was very important. The Judge President was approached for his leave. I was aware that he required the minister's permission or consent, sorry. He assured me that he had the minister's consent. Obviously, there is no doubt, or let me reassure you, that should I be given or should I be honored with a permanent appointment, I will be extremely mindful of the divisions between the advocacy and between the bench, and I certainly will not be in any way persuaded to lend any further assistance as a counsel or as an advocate to specifically the Judge President's wife or himself or anybody for that matter. I certainly will honor the fact that I will be bound then to render and exclusively render judicial services.
Is it not unsightly that we as a Judicial Service Commission should appoint a person who is a close family member of a family who are holding judicial positions in one division and add into that family affair?
My response again is a simple no. My knowledge of the appointment of acting judges is that more often than not, those individuals are introduced by a serving member of the judiciary as an individual that might very well be suitable to act as a judge. I don't see any reason why the same principles can't apply and do not apply to a permanent appointment. My association with the specific family does not mean that I can in any way be compromised to be an independent judge doing my independent duties properly and fully without fear of favor. I can't give a better answer than that.
Thank you, Chief Justice.
Follow up.
Thank you, sir. Which colleague wants to follow up?
Julius. And Lamola.
Okay. And maybe before you follow up, sure of his answer. Advocate Head, did you say that the JP assured you that he had the minister's consent, or did I not hear you correctly?
His exact words were, "Everything is in order." I do not recall him specifically saying he had the minister's consent.
Yes, I was asking because that's what you said. I wanted to be sure that you meant to say those words, or could it be an error? I even wrote them down.
Thank you very
So
much.
I just wanted to, okay.
Thank you for giving me that opportunity. Then I did misspeak. The exact words were, and I remember them very vividly, "Everything is in order. You can go ahead, apply your mind to appearing tomorrow."
Okay. Honorable Malema.
Thank you, CJ. Did you say JP's wife is a judge in the Western Cape?
Yes, that is correct.
When she got appointed, was the JP of the Western Cape?
Yes, he was.
Are you in any way, apart from the relationship you've described, have any relationship with the JP? Like, are you married in his family, or are you brother-in-law, or anything of that sort?
No other relationship whatsoever.
Except that you are friends with the wife who was appointed by this body when the husband was the JP in the Western Cape.
That is quite correct.
Thank you.
Honorable Minister, I propose that you put even questions you were going to put later so that I take you out of the list.
Oh, okay, thank you. Thank you, CJ. Mine is just a follow-up on this, that everything is in order. Did you inquire with regards to the papers of allowing you to, of revocation, or you just took the JP's word?
I accepted his word. I do believe I said in my representations to the Legal Practices Council that, first of all, it didn't occur to me to question it. And secondly, I do believe it would have been pertinent of me to demand that he must give me a copy of the letter from your good officers confirming that I could go.
Okay. My second question relates to a different matter, aspect. I see you are 65 years of age, and it's almost advanced age, almost towards retirement. Do you think it will be prudent of this body to appoint you at that age? I'm not saying that should be a principle. We do appoint those of your age sometimes, but I'm just asking, do you think it's fair that we do it with regards to you, given the privileges you had as a white male in this country?
Yes, thank you, Honourable Minister. Just again to go back to maths, I'm 64 and 6 months, but yes, I shall be 65 this year. You mention my white privilege, and I must take that up and say immediately, I fully accept and I fully concede that I've had the benefit my entire life of being privileged. There is no doubt about that. I equally believe that it's imperative that the bench change and become more representative and reflective of the demographics of our society. And I fully endorse the fact that there remains an representation of certain individuals by gender and by race, in other words, specifically Black women on the bench. However, the bench must also be reflective of other minorities, and more specifically, minorities that are unrepresented in general, and more pertinently, not visible. And that is the LGBTQ plus community, of which I am a member. Now, I accept that my period to serve will be relatively short, but I have come forward as a member of that community. I don't know whether other candidates have come forward on the same basis, and I trust, if not now, then certainly in the future, they will. But I believe that I can play the role of being visible and of encouraging other members of the LGBT plus community to come forward. But just on a general note, that's not the defining reason for why I should be considered. I have a work ethic. My record shows that I am productive. I work hard. I'm blessed with good health. I was very blessed to wish my uncle for his birthday 2 weeks ago when he turned 102. So I'm hopeful that I'm equally blessed with good long genes. And so, yes, I understand what you're saying, but I do believe that even if it is for a limited period of time, I can be a role model. I'm not denying that there haven't been prior role models. I can speak only very specifically for the Western Cape. Judge Gerald Jossman actively was visible as a representative of the LGBT community. He very sadly passed away in a motor vehicle accident many years ago. To the best of my knowledge, and I'm fairly certain that there is no open representative of the community currently on the bench. And for that reason, I would make the submission that I am a suitable person, despite the fact that I am a white male, which I readily concede I have been privileged.
Yeah, thank you, Mr. Heck. I also wish you longevity.
That is very kind of you. Thank you.
Yes, thank you. Thank you, CJ.
Can I make a follow-up, CJ, through your indulgence? Can I
Please go ahead, sir.
Thank you, CJ. Just on the last point that Advocate Heck made with regard to being a role model, I came across the Lange versus Mass matter that was resolved in 1998. And when you are a student, there are certain materials that you come through, and when you are in front of somebody that you think probably played that role model, I think it will be fair for me to ask that question. Just with regard to that matter of the Lange, because it is also noted as part of your contribution to jurisprudence. In that matter, I see there was also an emphasis on the values of the Constitution as provided in Section 1 of the Constitution. And I came across a point where it is said that the De Lange, in the De Lange, it can be seen as, because it was decided in 1998, it dealt with it was a test case in terms of the independence of the judiciary as encapsulated in Section 165 and the role that it can play in terms of giving meaning to those rights that were enshrined in the Constitution. So I would be more interested just to get a sense from you, your appreciation, because it is regarded as a pioneer of the role that the court is played in terms of shaping our jurisprudence. And I just want to quote what the court said in that one. It said, "Our courts will develop a distinctively South African model of separation of powers, one that fits the particular system of government provided for in the Constitution, and that reflects a delicate balancing informed both by the South Africa's history and its new dispensation between the need, on the one hand, to control government by separating powers and enforcing checks and balance, and on the other hand, to avoid diffusing power so completely that the government is unable to take timely measures in the public interest." Can you just share your reflection on that, particularly the role that the court has played in promoting values as enshrined in Section 1 of the Constitution, which captures accountability, transparency, rationality, and the rule of law? Thank you, Chief Justice.
Yes, thank you, Commissioner. As a lawyer, I am inclined to apply myself to a specific set of facts. And even as a judge, I have, or as an acting judge at least, one speaks and addresses a specific set of facts. So I am restrained from making extensive, broad and general statements outside from a general set of facts. Same to say that I do agree entirely that, first of all, the Constitution is the highest source of law in this country. Secondly, that both the legislature and the judiciary are bound to honor what is contained in the Constitution. And thirdly, that there should and must be sustained a clear division of power between the legislature and the judiciary. And however, that both should strive to achieve, as you quoted, the furtherance of our own unique South African democracy, which I hold dear, which I do believe is a model for the rest of the world, to be held up and to be respected. And I'm not sure if I'm answering the question directly or adequately, but those just are in brief the sentiments that I would share. As I say, I'm reluctant to start talking about broad policy issues because I don't think, as a candidate here today, that is my role here today.
No, thank you, Advocate Tech. Thank you, Chief Justice. You have indeed addressed my question because of the pioneering role that you played in that Dilanga matter. Thank you.
Yes, thank you.
Thank you, sir. Honorable Baba.
Thank you very much, CJ. Good morning, Advocate Tech.
Good morning, Honorable Commissioner.
Thank you very much. There is an allegation that you did not disclose your membership of the Conservative Student Alliance. Can I get your view on that?
Yes. The Conservative Students Alliance was a club or a society at the University of Cape Town in 1976 to 1979. If I had presumed to say that I was a member of a political organization in the name Conservative Students Alliance, I think I would have elicited a considerable greater degree of criticism, because it was no organization at all. At its best, at its heyday, it might have had 15 or 18 members. I'm happy to address what happened 45 years ago if I need to, but it was nothing more than a banner under which I campaigned for a position on the Student Representative Council for 2 years. I was the sole person that was elected. I hesitate to say this, but I feel I have to be myself. If it was anything, it might have been a grouping of people that met for beers on a regular basis. It certainly was not an intellectual. It certainly was not a political. It certainly was not any organization that can in any way be described as having contributed in any way to any political thinking.
So you want to make us believe that this club was not affiliated in any way or promoted any views of any political party at the time?
That is absolutely correct. I don't want to delay proceedings, and again, I can give a long, protracted explanation of my role at the University of Cape Town at that period of time. So very briefly, in 1976, the apartheid regime released physical violence into the townships in the form of the police and the military. On the 16th of June, 1976, there was a massacre in Soweto. We all know that day because we remember it every day. On the University of Cape Town, they were running battles between the police and a small number of students who were actively involved, who committed themselves to close the university down. There were burning tires on the highway, and there were police with live ammunition on campus. I will try to be brief. As a schoolboy, I was bullied. I had experienced physical violence. I abhor violence. I was extremely concerned that we were heading into an escalation of violence. There were two schools of thought at the time. One was liberation before education. The other one was education for liberation. I followed the latter view. I decided to stand for the SRC, to promote that view. The student body, the white privileged student body, as it was in 1976, was highly apathetic, was not politically involved or politically motivated, except for a very small group of people. To get attention, I needed to be controversial. I needed to get attention, and I chose the word conservative student allowance rather than moderate student allowance or whatever the case may be. It was not representative of any political party. It was not representative of any political philosophy. It was simply to say, please, let's apply our minds, let's apply our thoughts, let's apply our words to achieve liberation. And let's try as far as possible to avoid violence. I acknowledge and I respect that those who took up arms played a vital role to having achieved ultimately liberation. But to also say that in 1976, the system was cracking. There was already significant political pressure. There was the boycotts. There was already the hope, the bit of light at the end of the tunnel that possibly a negotiated settlement could be achieved, which was ultimately achieved. That was my position. That's why I was a party to what was at that stage student politics.
Thank you, CJ. Thank you, Advocate.
Thank you, sir. Commissioner Matolo Dlepu.
Okay, thank you, CJ. Good morning, Advocate Hack.
Good morning, Commissioner.
Okay, you are well aware that transformation of the legal profession is still far behind other sectors, and the Western Cape being still the West is still not transformed, according to the study that we did. But what I wanted you to share with us is, as an advocate, what initiatives did you have, or what role did you play in trying to empower Black females or white females in the advocacy? Or, I mean, just share with us what initiatives do you take to do that?
Yes, thank you. First of all, the person who nominated me, Mr. Apollos, was an attorney who briefed me over many years, and he asked to do pupillage with me when he decided to come to the bar. I had another pupil who was a black male who worked with me. My door was always open, and I practically did assist on a regular basis to mentor and to guide fellow advocates, young, inexperienced advocates at that particular time. I also, as is borne out in the 3 letters of support, which I trust have been placed before the commissioners, I have done whatever I could to provide access to justice. I was pertinently aware of the cost of litigation when I started my career because I had a significant debt. And when I say my career, my first career in the commercial world. And I provided access to justice, particularly to the marginalized members of society. And you would have seen that I particularly and pertinently assisted with the advancement of women through rugby at the University of the Western Cape, to provide and assist with setting up structures, bursaries, and legal advice for them. And I, again, as a member of the disadvantaged community and oppressed community, and a community that remains on the fringes despite the Constitution. The Constitution provides, it guarantees that there can't be discrimination on the grounds of sexual orientation. But LGBTILQ is a vast spectrum of people, and they remain unidentified. And I made myself available to assist anybody who particularly came from that community, and particularly women. You would have seen the letter from the attorney, Ms. Schult, that I, over a considerable number of years, assisted particularly her firm, who consist only of women, and also her clients in the furtherance of their rights and promoting their interests and ensuring their equality in terms of the Constitution. And again, I'm sorry to use a colloquial term, but what you see is what you get. I'm trying as best as I can be. I'm not fabricating. The series of judgments and letters show this is not some recent aberration. This is something I've done from the day that I entered to the profession.
Okay, thank you. A follow-up question. I appreciate what you have done in your personal capacity, but what do you think can be done more to fast track this transformation from your point of view, especially in the Western Cape?
Yes. Thank you again. I'm not a social influencer. I can't, it is not within my nature to turn to Instagram and make statements and try to educate. I have difficulty with that. It's against my it's not against my nature. I don't have the ability to do it. I'm not an activist in that sense. I have played my role, and I will play my role as a jurist. That's my strong point, my ability to think, my ability to argue, and my ability, I trust and I hope, to persuade, and then ultimately, if I'm honored to be afforded a position as a judge, to deliver judgments that are appropriate. But how do we change? How do we solve the problem? I'm aware, and I'm fairly sure that all members of this Honourable Commission will be aware that there was a protest demonstration outside the Constitutional Court 2 days ago by an amalgamation of LGBT communities and organizations demonstrating and addressing the fact that there had been a series of violent crimes against the LGBT community, at least 8 in the last 2 months, where people were killed. Hate crimes as a result of the fact that they did not fit into a heteronormative image. I don't want to be perceived to be lecturing. I know everybody knows and understands what I'm talking about, but it's just to emphasize that teenager at school, that boy at school who is dating a girl who is completely comfortable with his own sexuality, but nevertheless is effeminate, does not fit into society's norms of how you should behave. It's that person that also needs to be made visible. And so I can only but say, particularly in the Western Cape, where I absolutely agree with you, there is a single need of further transformation, particularly for the enhancement of black women and the presence of black women on the bench. It's essential. At the same time, there is a need for a presence of people who are in the LGBT community. It is unfortunate that I am a white man that has come forward, as I said earlier. But that is something that society needs. They're visible in art. They're visible in the theater. They are not visible in the professions. They are not visible in the government. They are not visible in the judiciary, and they should be. I hope that answers your question.
Thank you, CJ, and thank you, Advocate.
Thank you, ma'am. Honorable Nyambi.
Thank you, CJ. Morning, Advocate Hank.
Good morning, Commissioner.
One issue, probably it's not giving you a good image about yourself. From the Cape Bar, the issue of when you responded to the questionnaire, you say it's of public record that you are acquitted for the shot you fired outside a member of parliament home, but you do not disclose that you were charged in respect of the leader of the opposition, Colin. So if you can share with us what's the story here? Because it's like there's something that you responded, but when we go through what they are highlighting to us is giving a different picture. Probably clarify us.
Yes, certainly. Again, I must stress we are talking about 42 years ago, and it certainly was at the time headline news for a number of months in the newspapers. And I forget that I'm a little bit older than many people that are walking around today who would not have seen those newspaper reports. I was on the SRC. I was telephoned one day, shortly a week before Easter, during the week prior to Easter, and I was asked if this person asked if he could meet me. He represents a student bodies in America, and they've seen what I'm doing on campus and they want to meet. And I met him. That very night, first time I'd ever met Arnold van der Westhuizen, the shots were fired through the door of the apartment of Mr. Eglin. I had no role to play whatsoever. I was sitting in my car up on the road. I had no knowledge that he intended to do this. I had no participation, planning, or in any way, any involvement in it. It is the most classic example of being at the wrong place at the wrong time. He and his cohort, a certain Mr. Beelders, had been conducting a reign of terror in the Western Cape at that particular point in time, under the name Scorpio. I had never met them. I had no knowledge of them. I had no interest in them. I had no affiliation with them, and I did not in any way conspire with them or wish to be involved with them. But I was answering a telephone call, and I went and I joined this person for a few drinks, and this happened when we were on our way home. There was considerable pressure at the time to make it clear that attempts were being made to address this particular problem. Again, I don't want to delay time, but those two individuals were specifically targeting the Jewish community. And there was a lot of pressure on the state to have to do something because they could not catch these individuals. They were caught that night or the following morning because I went the very next morning to somebody, in fact, on the way home, to say, you will not believe what has just happened to me. That person reported it to the police, and I was arrested. I was on bail. Then my bail was removed because the prosecuting authority believed that it was necessary to do everything they possibly could to try to implicate me in the process. I went through a complete trial. I gave my evidence over a number of days in great detail, saying what I've exactly said now. I had no role to play. I did not participate with it, and I was acquitted of all charges. The fact that it happened to be the leader of the opposition at the time, I don't think was material to these people, but I certainly do not want to talk for them. I think it was because he was Jewish. I think that's why he was targeted. But it was most certainly not anything that I wished to, did play a role in. But it has been a shadow over my life. I did say earlier, I know what legal costs are because it cost me a lot of money. I left university with a very substantial loan of people that I had to repay for legal fees, and it derailed my plans to finish my LLB degree at the time. And without wanting to again be in any way emotional, I experienced one, a jail cell door shutting in my face, two, a person on the 4th or 5th floor of a building in Barrack Street with a considerable amount of rank, pointing to a book and saying to me, Mr. Hack, you are going to hang. What? You better talk. And I had nothing to talk because I had no role to play in this. And it gave me a further realization of the struggle and how so many people had suffered in that typical similar environment. But there was one big difference. Those people were there because they believed in something. They were there for a reason. I was there, wrong place, wrong time.
Thank you, Mr. Heck. Thank you, CJ. May I follow up, CJ?
Please follow up, sir. Go ahead.
Thank you very much, Advocate. Following the incident that my colleague mentioned, did you take membership of the Students' Moderate Alliance? If yes, who were the main funders of this alliance?
Sorry, you're talking about a specific other organization, Moderate Alliance, or you're talking about my organization, the CSA?
Yes, there was CSA, and there was later an organization called Students' Moderate Alliance.
I had no role.
You
I
had
don't
no
know
role
them.
in that.
I don't know them.
So you did not take up membership in that organization?
No.
Thank you so much. Thanks.
Professor?
Thank you, Chief Justice. Good morning, sir.
Good morning, Commissioner.
Would you mind to share your judicial philosophy with me?
Goodness. Dispense justice. Again, it's simplistic, but it is what it is. Look after the vulnerable. Look after the weak, the disadvantaged. My judgments show, particularly that I take a strong point about financial disadvantage. It's all very well to talk about the right to vote, the right to equality, and the right not to be discriminated against. But one of the single biggest problems, if not the biggest problem, that besets South Africa is poverty, is the lack of opportunities. I read, coincidentally, earlier this week, somebody saying, an overseas influencer, probably a youngster, but so be it, that privilege is not about having opportunities. Privilege is about not having obstacles in your way. And the biggest obstacle in the way of the determination of individuals in this country is poverty. And so look after the vulnerable, look after the dispossessed, look after the less advantaged in society as far as you possibly can by applying the law, of course.
And your understanding of the rule of law?
That it's paramount, that it is the basis upon which modern civilization rests and survives, and that is, first of all, upholding the fundamental principles of the Constitution and all such laws that are legislatively passed and or created in any other manner, as long as they are consistent with the Constitution.
Thank you, sir. Thank you, CJ.
Thank you, Prof. Commissioner Tsepe?
Thank you, CJ. Good morning, Advocate. I am actually covered, CJ. Thank you.
Thank you, Commissioner.
Thank you. Honorable Singh?
Thank you very much, Chief Justice, and good morning, Advocate. Chief Justice, my two questions have been covered, but I thought I must just respond, and perhaps for the record, on an issue because Judge Sally Sloper has been the subject of this interview. And I was on the JSC in 2014, October 2014, together with the politicians like Commissioner Didiza Matseka, Commissioner Malema himself, Commissioner Schmidt, when she appeared before the JSC in October 2014. And she was recommended by this JSC for appointment, and she was subsequently appointed by President Zuma at that time, I think on the 11th of December, to start on January 1, 2015. At the time when she appeared before us, she was not, according to my knowledge, married to Judge Sloper. The marriage only took place subsequently from records in April 2015. So I just wanted to clear that this JSC did not appoint her when Judge Sloper was the JP and when she was married to him at that time. Thank you.
Thank you, sir. Honorable Breitenbach.
Thank you, Chief Justice. Good morning, Mr. Hack.
Good morning, Commissioner. Are you with us remotely?
I'm sorry, yes, I am, and my connectivity is not great, so I'm not switching the camera on. You were arrested for the attack on Colin Eglin's home. You rightly point out that you were acquitted. However, were you a member of Scorpio?
No, I was not.
When you were asked to meet with these people, did you check on them? Did you find out who they were, what they stood for before you met with them?
Not at all, and I met only with the one, Arnold van der Westhuizen. Please do remember again, this was 1979. We do not have the advantage of the internet. I would have.
Yeah, I'm nearly as old as you are, Mr. Hex. I understand 1979 very well.
I received the phone call that morning. I met him that evening at a pub.
Okay. So you kind of downplay the Conservative Students Association and make it out to be the small little group of beer-swilling students. In fact, it was a semi-counter for NUSAS at the time. It was very pro-white, very pro-National Party, very pro-establishment. Do you differ from that?
Yes, I do.
I see. You say that you abhor violence, yet you align yourself with people of that nature.
I'm sorry, I don't understand the question. I most certainly do not align myself at all with people of that nature. If you're suggesting Scorpio.
Okay. And just as a matter of interest, Colin Eglin was not Jewish.
Oh, I apologize. I believed he was.
So part of the duties of this body, the JSE, is to protect the independence, the impartiality, and the effectiveness of the courts. Should the situation arise where a judge who has been found guilty of gross misconduct continue to perform the duties of a judge, notwithstanding such a finding, would this, in your view, not of necessity weaken the legitimacy of the bench and thus eroding its independence and its effectiveness?
I'm really not prepared to enter into that area. I do not believe it's my role to give any opinion in that regard. Again, if I'm honored to be appointed, I will apply my mind to whatever facts come before me.
I'm not asking you about the Western Cape Division of the High Court, Mr. Hack.
I understand, but I'm
asking
not.
You in general, you're applying for a position.
With
you don't have a view.
No, with the greatest respect, your question cannot but be in relation to the Western Cape situation. I mean, it's a very unusual situation to suggest this could happen on any kind of a regular basis. And I have again must assert the fact that I don't believe it's appropriate for me to make any comment.
Thank you. Believe it or not, you answered the question.
Thank you. CJ, is Dodov here? Can I make a follow-up, please?
Yes, sir.
Advocate Hack, do you believe or subscribe to a view that all of us, we write our own histories?
We
write our own histories.
Right.
With our conduct, how we behave, what we do. We write our own history. Do you believe in that?
We live our lives. If that's what you mean, then I would agree with you.
I mean, what we do today will follow us in the future. That is what I mean.
Yes, I certainly agree with that.
But do you also believe that we are the authors of our own misfortunes?
Yes.
Good. If you believe that, do you know Mr. Yap Mare, the late Mr. Yap Mare of the Hersterte National Party?
Yes, I recall.
Which was a splinter group from the National Party.
Yes, I recall.
If you remember, he succeeded Mr. Albert Herzog, who was the son to Mr. Barry Herzog, who was the Prime Minister of South Africa.
Yes, I
Yes.
do recall that.
Did you ever meet him
Never.
in your life, Mr. Yap Mare?
No, I never met him.
Okay. The information that I have, it may be not completely correct, is that when I read books about NUSAS, this conservative student body was an affiliate to the HNP. Do you believe that?
It's absolutely not correct.
Okay, thank you.
Factually not correct.
Okay. Thank you, Chief Justice.
Can I make a follow-up, Chief Justice?
Thank you, sir. Yes, Honorable Malema.
Can you just describe how this student organization was constituted?
It was registered with the university as a
No,
student.
let's take it from where it started. How does it start?
I do believe it would have been in the latter part of 1979, as 76, when I chose to make myself available as a candidate for the Students' Representative Council. And I realized I couldn't, without some appearance of backing, get any interest from the electorate. And so I personally created the name, and I think it was simply a question of filling in a form, and there you were, and handed it in at the administration at UCT, and you were a student society.
So in the comfort of your own room, you decided, I'm going to contest the SRC elections, but I will need an organization to do so.
Yes.
Then you formed an organization.
Insofar as it could be described as an organization, I created
so it was your own child.
Yes.
You wrote its own constitution. Did they have a constitution?
I believe we must have had, but it would have been very fundamental, primarily to
for that
support student representative council elections.
Yes, and then you recruited people into it.
It was already a circle of people that would sit generally and talk about what was happening on campus.
Yeah, but did they have members?
As I say, there were members, yes, but it never reached formal structure.
So after having these members, you never seeked some relationship with any of the political formations at the time?
No.
Were you ever addressed by anyone from the political formations at the time? Maybe during your campaign for endorsement or anything of that
sort? There
sort?
was a dinner, I remember, and it was addressed by the then ambassador to the United Nations, if I remember. South African ambassador to the United Nations, I can't think of his name at the moment.
He was in the National Party?
Well, he would have been an appointee of the government at the time, but he was at the United Nations.
I'm trying to establish where this confusion comes from. Perhaps someone from one of the political formations at the time came or endorsed you, or some of your members would have belonged to a political formation outside that student formation, and perhaps that linked to or creating this linkage which you don't know about.
I understand. Yes, that is very probably correct. There were a grouping of people, and they were a broad spectrum of people. They didn't all necessarily share my views.
Thank you, CJ.
CJ, can I make a follow-up? CJ, follow-up, Makwanisha.
Yes, Honorable Magwanisha.
Advocate Heck, what was the organizing philosophy of this organization?
I do apologize, I couldn't hear you.
What was the organizing philosophy of this organization?
It was to address the manner in which the University of Cape Town should respond to the oppression that was taking place at the time on campus. And as I say, it was a question of following the course of close the university down until such time as there has been liberation, or keep the university open, and in a certain sense, there the word conservative came in, conserve the university and focus on your education so that you can contribute in due course to liberation.
A follow-up?
Was it open to all races?
Yes.
Thank you, CJ.
There's a colleague who said follow-up where I couldn't make out who it was.
It's Xaba.
And myself,
Yes, Honorable
Chief
Xaba.
Justice Muima.
Yes. You see, at the time, politics was, in a way, for a lack of a better word, contested by the conservatives and the liberals. Do you agree with me?
National politics.
Yes, national politics.
Yes. It was the governing party and the Progressive Party at the time.
And then as a founder member of this organization or club, you saw it fit to name it a conservative club.
It was very unfortunate. It was a very unfortunate choice. I did not in any way align myself with the state, the government, or the National Party.
And you say that you chose education for liberation to contradict education now and liberation later. And you add that that was not a political philosophy. Did I get you right?
Well, I'm not too sure if I've been understood. I'm not suggesting that that's not a philosophy which is of a political nature. It's a political philosophy. Yes, it is. I think the question earlier was this organized? Was the CNS, the Students' Conservative Alliance, an organization? I said absolutely not.
Thank you so much, CJ. Thank you very much, Advocate.
Was it you, Honorable Muima, who wanted to follow up?
Yes, Chief Justice.
Go ahead, sir.
Just in terms of student politics formation, so in the 70s, 80s, NUSAS was a national federation of SRCs. And the form that it took, it was a bit of progressive, but of course, because of the limited number of black students, particularly on those white campuses, SAS was born, and it evolved into Azaso and SANSCO, and in 1991, NUSAS and SANSCO united to form SASCO. I think the point that we just wanted I just want to bounce with you is that, look, many progressive and liberal white students were organized under NUSAS. So I just want to get a sense in terms of your posture. Were you opposed to the progressive nature of NUSAS? Because the K-Bar Society says that your views evolved from a bit of conservative and in your later years of studies to being progressive. Is that the reflection of your comment?
No, it is not. I learned more. I came to understand better, but my views did not change. I was committed to democracy. When I joined the SRC in 1976, I was committed to universal democracy, freedom. I did not understand the struggle. I did not appreciate what the greater majority of the country had endured and had gone through. And I did use the words, my views developed, but they developed into simply a better appreciation. as we are spending time on this, to give you an example, while I was acting and at coffee with the judge president, he spoke about not being allowed to be in a white area after whatever it was, 5 o'clock. And it did hit me for the first time that on that particular point, I had never appreciated and understood it. So I'm just saying, and I did say, and that's what is being quoted in that bar reference, that my appreciation and understanding developed, but my views were not that I changed from being a conservative in the broader sense of the word to being a liberal, a radical, a socialist, whatever it be. These are all unfortunate labels at the end of the day. In many respects, I embrace all of those labels, but it's not useful to have these labels. I was committed to liberation and to democracy. It was the manner in which it was going to be achieved. I believe there was already sufficient pressure being applied in the United Nations, from the European countries, not from England, from the European countries, particularly the Nordic countries. The boycotts of sport were hurting the white minority government, and I did believe that it was going to be possible to have freedom and democracy, not necessarily through the barrel of the gun.
Thank you, Advocate Jack. Thank you, Chief Justice.
Thank you, sir. Advocate KNSC.
Thank you, Chief Justice. Good morning, Mr. Hack.
Good morning, Commissioner. I'm sorry, I don't see you. Are you with us remotely? Sorry.
Yes, I am.
Sorry.
Good.
Yes.
I want to take up the topic with you of public perceptions, because as you know, justice must not only be done, it must be seen to be done.
Of course.
And the difficulty I want you to give me some comfort in relation to is that you are being appointed to a bench that is deeply divided. It's a matter of public record that there is hostility between the judge president and the deputy judge president, amongst other hostilities. And that it's a matter of public record now also, and indeed there's a finding by the Judicial Conduct Tribunal that the judge president under whom you will serve has been found to be guilty of improperly attempting to influence two justices of the Constitutional Court. Now, in that context, I come back to this question of perceptions. It is known that you, and accepted by all relevant persons here, that there's a long-standing friendship between you and the judge president and Judge Sali Schlorbeck. And by all accounts, you attended their wedding. Now, with that history, would there not be a perception that you would be amenable to the influence of the judge president, and in fact part of the faction of which he is part on that bench?
Thank you. Let me first say that in the 9 occasions that I have acted, the judge president has never in any manner or means whatsoever referred to the contents of the file that he placed in front of me or had delivered to me, or in any way whatsoever tried to influence me. The judgments that are in the dossier show that I have dealt with relatively controversial matters, matters involving members of the legislature, and under no circumstances has the judge president in any way tried to influence me. Secondly, I know there is a perception that the Cape bench is divided. I have not experienced that on a personal level. I have always been treated with courtesy politely, with collegiality by every judge that I've had interactions with, including the Deputy Judge President. I know my name has been mentioned in the complaints, and I know her views, but at the same token, we have always treated each other with the necessary politeness, friendliness, collegiality. I do not see myself as being in any camp. I believe, again, that my judgments will be the basis upon which the public will see me and see my role on the bench. I am mindful not to enter into any public media statements, which I've already demonstrated today, and I will continue doing so. But finally, all I can say as far as the position of the proceedings against the Judge President is that they must follow their course. There must be due process. And I will eschew nothing other than due process. I'm not sure, I hope that's answered your question.
Mr. Hack, we all agree that due process is in order and must take place. The question was really about public perceptions, though, and that given your long-standing friendship, there would be a perception that you would be on one side and a perception that you may be subject to influence, and that, let me put it plainly to you, the Judicial Services Commission may be better advised to appoint somebody in these circumstances with no such long-standing friendship in place.
Again, undue influence. Undue influence in respect of what? Undue influence in respect of my judgments? I do not believe that there is such a public perception. I think the Western Cape is a sophisticated society like the rest of the country. It understands that individual judges must honor their oath and their obligations to judge without fear and favor. And at the end of the day, if I should again be so fortunate to be appointed, it will be this body that appoints me, not the Judge President of the Western Cape. And I will conduct myself accordingly, and I would say to you that I don't believe that you would be correct in saying that my appointment by this body would create the wrong impression or a negative impression that I might be pliable in any way whatsoever.
Thank you, Chief Justice.
Thank you, Advocate Kane. Mr. Hack, thank you very much, sir. You're excused.
Thank you very much.
Colleagues, we
The candidate is ready, Chief Justice.
Good day, Mr. Hockey.
Good day, Chief Justice.
How are you, sir?
I'm very well, thanks, Chief Justice, and you?
I'm very well, thank you. You've been an attorney for about 30 years, am I right?
Yeah.
And you've had several acting stints as the High Court judge.
Yes, yes. I've acted for 4 full terms, Chief Justice, and 1 half term.
Did the acting stint allow you to adapt properly to the High Court environment?
Yes, yes, it did. Chief Justice, my first stint was long ago, in 2004. I thought at the time that I dealt with the stint very well. I wrote good judgments. I enjoyed it. But the one area that I thought I could improve at that particular point in time was to get more experience in commercial and corporate law. And I did go back, and I went from a small firm to a very big firm, one of the biggest in South Africa, in 2007, and I've been there for 13 years. And it was a wealth of experience that I picked up there. In a small firm, one tends to reach a glass ceiling. And in a big firm, one deals with very, very complex matters. So that complexity and the experience in commercial and corporate law is something that I think, as a black lawyer, I can bring to the bench.
Has it ever been a struggle for you to produce a judgment within the recommended period?
Not at all, Judge, Chief Justice. I've got no judgments over 3 months. I've got my own personal time period of 2 months. Many of my judgments I produce well below that within that period. There are 2 judgments that I delivered just under 3 months, just under. But there were reasons for that. It is, and if you will allow me, I can demonstrate. The last term of last year, there was a period. In fact, the judgments that I listed as outstanding at the time when I completed my forms, if you look at when those matters were heard, you will see that the four of those judgments, no, three of those judgments, reserved judgments, I picked up over a period of 4 days. It was an extremely busy term. And I think there was a lot of catching up to do in terms of the backlog because of coronavirus. The week before I picked up those judgments, there was another 2 that I picked up, which I completed by the time that I completed my forms. So the 3 judgments that I did note in my application form were all delivered within the 3 months. The one I in fact delivered on the 21st of December, just the day before that, I delivered another judgment that I just picked up after I completed my form. In fact, I delivered 2 judgments during that period. And the other 2 I delivered in January, also before the 3 months. I worked out during recess.
Okay. All right. Now, just as briefly as you can, did you ever get an opportunity to put your arbitration skills certificate and certificate of training as an accredited mediator to use? Just as briefly as you can.
Yes, I did. I presided over matters. I presided over very confidential matters, and I presided on a local government level where there's when executives gets charged in local government, they normally there's investigations. They appoint independent chairpersons of the disciplinary hearings. So I've presided over that, and several others. And my mediation skills you use every day. I use it in court every day.
Right. No, thank you very much, Mr. Hockey. Colleagues, may I have names of those of us who have questions for Mr. Hockey?
Makwanisha.
Lucas.
Madonsela. Dodovu.
Tepe.
Was there somebody before Honorable Dodovu? Okay.
And Schlemmer, please.
Breitenbach, please, sir.
Maya.
Thank you. JP, over to you, sir.
Thank you very much, Chief Justice and fellow commissioners. May I also similarly disclose that I have known Mr. Hockey for a very long time. I first invited him to act in the Western Cape High Court. I think it was in the year 2004. I consider him to be a friend, and we have a lot of mutual friends. At this point in time, Chief Justice, I have no questions for this particular candidate. Thank you.
Thank you, Judge President. Premier.
Thank you, Chief Justice. Good day, Mr. Hockey. Thank you very much for being here. My first question, as will be to everyone. First of all, as I've always said, I'm a very proud South African, and I am very proud of our Constitution. And of course, the Constitution giving us the separation of powers.
Yes.
And in that light, and in the time that our new democracy has been in place, are you happy that those separation of powers are working, that there doesn't seem to be a creep across from the political, the executive, and the judicial? Do you think that we are on track?
Yes, Premier. I think it works. I think the judiciary is there as a very important pillar in democracy to see that there is no crossovers. There always will be, but there are checks and balances, and the judiciary is there to make sure that there's no encroachment of the executive, and we all know of the cases. There are cases where the executive encroaches on the powers of the legislature, and vice versa, and the judiciary, of course. The judiciary especially must be as a bastion of the rule of law. Must make sure that the judiciary rather does not encroach onto executive functions and functions of the legislature. And yeah, so I think it works. I think we get tested all the time. We have been tested. And there will be tests in future. There will be people that make mistakes. But I think we've got systems in place to make sure that the three arms of government works.
And then, Chief Justice, if I can follow up on that question. So then, Mr. Hockey, are you happy with the makeup of this commission, which is now obviously in the judiciary space, but loaded with politicians? I'm one myself.
Yes.
Go ahead.
I think it is. I'm happy. Yes, I think it's important. It's extremely important to have lawyers there. In fact, of course, there must be lawyers. There must be people from the judiciary because they know best what it requires to be there and what skills and attributes one must have to be a judicial officer. But importantly, people that are public representatives, politicians, representing the public, need to have a say as to who is going to preside over the cases of the public. So yes, I'm fairly happy. I do think the lawyers play an important role, but politicians and civil society must have a say, no doubt about it.
Thank you very much, Chief Justice. I've got one more question, and that is in reading through your CVs and the documents and looking at even, can I say, in your own statements that you say that you perhaps have limited experience in criminal matters.
That's actually not true. I cut my teeth in criminal law. In fact, Premier, practitioners of my generation is expected to have experience in criminal law, family law, MBAs. It's just so when I started practicing in the 90s, we didn't have opportunities often to join the big firms that does commercial law. So I started off with a firm that does a lot of human rights, did a lot of human rights work, and my principal ran the criminal department in that law firm. And for 2 years, I almost exclusively did criminal law. After completion of my articles, that partner left the firm to start his own practice. And a year after that, in fact, immediately, I was tasked to run that department. And I was made a partner just about a year and a half after that to run that firm. But I very soon told him that criminal law, of course, it's important. It's important for purpose of access to justice, and everybody's got the right to decent, proper legal representation. But it's not something that I wanted to have my whole career focused on. So I very soon started doing other work. With the advent of our constitutional democracy, and you'll see in my CV in 1994, when UCT offered a course on constitutional law, I jumped and I did that course.
Thank you very much. Thank you very much, Chief Justice.
Follow up, CJ.
Thank you, Honorable Premier. Is that you, Minister?
Yes.
Please go ahead.
Mr. Oak, do you consider the Constitution the supreme law of the country?
Absolutely.
So,
absolutely, Minister. Wonderful.
In that case, do you think it will be fair for us to ignore the Constitution in relation to the composition of the JSE and respect it on other aspects?
No, I think we have to abide by the Constitution, right? I think that the Constitution it's there. We have to abide by, but besides the fact that the Constitution makes provision for the composition of the JSE, I personally, there may be very other good reasons why there should be changes, but personally, I believe that the Constitution prescribes the right composition.
Thank you. Thank you, CJ.
Thank you, Honorable Minister. Honorable Magwanisha.
Thank you, CJ. Good morning, Mr. Hockey.
Good morning, Commissioner.
Your CV demonstrates that you are a member of many progressive organizations. And it also demonstrates that from 1993 to date, you have been in a position of authority at the level of a partner in 2 firms. Now, how many blacks and women did you brief?
How many blacks and women did?
Did you brief as an attorney? In which areas of law? And to what an extent can you, if you can give me 5, who you can say I have contributed to these people being silks?
To the individuals?
Yes.
Honorable Commissioner, I've actually got, and there are other people as well. In my previous firm, we briefed in the 90s. There were not many opportunities for counsel. There are more opportunities now, but it's still, briefing patterns is still skewed. So
let me help you. Let me help you for the sake of time.
yes.
Can we focus on Weber Wenzel?
Where?
Can we focus at your time at Weber Wenzel, where you are a partner?
So currently, yes, Commissioner. Currently, I brief. In fact, Weber Wenzel keeps a statistic of who we brief, and not just in terms of the number of briefs, but I think it's also important to take in consideration the value of those briefs. Because you can brief somebody to go to 3rd Division or the motion court and appear for half an hour or an hour and charge a minimal amount, and then you tick that as I've briefed black counsel. So one must also look at the value of a brief and the complexity of the matter concerned. I'm very reluctant to name names, but I can assure you, and my record shows that probably about 60% of people that I brief is between 50 and 60% in terms of value are black. I don't want to go into name people without their permission. So please allow me not to name names, but I give you my assurance.
Fair enough.
That is the case.
Yes, fair enough. Can you say the areas of law where you brief them?
Yes. So the areas of law, my practice at my last firm is mostly commercial and some administrative constitutional law. So those are the areas. Those are the areas that I became very fortunate that I have very big commercial clients, corporate clients, and I had matters that are extremely complex, and one matter, for example, there's a quantum of over 1 billion rand as a capital amount, and that may have run up now to 2.53 billion rand. So those are the nature of the matters. And in that matter, we brief black counsel.
Thank you, CJ. Thank you, Mr. Woki.
Thank you, Commissioner.
Just in passing as a follow-up, were you in attendance of the gathering by Weber Wenzel senior executives that I was asked to come and address?
I was there.
Where I raised the issue of briefing patterns, and if you were, has there been improvement ever since I raised my concerns there?
Yes, I was there. I was there, Chief Justice. And in fact, there was an ongoing discussion, and I think you assisted very much with in that discussion, and that in fact that discussion culminated in the firm keeping records, and there's been a major improvement over the years, and as I say, I was one of those to say that you mustn't just tick boxes, you must actually keep records. And there is an improvement, and I believe it is still going to improve. I do think that people took at heart what you said, but there were many of us within the firm that of course have taken up that discussion before the time that you came to address us.
Chief Justice.
Honorable Lucas? Oh,
May I please
I couldn't make us, I apologize, Honorable Lucas. It looks like, is there a follow-up or an addition?
It's a follow-up, Chief Justice. It's Madonsela. It's my question relates to the same subject matter, all around the same area that you have just made.
Okay, you may just as well, you were going to come after Honorable Lucas, so do that and ask whatever other question you're going to ask. Sorry, Honorable Lucas, you'll come after him, I'm sorry.
Don't forget me.
Thank you.
No, look, in fact, it's the only question that I had. Oh, no, just the two questions, yeah. The first one is in relation to the fact that you are an attorney with Weber Wenzel. And I just want to get the assurance in my mind that you have nothing to do with the letters written by Weber Wenzel to this commission, GSC, in which Weber Wenzel represents certain organizations making certain demands to the commission, which I think might be problematic for me. Am I correct that you have nothing to do with it?
Thank you very much for that question. It gives you an opportunity to clarify something else.
Yes.
I, in fact, resigned. I've put in my resignation in January last year, and I had very good and fruitful discussions with my senior partners and others because, sorry, I'm going to digress a bit because I think it's also important. I joined Weber Wenzel in 2007. And I told myself that that would be a period for me to get exposed to more commercial work and to make a contribution to the firm in terms of transformation, etc. And I said 5 years. I stayed for 13 years because I enjoyed it so much. I enjoyed being part of the leadership of the firm. I enjoyed making a positive contribution in terms of transformation within the firm. So to come back to your question, I'm not even aware of the content I said. I didn't know that Weber Wenzel wrote. So I'm not a partner at Weber Wenzel. I left to take on a new challenge, and that new challenge, in fact, I'm a very determined person. And I set goals for myself, and my goal is to make a contribution to the bench.
Well, thank you very much. I just needed that clarity in my mind. Secondly, which is the question that I wanted to ask, another question is that I see that you cited one of the cases in which you appeared, which is a case of significance.
Sorry, I can't hear so well.
The case of significance that you have cited, in which you appeared, is one that is of some familiarity amongst lawyers. The Richtersveld community case, which went all the way up to the Constitutional Court. I just want to find out, what role did you play in that matter?
Thanks, Commissioner. I came in after the matter was heard in the Land Claims Court. I got involved in the Supreme Court of Appeal, and more intensely in the Constitutional Court, and what happened thereafter. And the role was really, we've reached the stage after the judgment to facilitate a settlement. I acted for the mine. The mine wasn't really the principal party in the litigation. It was really between government and the community. But the mine, of course, Alex Co, a state-owned company, was obviously a interested party because it owned the land. that was subject to the matter. So I'll,
So you were acting for the landowners against the land claimants?
we were acting for the landowner in that sense, yes. But it was really a role that we had to clarify what is happening. We had to obviously assist the court in terms of how the land was being used. We were not involved in the historical dispossession. That argument we were not involved in at all. So it was more what the land is about and how, especially after the case was successfully argued in the Constitutional Court, we also had to, of course, be involved in the final settlement. We weren't involved in the original negotiations that was done between the community and government, the state.
What was the final settlement?
Sorry, what was?
What was the final settlement?
The final settlement.
Yes.
The final settlement was that the land was transferred to the community. Alex Core retained the rights to mine on the sea, the mining rights in respect of the land. The sea mining rights was, of course, not subject to the case, subject to the claim. So Alex Core retained the right to mine in the sea. The community was granted the mining rights in respect of the land, and the settlement involved a pooling and sharing joint venture in terms whereof the sea mining and the land mining happens under one umbrella, a joint venture.
Thank you, Chief Justice.
Thank you, sir. Honorable Lucas.
Thank you, Chief Justice. In fact, my question will be the same one as the one that was now raised by Honorable Madonsela. But I just want to understand from Mr. Oki. Good morning.
Hello.
The Richtersveld claim, according to the settlement that was agreed upon, is one of the biggest claims that was settled in terms of land redistribution or restoration of land to the original owners. But what should be the role of any legal firm that is supposed to be representing claimants, just generally, and particularly with regards to the Richtersveld, the fact that after so many years, the communities of Richtersveld are still not getting the benefits of this settlement that has been there?
Of course, as a lawyer, you're not involved in that kind of intricacies, but of what is happening there. But I think if I can make a general statement, I think it is very sad, very sad. It perturbs me that not only in the Richtersveld, but for other claimants as well, when things just didn't work out. And people that have been deprived of land then win through the land claims process ownership of their land back, but they don't see benefits. I think it is really, really sad. And I think, not just as lawyers, but I think the government needs to also step in and step up, because there's a lot of support needed, a lot. Things have changed over the years, and the use of land has changed. We're in a very modern society where the methods of the way that people conduct agriculture is different, and we live in a competitive world. And I think it is the role of the Department of Rural Development and Land Affairs, and they do. I'm not saying that they don't, but I think not enough is being done to support those communities. And I think we must government. I don't want to speak for government, or I don't want to speak. I'm not a politician, but at least the least that we can say is that there are a lot of lessons that can be learned.
So my second question is a follow-up to the very same issue. I've noticed in the list of cases that you have mentioned that in the Supreme Court of Appeal, you have actually appeared for the community of the Richtersveld. Before 2004, you have appeared for the mine, for Alexco as a company.
Yes.
So I just want that
No,
clarity.
I-
And was
I-
there not a conflict of interest?
No, I must apologize if there's a wrong impression there. I always acted for the state-owned company in that matter, not for the community. I must say I had very good relationship with some community leaders. There's a lot of problems there, of course, but through the litigation when I was involved, and I got along very well with them.
Oh, thank you, Chief Justice. Thank you, Mr. Hockey.
Thank you, ma'am. Honorable Dodovu.
Thank you very much, Chief Justice. I can see that you have written a lot of judgments around local government.
Yes.
Where political parties are involved. In your view, is there a lacuna in terms of the legislation, generally speaking, on local government, given one, the challenges that are facing local government, the crisis, as well as the tensions that are within local government? Is there something that needs to be done in terms of the legislative framework?
Let me say, I'm not an expert. I'm not an expert on local government. I've done work in local government. I've written, in fact, just yesterday I handed down another judgment concerning local government issue and the provincial minister or the MEC's right to interfere in local government. I honestly can't say whether there are lacunas, whether there's always room for improvement. And I think we're still a very young democracy. And we must not let opportunities go by where we can learn from something that is not working. But maybe the expert can tell you there's this problem, there's that problem in terms of the legislational processes. But if a set of facts, if a case is put in front of me, I would be able to identify what the problems are. But right now, broadly speaking, I think I can't think of anything else.
Okay, no, it's okay. I understand that. I looked at the questionnaire that you filled, the JSC questionnaire that you filled. In page 9, I see a lot of discrepancies. Is that human errors or
which case is that?
I'm saying at page 9 where you finished information about the positions that you held. Just go to your questionnaire, the JSC questionnaire.
Yes.
And I want you to answer me directly, because if not, I will have to follow up some questions.
Yes.
I see a lot of discrepancies here and misrepresentations. I'm asking myself whether is that human errors or is a misrepresentation.
Can you just point me to it?
If you want me to go there, you say you were a member of Azaso.
Yes.
Between 1992 and 1998. Yeah, that's what you say. And
That's a mistake.
That is why I'm asking whether is that a human
I saw
error?
that last night. In fact, the 8 should be 9.
Because what we say now in this commission will have profound implications for you.
Yes.
That is why I'm asking whether is that a mistake, because
it's an error.
Azaso ceased to exist in 1987. Is that a mistake?
Azaso became Sans.
I know.
Yes,
I know. I'm
yes.
saying
Yeah, so it is an error.
1987.
It is an error. I obviously just took it as one,
Yeah,
but
yes,
Azaso morphed into it. It was a name change, really.
Yes, and and you also say that you were a member of SAICO, the South African Youth Congress, between 1992 and 1997. Is that a mistake or what? Because
That is also, what I mean there is, before SAICO was formed, there was obviously youth structures.
I'm not talking about that.
You're talking
I'm
about?
talking about the fact that you were a member of the Silverton Youth Movement,
Yes.
which was affiliated to SAICO.
Yes, it became.
Yeah, that's what you say. That's what you have written.
Yes.
And my point is that SAICO ceased to exist in 1990.
Yes.
And in terms of the information provided here, you were a member of SAICO between 1992 and 1997.
No,
Is that correct?
I'm talking about South African Youth Congress.
Yes.
Was formed in the 90s.
Yes.
In the 90s, I don't know when it ceased to exist.
It was formed in 1987. It ceased to exist in 1990. But in terms of the information provided, you say you were a member between 1992 and 1997. That is why I'm asking.
No, yeah, it's a mistake. It's a
a
mistake. I got my decades wrong.
Yes, because this will have profound implications for you.
Yeah, no, I apologize.
If it's a mistake, it is.
I
The last one,
apologize.
the Athlon
No,
action.
before you move on that one.
Okay.
See, through you, CJ. Were you a member of SAICO?
Yes, Honorable Malema.
Were you a member of SAICO?
I was a member through. I was obviously didn't serve on the executive.
Yeah, not that.
I was a member through a branch
of SAICO.
Of SAICO, yes.
When?
It was in the 80s. I can't recall when SAICO was formed, but obviously we had our youth organization before. We were part of the formation of SAICO. So it was in the 80s, Honorable Malema.
Okay, thank you.
Sorry, I apologize. That is embarrassing era. I got the decades wrong.
Actually, I must say, I'm very, very good to you. The last one, the Athlon Action
Committee, there's a mistake there as well.
Committee.
Yes.
Yes, for me, these are important historical moments in our country, and I'm jealous about them because I don't want mistakes in that respect. With that, thank you very much, Chief Justice.
Thank you so much, Commissioner.
Thank you, sir. Commissioner Tsepa.
Thank you, Chief Justice. Good day, Mr. Hockey.
Hello, Commissioner Chepe.
I just wanted to discuss something in the GCB comments.
Yes.
They say your judgments there appear to be a lack of constitutional matters, or that you don't seem to have had any constitutional. You didn't have an opportunity to engage on constitutional law matters. They do say that in your practice you have done some constitutional law matters. I just wanted us to clarify that issue, whether while acting you had an opportunity to engage with constitutional law principles, and if so, when, which judgment would those be, and if you could just take us through. And it's in the context of Section 39(2) that I'm asking this question, and I would like you to just take us through.
I think that the Bar Council was very complimentary, but they missed some of the judgments that I wrote, or they didn't really study it very carefully. With due respect, I think I've got a lot of support from them, but they missed the point. There were few, but if you want me to point out one, there's the issue of the it's called the Plaaslike Besorgde Inwonersvereniging versus various political parties. In fact, not various political parties, versus the George municipality, which concerned the election of the executive mayor, which happened last year during the early part of the lockdown. I think they missed the point that they are dealt with political rights, And what I said in the judgment deals with a lot of issues that if you deny a public representative, somebody that's been democratically elected by the public, if you deny that person a right to vote, then you make nonsense of the right in terms of Section 19 of the Constitution of the right to vote. So I did deal with the constitutional issue in that matter. There are also other matters where I dealt with constitutional matters.
Okay, thank you, Mr. Hockey. The second question relates to other adjudicative functions that you would have engaged in other than the time when you were acting at the High Court. Do you have any, and what role do you think they play in, were you to be appointed as a judge?
I don't quite understand functions in terms of?
Any other adjudicative functions that have you been involved in? Arbitration, quasi-judicial fora?
Yes.
Yes, and could you tell us a little bit more about them, and in what way do you think they will assist you in your role as a judge, were you to be appointed?
Yeah, thank you, Commissioner Chepi. I dealt with it a little bit earlier on, but I did mention that arbitration often by the very nature is confidential in nature, and I obviously can't divulge the parties and the nature of the disputes, but I were involved both as a litigant and as a presider in commercial arbitrations. I did mention also earlier on, I think I did mention that I also did one particular very sensitive matter on local government where I acted as chairperson. And when it comes to mediation, if you consider that also as a quasi-judicial function, all the time in my litigation, I think it is so beneficial to your clients if you have good mediation skills, because lawyers tend to be in the system that we have. Lawyers tend to only look at their clients' case and their argument and how they can build up their clients' case. And I think because of my skills, I look at the strengths and weaknesses of the opposition, and I make a good assessment of my client's case. And that is why, in fact, many of my cases often don't. I do a lot of legal opinions. I'm not in court every day, so I use those skills to avoid litigation in court. But I've been come back to your question, Commissioner Chepe. We had an engagement a few years ago, and I think the two of us, we very constructively settled the matter that we really didn't want to go further than the two of us. And I think those attributes help when you're a judge. I can demonstrate an example for you, and it's just one example of many. When we do third division, we do motion court, and normally at the end of third division we have divorces, and then we have Rule 43 interim orders pending final divorce orders. So my attitude is to call the parties in the morning, especially I'm just referring now to the Rule 43 matters. I say, you're going to come up at the end of the row, don't come to court, use the time to try to come to an agreement, either narrow the issues or agree. Often they come back to court with the order. And I tell them the reason why. I've done it in court, in fact, in front of everybody else, where I told parties that this is not the matter that I want to hear argument on. It's an interim arrangement that you want the court to order on. I don't see why the parties cannot agree with it. Often there are children involved. You know, arguing matters in court and enforcing orders has a negative effect on the parties and especially on the children. So I try them to come to an agreement, and I use those mediation skills all the time.
Thank you, Mr. Hockey. Thank you, CJ.
Follow up, CJ.
Thank you very much, ma'am. Yes, go ahead, Honorable Minister.
What is your view to the criticism that the overuse of arbitration and commercial disputes in South Africa denies the courts an opportunity to develop jurisprudence on complex commercial matters, while we do acknowledge that arbitration does help to expeditiously deal with matters and so forth. But to that aspect of developing jurisprudence, what is your view on that?
Honourable Minister, I think firstly, I don't have any strong views which system is best. I have confidence in the courts. I think our courts are amazing. I have confidence, but there are instances where parties would have agreed in corporate agreements that if there are certain disputes that arise between them, they must go to arbitration. I still think there are very complex matters that come to court, you know, as a judge, we must deal with it. I don't have strong views. I think the nature of our system and the wonder of our system is that we give leeway. There's this freedom, and parties must decide. I personally never pushed arbitration. I think the courts are very competent to deal with complex issues. But I see where you're getting at. I think there are people, let's be honest about it, there are practitioners that mistrust the court system. I don't agree with that. And they tell their clients, let's arbitrate because we don't know what we're going to get in court. There are those people. I don't ascribe to those beliefs.
Yeah, that is another aspect, but remember the other aspect is that the arbitration is confidential. Yes. And even the arbitration award itself is confidential. So it also denies any other party some kind of precedence or that could help, even if it's an arbitration matter, but you can't get any form of precedence from that.
Yes.
It is only known between the parties.
Agreed. That's unfortunate. Obviously, there are sometimes justifiably instances where people don't want to hang out with this dirty washing in public. There are sometimes confidential commercial issues that are dealt with that people don't want competitors to get to know of. So for those reasons, the confidentiality aspect of it is understood. But I fully agree with it that the benefit that we can get from those complex, sometimes very complex arbitrations are not there for the general public. But I do think in the same vein, Honourable Minister, that our courts are dealing on a daily basis with extremely complex commercial corporate matters.
No, okay. No, that's fine. Thank you. Thank you, CJ.
Thank you, Minister. Professor.
Thank you, CJ. Good afternoon, sir. We met in the lift yesterday evening.
We did indeed, Professor Slimmer.
Would you mind sharing your judicial philosophy with me?
My judicial philosophy, Prof, is that we live in a constitutional democracy. So when a judicial officer exercises his or her judicial functions, it must be done in terms of the prescripts of the Constitution, and the Constitution informs and facilitates the rule of law. That in a nutshell is my judicial philosophy. I think where that goes, questions of substantive and procedural questions. I think procedural aspects are also important. But substantively, when a power is exercised by a public functionary, it must of course be exercised in fairness and not arbitrarily. It also requires that there must be a set of rules, laws that are clear and fair. And on the procedural aspects, of course, exercise of any public power must be done with fairness, which includes your outre partem rule, and under our democratic democracy, public participation sometimes, often, if people are affected by whatever powers are exercised. In a nutshell, Professor, that is my approach, my judicial philosophy. I hope that is that answers.
Thank you for that. A next question that I want to pose to you is based on something also that the GCB says in their argument, in their document. They say we have to weigh up objectively the quality and diversity of your judgments against the other candidates. What, in your perception, is the quality of a good judgment?
The quality of a good judgment, firstly, I believe in part of quality, not everybody might think this way, but part of quality is to be clear. I'm a big proponent of clear, simple language. That is part of it, but otherwise, judgment must consider all the issues. It must analyze the facts. It must apply the law to those facts, and it must be convincing. It must be convincing, it must be astute. Every judgment should be almost like a thesis, I believe. It must be scholarly. I know that is a word that has been used, but I think I give a lot of time and effort in my judgments. And I think it is the duty of every judge to, if you want to dispense justice, you must write a good quality judgment. Different judgments structure the judgments differently. I've got a particular way. But yes, I don't know if that answered everything that you wanted to hear, but we can talk about it for a long time.
Thank you, sir. Thank you, Chief Justice.
Thank you, Prof. Honorable Brayton.
Thank you very much, Chief Justice. Good afternoon, sir.
Good afternoon, Honorable Brayton.
I'm sorry, I have poor connectivity, so I'm hoping to preserve the sound by not switching on the picture. You'll agree with me that part of the duties of this body, this JSE, is to protect the independence, impartiality, and effectiveness of the courts.
Yes.
Should a situation arise where a judge who has been found guilty of gross misconduct continues to perform the duties of a judge, notwithstanding such a finding, would this, in your view, not of necessity weaken the legitimacy of the bench, thus eroding its independence and effectiveness?
Honorable Breitenbach, that question is obviously asked in a particular context. I'm going to ask that I please don't be drawn into the debate about the Judge President of the Western Cape. I say that for various reasons. I can motivate why.
Please do.
I get along very well with the Judge President. I'm very pleased with the opportunities that he's given me. He's given me work that's complex. I get along with him, and I do get along with every single judge. You know, we sit with judges all the time as colleagues in appeals, etc. And I had absolutely no problem with any of them. Neither, I believe, they have with me. I think all of them without exception, support. I can't say because there are some that didn't indicate, but many of them have in fact indicated that wished me luck. And I personally would like to retain those relationships with everybody. I've got good friends there, and I tell them, in fact, when I started last year, when I started my acting stint, I told them that I'm not going to get drawn into this debate. People put you in a camp so easily. And I think it's very unfair, very unfair. Everybody agrees that there must be collegiality. Everybody across the board. There must be collegiality at the KPNs. And once you get put in camps, it makes it very difficult. You know, there are perceptions which are sometimes unfair. So I ask you, please don't involve me in that debate.
Thank you very much, sir. Unwittingly, you have in fact answered my question. Thank you. Thank you. I'm done, Chief Justice.
President, thank you very much. Over.
Thank you, Chief Justice. Good afternoon, Mr. Hockey.
Hello, President.
Molo Shongololo tells us that you're a passionate advocate of children's rights and have extensive involvement in their operations. Thank you. I just want to thank you for that. We need many more men in this country who will protect our children. Now, first, a quick follow-up to the minister's lamentation about the possibly adverse effect of arbitration to our jurisprudence. Would you not agree with me that the court will always have a place in dispute resolution, because things do go wrong in the world of arbitration, and when that happens, where do the parties go? They come running to the courts, and we see those kind of cases every now and then in our courts.
Absolutely, no, I agree with you fully, President. Fully, I agree with that. The courts have a very, very important role to play. As indicated, sometimes people resort to arbitrations, but they end up in court. So I have full confidence in the courts, its capabilities, and its role.
Yeah. Just one question. According to your declaration in your questionnaire, and the GCB raises this as well, you have negligible experience in criminal law. Could this deficiency, if I may call it that, compromise your ability to preside in this big and important component of high court work?
President, I disagree. I've got experience. As I said earlier on, I cut my teeth in criminal law. I ran the criminal law department in my previous firm for a while. It was many years ago, but it's like riding a bicycle. Once you can ride it and you put it aside, and 20 years later you get onto it, you ride again. I'm comfortable in criminal law. I've done quite a number of matters, applications that involves criminal law, appeals, applications. In fact, if you look at the cases that I've submitted with my application, there are criminal law involved there. There's a matter there that I think is very important for criminal law jurisprudence concerning the Firearms Control Act. We analyzed the act, and it was basically an application, a reivindicatie application, where somebody that transgressed the rules and regulations in the act, Firearms Control Act, and they wanted the police confiscated. They wanted the firearms back. I ruled against him, of course, but that's part of criminal law jurisprudence. I've got a. I'm not a criminal lawyer. I haven't done criminal law for practice. In fact, I did do a criminal law case about 2-3 years ago, where I had the opportunity to also use my mediation skills with the listeriosis matter that happenings. I think it was about 3 years ago. One of my clients faced charges, and I engaged with the prosecuting authorities and had good discussions, and it culminated in a Section 105 capital A plea and sentence agreement. So I've got the capabilities. I can do it. I'm comfortable with criminal law. And as I said earlier on, black lawyers from my era are expected to know only criminal law, MVAs, matrimonial law, the odd civil law matter in the magistrate's court. I've broken those shackles, and I armed myself to do other work, and I bring that as a black lawyer. There are many other black lawyers that's got very good and vast criminal law experience that can contribute that to the bench. I can make another contribution, but I must say, criminal law is a very, very important part of the High Court. It's a very, very important function of the High Court, because that is where serious cases are heard, and that is where we lay down precedents for the lower courts. And I can deal with it. I'm very comfortable with criminal law.
But Giuseppe complains that you sat only in one criminal trial.
Yes.
But they do say that it was a big one. How did things go there? Were you able to cope? Did things go comfortably for you?
Unqualifiedly, yes. Yes, I coped with it. I can deal with criminal trials. I've done them. I've done many of them. I've as a litigator, as a lawyer, I've in my early years of my practice, I've at one stage I was destined to become a very respected criminal lawyer. The magistrates all got to know me, and but it is not the path that I wanted to go down. I wanted to do other things.
Thank you very much, Mr. Hockey. I'm satisfied. Thank you, CJ.
Thank you, President. Thank you, President. You're excused, Mr. Hockey.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you, Mr. Hockey.
Good afternoon, Advocate Magonadano.
Good afternoon, CJ. Good afternoon to
How
the
are you, ma'am?
commissioners. I'm well, thank you, CJ. And how are you?
I'm very well, thank you. You hold, among other degrees, LLM labor law.
That's correct, CJ.
Did you get the opportunity to put the labor law to use in your practice?
Not as much as I thought I would, CJ. So it's good on paper, not much on practice. Probably just a handful of cases that I had to appear in labor court, the briefs.
Did you get to act in the labor court?
No, CJ.
Now, you were a prosecutor for some 8 years, am I right?
That's correct, CJ.
More, and have been a member of the Cape Bar for over 11 years.
That's correct, CJ.
How did you manage to get yourself admitted to the English bar, so to speak? Or am I confusing you with someone else?
How did I manage to get myself admitted?
Yes. Maybe I'm confusing you. No, I think I may be confusing. No, I'm confusing you with someone else. It's okay.
Probably.
Sorry,
You've acted as a judge, have you not?
Yes, I have, CJ.
For how long?
When I calculated, it is 25, just over 20 weeks, give or take. It's since 2015. Sorry, CJ?
Yes, ma'am. Please continue. I'm sorry.
Yes. Since 2015, I did a term, 2 terms. 2016, I did 3 terms. 2017, I did 2 terms. 2020, I did 2.5. So that's about 9.5 terms when I calculated, about just over 20 something weeks.
Was produced. Yes, carry on, ma'am. Please carry on.
No, I'm just saying my calculation may be wrong, so I mustn't be taken that it is law.
Sure. Was it ever a challenge to you to deliver a reserved judgment within 3 months?
Most of them I've delivered them within, but I've had a few Chief Justice, I must say, that have crossed by a week or 2 at times, and sometimes due to just work pressure or wanting to really form my decision properly. And yes, I think I've given also on my application some of those reserved judgments that were listed there. They are no longer reserved. I've delivered those judgments since between December and February this year. I can take you through the dates if that would be required.
No, you don't have to. Thank you, ma'am. Yes, but litigants never had to wait for 6 months or 1 year for your judgment.
No. Oh, no, CJ.
Well, just in passing and very quickly, many women advocates come and go. How did you survive? What advice would you give to those that are yet to join? What survival strategy, if any, would you give to those that are yet to join the bar?
It's hard. It can only be by grace, Chief Justice. But I have been so fortunate that I was vocal when there weren't any briefs coming my way. Since I'm a member of the BLA, as I've indicated in the application, I have, with a committee that I formed, I was part of, we've approached the State Attorney's Office, which is the biggest litigator in South Africa. So I've been vocal. I know a lot of people are vocal as well, but unfortunately they are not heard. Perhaps whilst we have the ministers and others here, perhaps something needs to be looked at as how there is a check and balancing system that really works to make sure that there is real work that goes to female advocates, especially female Black advocates, and that they are given an opportunity to really work with the work. So I've been fortunate. There has been ups and downs myself. I've cried with some of my colleagues who would come in my chambers, telling their story of how hard it is. Some have left the bar. It's not easy, Jason.
Is it fair to assume that even if you were to be appointed a judge, you would not abandon the cause of pleading or pushing for women practitioners, for Black practitioners to get work, quality work?
If this office of the CJ would allow me the judiciary, I certainly wouldn't. I think it is for us who are ahead not to forget the ones who are behind. That is me accepting that it would be a promotion if I would be appointed. It is of necessity that if one climbs up the ladder, you do look down and pull others up within the legal means. So I certainly wouldn't if I would be given that opportunity, certainly.
Thank you. Colleagues, let me have the names of those who have questions for the advocate.
Jenny Kane.
And Maya, after Commissioner King, CJ.
I've got you, President. Thank you.
King.
Schlemmer. Breitenbach, please, sir.
Honorable JP, over to you, sir.
Thank you very much, Chief Justice. Just as a point of correction, it is not this particular candidate who is a member of the English bar. It is...
Yeah, I noticed that. I noticed that. Thank you, JP. Thank you, sir.
Perhaps let me confirm that Ms. Magona is true. She has acted in the Western Cape for, I think, altogether 9 terms, or for a period just in excess of 9 terms. On each one of those occasions, I had invited her to act. And also, I would like to confirm that I know her. I consider her to be a friend and a sister to me. We have also interacted through other structures such as PLA, of which she is a member. Other than that, at this point in time, Chief Justice, I have no questions for this candidate. Thank you very much, sir.
Thank you very much, Judge President. Honorable Premier.
Thank you very much, Chief Justice. Advocate, welcome. Thank you very much for being here. And I think I'm going to just ask you, first of all, the separation of powers, and specifically asking you on whether you think that the system is working well within our Constitution, as opposed to perhaps some commentators saying that there seems to be almost creep between, say, the executive and the judiciary, or vice versa. What is your feeling on that?
Good afternoon, Premier. Thank you for the question. The system of separation of powers, in my view, I do think that it is working very well in our country. It is good that there is a checking and balancing of the powers of the various organs of the government. That is the legislature, executive, and the judiciary. I cannot say that there is any encroachment, and whenever there is any actions by one of the bodies, so to speak, it must be within the means of the law. The Constitution has to be respected. We have to make sure that the public perception is kept in the positive when they look towards these three spheres. So the separation of powers in this country is working very well. Thank you, Premier.
Thank you very much, Advocate. If I can follow up, I also read, and I must commend you on what I read about your community upliftment and your training of the next generation of lawyers. That's well done. But my question goes to a comment as raised here, and I'd like just to get some clarity to say that there could be an issue around indebtedness to SARS. Could you maybe give us an update on what that position is?
Oh, it's, the question that always asks you if you want to disclose anything. My understanding, I might have misinterpreted it. I thought perhaps I should mention I am under a payment plan, which is something that is legally allowed within terms of our law. That's where I am. And I thought to disclose that out of transparency and being honest to the commissioners.
Okay, thank you very much. I'm covered, Chief Justice.
Thank you very much, sir. Advocate KNSC.
Thank you, Chief Justice. Good afternoon. What I would like you to please deal with is the criticism from your colleagues at the Cape Bar, essentially, that you are still relatively junior and that there is a question mark about the quality of your judgments. They seem to have the view that you require more experience, preferably in practice, prior to taking a judicial appointment. Could you allow us to have your insights on that view?
Thank you, Commissioner, for that question. I must say, one must not, or at least I come from that point where I'm not saying I know it all. It is good to hear from the colleagues. I think this is an opportunity that allows one to grow. So the comments from the GCB are welcomed by me. Commissioner, I would say the issue about relatively junior, I need more experience. I am ready. I appreciate their views. The rest are positive from what I could gather. And others, they could not comment, which I would ask this commission to then accept them as positive. So most of their comments are good comments, and I appreciate them. I think my being a junior is to say I'm ready to being a justice. I've written judgments. When I calculated, Commissioner, it's about close to 180 of these judgments I've written. I've heard some that went to the SCA on leave to appeal, and I think I've attached some confirmed, and I will add when I'm given the opportunity that I was also advised by one of my colleagues, another judgment of mine where I granted leave to appeal that went to the SCA, which also confirmed. So I have two, one which was not. So there's something that I must be doing right. I'm not saying I know it all. I'm not saying my judgments are perfect, but it is the opportunity that the judiciary is given to us as Black females to expose us to these various subjects that we deal with in our judgments. That really just is like a breath of fresh air. And for me, I've given it my many years and I'm ready. I can learn anything else further within. I think the judiciary has the processes within it to empower people who need to be skilled, and I'm available to do that. I'm open to it.
Just to follow up on that, if you were not to be appointed at this stage and continued practicing as an advocate at the Cape Bar, would you continue to gain valuable experience there?
At the bar?
Yes.
Well, there are challenges at the bar currently. I don't think it is public knowledge with regards to Black female, as I've indicated before in briefs, that we comes in drips and drabs, really. So the experience would be there, but it's always focused. I'm more on civil cases, which I get, which I'm grateful for from the state attorney, a little bit of, so it would be a challenge. It wouldn't be the same exposure that I get within the judiciary, that I get to deal with the variety of issues. And I learned so much. I'm no longer the same. Whenever you read a case that you know it's issues that you've never dealt with during practice, your mind is stretched to a point that you will never be the same. So going back, it will be going back to the same old practice, dealing the same old cases, no other exposure.
Yes, that's of concern. Thank you, Chief Justice.
Thank you, ma'am.
CJ,
Thank you so much, Councillor.
CJ, may I follow up?
Honorable President, is there a follow-up?
Yes, CJ.
Yes, Commissioner Matolo Depu.
Thank you, CJ. Good morning, Ms. Mahano. I just wanted to find out from you, I mean, what my fellow commissioner is saying. If you go to the Cape, you are going to be, I mean, it won't make a difference because they're not giving you briefs.
Yes.
That's basically what you're saying.
That's what I'm saying. Yes,
actually, you're sending you back to hunger more than anything.
That's correct.
Okay, thank you.
That's correct, Commissioner.
Can I make a follow-up on that, Chief Justice?
Yes, sir.
Just on the issue of lack of experience, I just want you to share with us, because I realize that that you played a part in the process towards the matter that dealt with the dissolution of the Scorpion and the formation of the Hawks and the principles around the independence of the Hawks in this matter of Glenister versus the President of the Republic of South Africa, which you have mentioned as part of your reference.
Can you refer me to page?
They say that as a junior counsel, you also appeared in the following cases that let me just check on the.
Sorry. Yes. I'm not familiar now with the name of the case.
Sorry.
Are you not confusing me with
my apology. My apology. My apology, Chief Justice.
Thank you, sir. And the President.
Thank you, CJ. Good afternoon, Ms. Magona.
Good afternoon, President.
Are you related to the author Cindy Magona by any chance?
Yes, I am, President. She is my aunt.
Please tell her that I think she's a phenomenal woman and I'm a big, big fan. I have all her books.
I will certainly pass that message. If she's not watching right now, I'll certainly pass it to her.
I hope she is. You've been described as a kind person of integrity by the GCB, by the way. And speaking for myself, I think those are some, if not the most important qualities in any human being, especially a judge. But then there are these other concerns
yes,
about your technical competence, and I'm satisfied with the answer you've given.
Thank you.
But I just want to follow up on something that was raised by the Premier about your situation with SARS and the banks.
Thank you, ma'am.
The actual concern there is that you are seemingly financially unstable, and that may be, I think it's a valid concern which you should address. Being in a financially, palace situation is risky. A hungry man may do things that are out of character. A hungry woman may do things that are out of character just to survive. So the concern is that that situation, has the potential of compromising your judicial independence. Can you give us an undertaking here and now that that will not happen? We will not hear that you took a bribe under the table so that you could send your child to school or meet some financial obligation or the other.
Thank you, President, for that question.
If you are appointed, that is.
If yes, certainly. President, I am centered in God. In fact, I fear God, revere God. I have principles. I'm a principled woman with integrity, I've been blessed that wherever I walk, I don't think only of me. I represent females, Black females. I love this country. I love our constitution. I'm dedicated to upholding the flag of this country. So all of that can never be part of me, President. The circumstances I am in was just to be honest with this commission. But I've lived all my life honestly and with integrity. So I'm making that undertaking. You will never, not a single person will even try to approach me, because as I have been told by colleagues, it just comes out of me that no one will just come and try to even think of doing such things, approaching me to take bribes. I know you make an example, but it will never, that will never happen with me. Thank you for that question.
Thank you, Ms. Magona. Thank you, Chief Justice.
Thank you, President. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Advocate Magonia.
Good afternoon.
May I just find out if you have got my name is Madonsala. I seem to think I may have been before the president, and even before Tsape, but
I had missed you out, sir. You'll be last. I'm sorry.
Thank you.
Sorry about that, Commissioner Madonsala. I said good afternoon. I see that you list in item 10 matters that you regard as significant, an issue there, and then it's also included in our pack, the case of Bwania. I don't know if I'm pronouncing that or the B is silent. Yes. Bwania and the Master of the High Court.
Yes, sir.
Which is listed as a significant judgment of yours. And, you know, we come across these kind of matters sometimes in the various communities that we interact. Now, when I read that, I just felt, Honorable Advocate, you know, the court was really saved by the bell, if I may say so, because there was a last-minute agreement by most of the respondents and the applicant. And I was just wanting to ask, if that agreement didn't take place, what kind of judgment would you have given? Because this matter has now, the other aspects has been referred to the apex court, or you say some of these items that are contained in the ISA and the MSA are unconstitutional. So can you just take us through your reasonings for your judgment, and also the comment that I make that, you know, one was saved by the bell with the agreement? Thank you.
Commissioner, I appreciate the question. As a lawyer, the principle is when your matter is in front of a superior court, the apex court in this regard, you ought not to discuss it any further until that court has reached a decision. I would love to engage with regard to this judgment and for this commission to know where my thought was. I don't know if I'm answering you, but because it is still before the senior judges at the Constitutional Court, we are expecting a judgment. One cannot discuss it any further, especially come to think of a different view, which may just confuse even the members of the public who are waiting on this judgment. And at the same time, not to be seen as if I'm trying to influence further. I've written the judgment, and it is now before the honorable judges at the Constitutional Court. So one cannot take it again and say, let me see what I can redo. So it's based on that principle that I would respectfully request that I not be requested to make any further comments about the matter whilst it's still pending.
No, Advocate, I appreciate your position, because perhaps the Chief Justice will be sitting also considering this matter at some stage.
I think, if I recall as well, Commissioner, I think he is one of the judges. You might not, Chief Justice, you may correct me. He might be sitting in that matter.
All right, just to ask you outside of the case, but sort of related, you know, there is a concept, and you've quoted it there, and you've quoted another brother of yours, where he says the fact of living together is not the end all and the be all. Will you express a view on that? I mean, is there a time period for people to be living together with each other, for this principle of law to apply? You think you don't want to answer that as well, or just your view?
It's really crossing on the issues that were before that court, which I commented on. You probably are talking about common law marriages, which we don't have in South Africa. But again, it's issues which are in that case. So I would rather err on the side of caution and not extract certain aspects of that case and discuss it in the public sphere. Yeah.
No, thank you, Advocate. Chief Justice, we look forward to your court considering this matter, and then I can ask more questions. Thank you.
Thank you. For what it is worth, Advocate, I can tell you, we don't find it to be an easy matter either. Commissioner Tsepe.
Chief Justice Madonsela, I wanted to...
No, you are... No. Because I had missed you, Advocate. You'll come last.
I was saying that I was asking that you should remove my question related to the very same question.
Oh, I see. Okay, sir. Thank you so much. Commissioner Tsepe.
Thank you, CJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
My other question has been asked, so I'll just ask you only one question, and it's over and above the time you have spent acting as a judge in the Western Cape Division. What other adjudicative experience do you have that you believe is relevant for your work as a judge were you to be appointed, and why do you think so?
Thank you, Commissioner. I think in my CV or in the application form, I can't recall now, I've indicated that I am currently a commissioner in the Cape Town High Magistrates Court, appointed since about 2014. So there, as you know, you get to adjudicate matters in terms of the small claims court. I have sat as a chairperson in various labor law disciplinary matters. I think I've mentioned also that. I've also, I've also been invited by my university for a couple of times to sit as an acting moot court judge. So that's again an opportunity that I was given to use the skills and look at issues differently and approach it with the students. And you have members of the public at the small claims court, and you have a chairperson of an institution, I think it's the Office of the Sheriffs, where I had to decide on various disciplinary hearings that they had. I've also mentioned that. So it has given me much experience. It assisted me over the years. Yes.
Thank you, Advocate. Thank you, Chief Justice.
Follow up on this issue.
Thank you very much, Commissioner Tsepe.
Follow up on this issue,
Rob,
Chief Justice.
is there a voice?
Yes, Sigogo, Chief Justice.
Is there a follow-up, or should I simply list yourself?
It's a follow-up, Chief Justice.
Please go ahead.
Thank you. How are you doing, Advocate Magona?
Good afternoon, Commissioner Sigogo. I'm well, thank you. How are you?
I'm good. I thought when you are talking, you were talking about the issue of you sitting as a judge in moot court. You will as well indicate to this commission that you have sat in a similar situation in the United States of America, where you were judging for moot court. And fortunately, I was present in that session. Can you share with the commission?
Oh, yes, thank you. Thank you for reminding me, Commissioner Sikoko. We went as the delegates of the BLA to the USA, and the National Bar Association there invited me to form part of the moot court judges. We're a panel of 3, and we would have students from their high school. They were given a topic, various topics, and then they would come in and present their cases to us, just as similar as moot courts here in our country. So I was given that opportunity. I think I've also mentioned the details in my application, and it was just good as well. That's just stretched me because a different system of law, of course, language, but I enjoyed that and the opportunity that I was given.
Thank you, CJ.
Thank you, sir. Prof.
Thank you, CJ. To your right, ma'am.
Yes.
Good
yes.
afternoon.
Good afternoon.
Would you mind to share your judicial philosophy with the Commission?
Prof, I think one must be ready to dispense justice without fear, prejudice, and favor. That is our constitution. So that's my philosophy. Look at a case, not the parties, look at the issues. The term feeler, coincidentally, Prof, we were taught by our professor in UWC, facts, issues, law, and application. So you then apply that law without fear, prejudice, or any favor. That's my philosophy. And it's important, as busy as one can be, or a lot of matters you may be allocated, to try and expeditiously deliver that matter. And research, learn, read as much as you can, because you might be dealing with issues you may not know of, or receiving for the first time, but you learn, you eat it, so that you can understand exactly what you need to do at the end of the day to resolve the dispute or the issue just between the parties. That's my philosophy, Prof.
Thank you. And what role does your judgment play in the development of the law?
Prof, I hope it has, especially we are waiting for Puanya case. We are waiting for, each case will have to be judged by its own, the rulings that I've made on them. We have to, that they speak to the issues that come with that particular fact. So the role that it would play to the development of the law is, I am subjected to the Constitution. I would have to interpret and translate that judgment on the issues whilst I am being guided by the Constitution and the laws that are relevant to that particular case. If there needs to be a development, one will have to act on it, but the interpretation of the law is important and the application of it to the issues is important, Prof.
Thank you, CJ. I'm going to leave it there. Thank you.
Thank you, Prof. Honorable Breitenbach.
Thank you, Chief Justice. Good afternoon, Madam.
Good afternoon, Commissioner Breitenbach.
I have just one question for you. What are your views with regard to a judicial officer who has been found guilty of gross misconduct linked to underlying dishonesty continuing to sit on the bench?
I have no views, Commissioner Breitenbach.
Thank
currently.
you.
Are you done, Honorable Breitenbach?
Yes, thank you, sir.
Thank you very much. Advocate Magona Dano, thank you very much. I can't emphasize enough that Jane Branya matter is very complex for us. You really were grappling with difficult legal issues. You're excused.
Thank you so much, Chief Justice, and I thank you every commissioner and the president. Thank you.
Bye.
Colleagues, may we adjourn until 2:20.
Chief Justice, the candidate is ready and we are all here.
Thank you, Judge President. Thank you very much. Good afternoon, Advocate Manu Lockwood.
Good afternoon, Chief Justice. Advocate Manu
How are
Lockwood
you,
here.
ma'am? How are you?
I'm well, thank you, Chief Justice. How are you?
I'm very well, thank you.
Good afternoon also to the Honorable Commissioners this afternoon. Thank you for having me here.
Afternoon.
You have been, I'm missing my notes now. For how many years have you been a member of the bar?
It's been 15 years at the Cape Bar, Chief Justice.
And how much practical experience in all do you have?
I have had a considerable amount. I have been working in the legal profession. This is my 22nd year, Chief Justice. I've had a broad variety of exposure, training, experience. First, I started training as a candidate attorney, worked in a private law firm for 5 years. I worked as a candidate attorney and then as an attorney. That includes the 5 years includes the candidate attorney and attorneys. In that time, I had a very practical role. I appeared in the magistrates' courts, in the labor court. In those days, I used to brief counsel to appear in the High Court. I used to appear as well in quasi-judicial bodies, CCMA, bargaining councils, disciplinary proceedings. Then I took a year out and I trained as a pupil at the Cape Bar. And I started practicing, and as I said, I've been there for 15 years now. In that time at the bar.
Yeah. Well, I am particularly interested in your membership of the Honorable Society of the Middle Temple. How did you get there?
Yes.
And also the Bar of England and Wales. Just tell me, how did you get there? What is required? What does it mean?
In the UK, they do things differently from us. So how it came about, to answer your first question, is my husband and I had a personal tragedy. We lost our daughter. And after burying her, a few months after burying her, I needed rest from practice. He, at the same time, obtained an opportunity to go and work in Wales and assist some churches in Wales. However, his work opportunity did not have a defined time frame. We knew we were coming back to South Africa. So, for example, I sublet my chambers, knowing I was coming back. I just didn't know how long for. And I knew that when I was finished with resting, I would want to work, and I would only want to work at the bar. So I made inquiries in the UK about what it would take, and I was told I would have to write the bar exam, which is what I did. That's how that came about. And so in the UK, you write the bar exam. Only once you pass that, then you can apply to become a member of the bar, and you have to join an inn. That's how the Honorable Society of the Middle Temple comes in, and only thereafter may you undertake pupillage and then work as well. As I said in my application form, I didn't get to work in the UK because about a week before I got my results from the bar, and I passed, by the way, my husband's work was finished, and I knew we were coming back. And so I didn't practice in the UK, but in fact, I was admitted into that bar while I was acting in the Western Cape High Court already. I was admitted in absentia.
And you've acted as a judge here?
Correct.
For how long, more or less?
I've finished 2 terms. I'm now in my 3rd term, Chief Justice.
And was it ever a challenge for you to produce a judgment within the expected timeframes?
No, not at all, Chief Justice. The longest I've taken in producing a judgment is 7 weeks by my reckoning.
So you're ready, you would say. That's why you're here.
I'm ready, Chief Justice.
Now, just very quickly, the reports I have received, even from some women who are senior counsel, particularly black, where that is still very difficult to survive at the bar, at least for some of them. How did you manage to survive?
Life at the bar is hard for most people, but most especially for Black people, but most especially, if there's another category for most, for African women at the Cape Bar. There have been measures, positive measures taken towards transformation, certainly since I've arrived at the Cape Bar, but not nearly enough, and the numbers speak for themselves. Briefs-wise, most of my briefs come from the state attorney. We're talking 98, 99% of my briefs. The rest of the percentage comes from private firms who brief me about once every 3 years or so, or from law centers. Private firms remain reluctant to brief Black people, and especially African people, and most especially African females. The Cape Bar is not immune from our history in our country and the dynamics of the Western Cape. So there is racism at the Cape Bar. There is sexism at the Cape Bar. And for me as an African person, there's a trifecta of being an African person. I want to say there are people as well who take transformation seriously at the Cape Bar and have taken measures to try and assist, but they're in the minority. Despite that hostile and challenging environment, I have managed to get exposure to some good work, interesting work. And it's not consistently, but I have, and I'm grateful. And whenever I have done so, I have given it my all. I always say to the juniors at the Cape Bar, treat your next brief as if it's your last one. Let your work speak for you. As I said as well, the other reason I've managed to sustain a practice is early on in practice, I received assistance, some mentoring. There were people, as I say, who are serious about transformation. And mentoring, the biggest thing about it is just giving a person time. To juniors, people to whom I can just pick up the phone and ask that stupid question. And I had that in my early days of practice. It boils down to that, Chief Justice.
Thank you. Colleagues, may I have the names of those who have questions for the advocate, please?
Nyambi.
Hiya.
Muyimang CJ.
Tete.
Madonsela.
Breitenbach, please, Chief Justice.
Thank you.
Dodovu.
JP, over to you, sir.
Thank you very much, Chief Justice. Firstly, I would like to confirm that Advocate Mangu Lockwood has acted for 2 solid terms in the division. This is her 3rd term of acting. On each one of those stints, I invited her to come and act in the division. That I can confirm. Also, I can confirm that to the best of my knowledge, she doesn't have any reserve judgments now. If she does have them, they are less than 3 months old, right? And like the other candidate, I've known her for a long time. I consider her to be my younger sister, and I would like to declare that up front. Other than that, I have no questions for this candidate. Thank you very much, Chief Justice.
Thank you, Honorable JP. Honorable Premier.
Thank you very much, Chief Justice. Advocate, thank you very much for being here. And my first question is what I've been asking everybody today so far, and that is we have a constitution that I'm very proud of, and I'm sure we all are. Within that constitution, we have 3 separate spheres where we have an independent judiciary, we have the executive and the legislative. And my question is, do you think, in our young democracy, do you think that that is still working well? Is there sometimes judicial creep or executive creep across those lines? But I'd like to just hear your comments on our system at the moment, and that you think, is it robust enough? Should there be any changes? What are your opinions?
Yes, thank you, Commissioner. I think when we discuss the separation of powers question, we must always remind ourselves of where we come from. And we come from a system where there was parliamentary sovereignty, in terms of which Parliament was not accountable to anybody. So it makes sense then that the Constitution should provide checks and balances in terms of which different spheres may constitute checks and balances on the powers of others. On the question of whether it is working or not, I think it's early days. In the light of the context of where we come from, it is still early days. We have chosen a system that provides for constraint, judicial constraint. In other words, where the judiciary is tempted at times, perhaps, to usurp functions, to tell the executive what to do, to tell the legislature what to do, that would not pass constitutional muster. And we've seen that from the case law. Judicial overreach judicial overreach is not permissible. And judicial overreach is when the judiciary tries to usurp the functions of the other spheres. So my sense is it's early days to say whether it's working or not. And I also think, depending on where the nation is at, what's happening, you will find sometimes that there's a perception that one of the spheres is weak, in which instance then one of the other spheres will shine, will appear to be strong, but in a constitutionally permissible manner that is possible. And that's what we're seeing playing out. That would be my answer, Commissioner.
Thank you very much. If I may continue, I first of all want to say congratulations. I see that from your peers and all of the support that you've got, they all seem to be very positive support. So well done on that.
Thank you.
So I would like to ask you a question based on an earlier statement that you made and what you were saying around as a black woman in getting your briefs and not getting sufficient support. What would you say needs to be done to change that? How do we actually fix that as quickly as possible?
So I didn't get the last part. Did you say as quickly as possible? I don't know if I have an answer for that, because the problems we have are multi-laden, I think, and deep-seated, complex issues. I would imagine at the very least, we need to have frank dialogue in the profession. What does privilege mean for this profession? How can we use it positively for the benefit of the profession? Because there are barriers in the profession for people, which some people know nothing about. But the issues in the Western Cape must also be contextualized. The issues at the Cape Bar must be contextualized within the dynamics of the Western Cape. Because we know, for example, that universities graduate en masse from the Cape, from the Western Cape universities. But where do they go? They don't stay there. They go to Gauteng. They come here. And for the profession, we need to look at the statistics, and you will see in Joburg they're far ahead of us in terms of transformation. I know that the Joburg Bar is bigger than the Cape Bar by ×3, but still they have made greater strides, and somehow they've managed to make the Black professionals, African professionals, feel at home. I think practically, we need to look at a system that forces people to mentor people, because it boils down to briefs. We need people to be forced to recommend juniors and say, because every silk, for example, every silk has a stable base of clients, of attorneys. And we know that those attorneys will constantly ask the silk, who would you like to work with? Or who can we brief if you're not available? Those silks, they need to get, I'm making an example, maybe 5 people. And you say to that person, for this whole year, when you get asked who to recommend, you're going to recommend these people. You're going to bring these people into your kind of work. Because there are areas of work where you will never see a Black person involved. One only needs to go to the motion court in the Western Cape Division. I'll be dealing with 100-odd matters, and I will not see one single African person in court, in sight. We have serious problems in the Western Cape. So I think we're beyond the times of leaving things to institutions to deal with, because it hasn't worked. It hasn't worked. We now, how many years into democracy? And I can tell you from the statistics, we have in the Cape, Western Cape, in the Cape Bar, we have 16 African females. 16 African females. That's about 1 for every year that I've been there. And if you split the last person, because that's 16 people, I've been there for 15 years. So we have big problems in the Western Cape, and we have left it to the professions to regulate these kind of issues themselves. But in the Western Cape, it is far too slow. Transformation cannot wait for the Cape Bar to catch up with it. And there are measures, I don't want to be misunderstood, there are measures that have been taken. For example, in the Western Cape, now, since last year, people have to, silks have to declare how many juniors they've taken on board. At the end of each year, there's a certificate that they have to fill out and say, I shared fees with so many juniors, I have brought in juniors with so many people. That system is a great start, I think, because it's one of the mechanisms of forcing people to do these things. But I think it's the only thing that can work. Another area we do need to look into is private firms. How come private firms don't brief Black people? Why is that? There's no explanation after so many years. They say things like, we don't know who's there. Are you serious? We're in the digital age. You just go on Google. And our directory at the Cape Bar now has a transformation directly. You can literally only look at the directory that gives you African names or that gives you Black people. How can anyone say, I don't know who's there? So it's not acceptable. It's not acceptable. So if we were to take measures that, as you say, Commissioner, are urgent, we need to, I think, focus on those 2 aspects. Those are the only 2 things I can think of now. Forcing people to mentor, doing something about private firms. Thank you.
Thank you very much. Thank you for that answer. That's all from me. Thank you, CJ.
Thank you, Premier. Honorable Nyambi.
Thank you, CJ. Afternoon.
Good afternoon, Commissioner.
In front of us, I see a Black, female, knowledgeable person. Yet, in responding to the question from CJ, you explain the issue of racism and the manner in which you have treated at the Cape Bar. If you can expand on that so that we can make sense and understand out of your practical experience of that racism and the reception that you went through.
I'll give you one example. You said practical, Commissioner. Yes. I'll give you one example, which I consider to be a racist incident. This one actually involves the profession, not just the Cape Bar. This happened about 4 or 5 years ago. I'm in the labor court in Cape Town. I'm fully robed. I'm there to argue a motion. I can't remember if it was opposed or not. It's an application. Before the proceedings get underway, I'm in the courtroom. I'm consulting with my client and my attorney. And there are other practitioners in the courtroom as well. Word comes that the judge wants to see all the practitioners before the court roll gets underway. And somehow it happens that I'm the last person still sitting in the courtroom consulting with my client and my attorney. And the idea is that we're all going to leave the courtroom, go into the corridor, and then someone is going to come and collect us and take us all together to the judge. So I'm the last one who leaves the courtroom and to enter the corridor. And when I entered the corridor, there were about, let's say about 6 practitioners. They didn't know who I was. They were all white male. I recognized one of them. He's from one of the big firms in town. And without talking to one another, they start converging on me. They start walking towards me, and I start to realize what's going on. And I wait for them to get to me just to make sure. So I said, what? And these 2 young men, the ones closest to me, they said, oh, we thought you were the registrar. I think that's an assumption that when you see an African woman, even not if she's robed just like you, in the court corridors, for a person to just assume that this person doesn't belong, she can't be our colleague. That's how I took that incident.
My last question. In your own words, if you can share with us your understanding of the connection between democracy and the rule of law.
The rule of law is one of our foundational principles in Section 1 of the Constitution. In layman terms, what it means is no one is above the law in our country. What it means is all conduct, all exercise of power must comply with the law. And that's it. And the connection to democracy must be obvious because in our Constitution, the Constitution itself says the Constitution is the supreme law of the Republic. And so there is an obvious connection between accounting for power, which is democracy, accounting for power, and accounting to the law.
Thank you.
Thank you, Commissioner.
Thank you, CJ.
Thank you, Honorable Nyambi. The President herself.
CJ. Good afternoon, Ms. Manu Lockwood.
Good afternoon, Commissioner.
I'm sorry about your daughter. To get to business, I'm listening to you tell the sad tale of a Black female practitioner at the bar, and I'm thinking to myself, my goodness, this is exactly what I experienced back in the day, in the 90s, when I was still in practice. Yeah. And we are still talking about this now. Here we have you, a clearly competent lawyer, but you are not getting, the recognition you deserve. Can I ask you this? Are you not tired of being asked what can be done so that you get briefs? Because I am. Should women still be asked what measures should be implemented so that the discrimination against them stops? Is that a fair question? Does it make sense to you?
I don't think it's completely unfair. It is exhausting, let me put it that way, but it's not completely unfair because we also need to contribute to the solutions from the perspective of our own experiences. The solutions need to meet the problems that we do highlight, and they need to hit them on the spot and not be on the periphery. So I do understand, from that point of view, I do understand the question. But yes, it's exhausting to still be talking about these things in 2021. It's so 90s, as you say, President.
Yeah, I'm sorry, you'll forgive me my exasperation, but I think it's unfair to be asked that, because this question has been asked over and over and over and over, and we've given all these answers. What you just said now is nothing new. It's been said a zillion times before, but the question is still asked and nothing is happening to remedy the situation. But that said, Ms. Mano, I just, why have you not taken silk? Or is the answer obvious?
Maybe it is obvious to you, but for me, once I acted, Commissioner, once I'd acted, I didn't want it. I wanted to come to the bench. Once I acted, I knew, I clicked in, and I just knew this was a calling I needed to answer to. So I went back to my practice. It was just a matter of time, I should say, after I'd acted the first time. I went back to practice thinking, when should I go apply to go to the bench? I could go later. I didn't have a plan about it, but I went back to practice, and every month I was thinking, I was reviewing my decision not to be making myself available to act. And I knew that I had moved on. Something in me had shifted. And so in that context, it didn't make sense to apply for silk. I don't need silk to go to the bench. That's my answer.
True that. Well,
true that.
No, it makes perfect sense, and actually it resonates, because the same thing happened to me, and incidentally, I went to act in that very division, the Cape High Court, and the bug bit, and I never went back to practice. Just one concern I have. I want you to tell me a little bit about Olive Trust, which you have declared you would not be keen to abandon, at least in its infancy.
Yes. The Olive
First, what is it about?
The Olive Trust is a trust that I started thinking about even last year. It was actually as a response to COVID. And when I heard that the schools were closing down, I started thinking about Ginsberg, where I come from, Ginsberg, Ekonge, Eastern Cape. And I I
grew up there.
All right.
Where in Zwelitsha.
Oh, yes. And when I started hearing schools are going virtual, and I thought, Ginsberg, I can't picture that happening. Schools don't have computers in Ginsberg. So that's how this thing started. And I thought, what can I do for Ginsberg? And I traveled as soon as I could travel after level 5 restrictions. I traveled to the Eastern Cape. I met up with some school principals. And the first thing I thought I'm able to do is to raise funding and provide some kind of scholarship for the kids, for some of the kids, bring out the strongest kids academically, and award a scholarship for them to go to a school that I also got to go to in town, Ekonge. And in order to do that, the plan is to put my own money in, but also to raise funding so that we can take more kids and undertake more efforts, educational efforts for specifically for Ginsberg. So that's why it was started. Unfortunately, because of COVID, there were a lot of delays. So the registration of the trust was actually only effected this year in January. And we've had more delays. One of the school principals I spoke to unfortunately passed away. One of the teachers I was dealing with there, she lost her father, then she lost her brother. So we have incurred a lot of delays, but it is a project that's very close to my heart, and which is the reason in my form I have said I would like to continue with it. I wouldn't be receiving any remuneration for it. It's purely to raise funding to assist the kids. Thank you, President, Commissioner.
Okay, and here's my concern. Who is or are the trustees? Because I'm thinking of a situation where, Lord forbid, the trust would have to litigate. It happens, and here you are a judge smack bang in the heart of that litigation.
I see. The trustees are here. The work of the trust would be in the Eastern Cape, but the trustees, I'm one of the trustees. The trustees are in, sorry, when I say here, I'm in the Western Cape. Sorry, we in Gauteng now. The trustees are based in the Western Cape, and I'm one of them. But the work of the trust would be in the Eastern Cape, which is why I thought there wouldn't be any issues. But if the Commission feels that there would be serious problems, it will break my heart, but we haven't gone very far. I would have to reconsider the decision.
All right. Thank you very much, Ms. Mangu. Thank you, CJ.
Follow up, Chief Justice.
Yes, Commissioner Singh.
Yeah, thank you very much, Ms. Mangu. I can see that this trust is very close, near and dear to your heart, and very noble intentions. Will it not be possible for you to get others to continue this good work whilst you still give it moral support and other financial support as well?
Yes, absolutely. I take that counsel, and I think I might well have to do that. I mean, you're right. You're right. I could still be involved from the sidelines, as it were.
No, thank you very much. And Chief Justice, will that be allowed? Just to ask the Chief Justice. If somebody is on the sidelines, a judge supporting, moral support, financial support,
she must just share the vision with somebody with someone, make sure that the person understands the vision well and step out completely. Her role can be to contribute money, but not expose herself to the possibility of somebody contributing to the trust and then turning around and saying, when he or she has a kid, I'm the one who contributed so much to the trust. So there could be potential conflict there. Just explain the vision clearly and step aside and just donate. Don't get involved in the running of this thing. It could compromise you.
Thank you, Chief Justice.
Chief Justice, the other thing is I'm very pleased to note that under memberships, Ms. Mangu used to be a director of an organization called Dangerous Football Association, and it's no longer in existence. Well, I don't know why it was called Dangerous Football Association. Thank you.
Thank you. Honorable Muimang.
Thank you, Chief Justice. Good afternoon, Mangu Lockwood.
Good afternoon, Commissioner.
Yeah,
yes, I see you.
In your questionnaire, you may I think it's on page 18, 19 of book 2 those books that are sitting next to you.
Right.
Yeah, book 2 of book 2, page 18 and 19.
Yes.
You indicate that you appeared in a number of cases. One of them is the NISTA.
Yes.
President versus the President of the Republic of South Africa. From your reflection, do you think the current structure of the Hawks reflects the thrust of the issues that you were canvassing as part of the teams, right from disestablishing the Scorpion and right up to the formation of the Hawks? Thank you.
Do I think the current structure of the Hawks, is what? Sorry, Commissioner, I didn't get the point.
Do you think that the progress thus far that we have made with regard to strengthening the Hawks mirrors the thrust of the issues that you were canvassing in that case?
It's a tough one because I don't know the inner workings, the current workings of the Hawks, and I don't really want to comment on whether their structure works or not, because one day a matter involving the Hawks may well come to me, and someone might be challenging that, and I would have to determine whether or not it's constitutionally compliant or complies with the rule of law. But as I'm sure you know, in Glenister, we never got to see the light of day in the team that you're mentioning, that I was part of, because, as you know, the Constitutional Court didn't really want to engage on those issues of the Constitution, the complement of the Scorpions vis-a-vis the SAPs, and the issue there became separation of powers, and the court said it's not up to us to intervene at this stage. The court decided to respect separation of powers there, as you know, as well. So those issues, they weren't actually well canvassed in that case, which is why I can't answer fully. I can't answer your question fully for that reason.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner.
Chief Justice JP Mlambo here. I've got a follow-up to
Thank you so much.
the question.
Is there a follow-up, JP?
Not to this question, CJ, but to the one by Commissioner Nyambi, but I'm prepared to wait my turn and raise the issue.
Okay, sir. Okay, all right. Commissioner Tsepe?
Thank you, CJ. Good afternoon, Advocate Mangu Lockwood.
Good afternoon, Commissioner.
CJ, may I declare now that I know Advocate Mangu Lockwood. I feel very old. When I was in the managing the firm, or in the management committee of the firm, Cheadle, Thompson and Haysom, she was a candidate attorney at the time. And so the firm, she did very well when she was at the firm. I just thought I should declare that.
Thank you, Commissioner.
I just wanted to find out from you, what other adjudicative roles have you played other than acting as a judge at the High Court, which in your view would help you fulfill your role as a judge were you to be appointed?
Thank you, Commissioner. I have, over the years, I've presided as chairperson over mediation proceedings, over arbitration proceedings, over disciplinary proceedings as well. I've also sat as an assessor in some long-running criminal trials, which, although they're not adjudicative, but at least the role is to assist the judge in the High Court, that was.
Thank you. Thank you, CJ.
Thank you, Commissioner.
Thank you so much, man. Prof?
Thank you, CJ. Good afternoon, ma'am.
Good afternoon, Commissioner.
Would you mind sharing your judicial philosophy with the Commission?
Judicial philosophy. You know, at university, they told us all about judicial philosophy. Conservatism, you can come to the bench as a conservative, you can come as a judicial activist, constructionist, whatever view you want to take. Ultimately, the Constitution tells us to comply with the Constitution and rule of law. That becomes the philosophy when you come to the bench. So I can't take it further than that. I acknowledge that we all come to the bench from all walks of life, having had all sorts of experiences, coming with our values and worldviews. But when we get there, the Constitution is the barometer for all of us. Rule of law, barometer for all of us. As activist as I want to be as a judicial officer, the Constitution and the rule of law, they limit my ability to do that. In other words, I must walk that fine line, no matter what it is that I believe in. So I believe there's a new judicial philosophy in town. That's the Constitution and the rule of law.
Thank you, ma'am. Thank you, Chief Justice.
CJ, follow up.
Thank you. Is that Honorable Malema?
Yes.
Go ahead, sir.
Advocate, she asked you about your own judicial philosophy. Please give us that. Your own.
My own?
As you sit there on the bench, what informs your judicial philosophy? That's what she's asking you about, not what they taught you at school. Your own.
Thank you, Commissioner. My own philosophy is that when a judicial officer presides over a matter, they must apply the Constitution. When we develop Section 39 sub 2, when we develop the law, common law, when we develop the customary law, when interpreting any legislation, we must do it in a manner that promotes the spirit, purport, and objects of the Bill of Rights. That's my philosophy. That's what I follow.
Thank you, CJ.
Thank you. Thank you. Advocate Madonsela.
Thank you, Chief Justice. Advocate Manu Lockwood, good afternoon.
Good afternoon, Commissioner.
In your earlier explanation of your background and where you come from, it appears to me that you or your husband are very much involved in the church. And if I'm correct on that premise, I just want to find out if your husband's involvement in the church or yours, is it ecclesiastical or merely evangelistical?
It's a tough one to explain because, you know, when we went to Wales, for example, I refer to that example. My husband went to assist the Presbyterian Church in Wales. And we've also attended evangelical churches as well. It's very difficult to confine us to either or. We believe in Christian values. We believe in many churches forming one church. That's the difficulty I'm having with the question.
Yeah. Now, but let me just put it this way: in South Africa now, you're back.
Yes.
In Cape Town, where you are.
Yes.
Are you still highly involved in the church administration?
Yes, we belong to a church. That's right.
I mean, are you at the helm of the church administration? Are you involved?
Yes,
in
I'm very involved in church. Yes.
Now, I asked because where I come from,
yes,
in KZN, one of the things that an advocate gets baptized into when he is a practitioner are actually church disputes.
Sorry, church?
Church disputes. You know,
right.
You know, the churches go to court.
Yes.
On a very regular basis.
Mm.
And in those cases, churches seem not to let go when they fight. Church members don't let go when they fight with each other and they go to court, and those cases go to court all over the country. I mean, one of them is in the Constitutional Court, as we speak, from my division. So I just want to find out is that not a potential problem that might arise? Don't you think it will arise? What do you think about it?
I haven't thought conflict might arise simply because I'm a church-going person, and a matter
no, not from that perspective. From the perspective that a matter might come, or a dispute might arise, and how you do deal with it if it arises.
Well, I mean, if, for example, a matter came involving a church that I have been involved with or I am involved with, then I'd clearly have to recuse myself, because a judicial officer has to recuse themselves if there is a perceived or actual conflict of interest, or if there's a reasonable suspicion of bias based on objective facts. And one must always apply those kind of principles. beyond that, I wouldn't just recuse myself because a matter involved church-going people.
No, my second question has been covered by Commissioner Singh. It had to do with the Dangerous Football Association as well. I must say on this note that I've just recently moved my support from Kaizer Chiefs to Amazulu Football Club because of dangerous footballing. Thank you.
Well done.
Thank you, Chief Justice.
Thank you, Commissioner.
Thank you, sir. Honorable Breitenbach.
Justice, did you forget about me?
Oh,
Thank you, Chief Justice.
Whose voice was it?
Magwanisha.
Oh, I didn't even have you. Sorry, Honorable Magwanisha. Go ahead, Honorable Breitenbach.
I'm happy to let the Honorable Magwanisha go ahead of me.
Oh, go ahead, Honorable Magwanisha.
Thank you very much, Honorable Breitenbach. Thank you very much, CJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
I would like to go back to 2002 to 2004.
Right.
You say one of your duties was to brief counsels for
Yes.
both the Labour Court and the High Court.
Yes. When I was an attorney,
Yes.
which was 2020,
Yes,
some appearances I made myself, but yes, I briefed counsel to go to the High Court and the Labour Court.
Yes. How many women and black advocates did you brief?
I don't know how many, but I can tell you that most of the people I did get to brief were, at that stage, there were female colored people. There were no African females when I was an attorney at the Cape Bar.
That's fine. My second one, because I think we must be fast. My second one, since you are now at the bar, and the MD of your former firm has said that you are a very good candidate attorney, have you received any work consistently from the firm?
From her firm.
Chidl, Thompson, and Hayson. I have since resigned.
That's a good answer because
the question still stands.
My answer is mostly not. Mostly not. When I came to the bar, I did hope I'd receive a lot of work from them. I didn't. They did start briefing me later on, but later on, I mean maybe 4th, 5th year. But I did hope they would brief me, but I also knew the reality of that practice, of that firm at least, because they were a specialist firm and they tended to do most of the work themselves. So they only briefed when there was no capacity within the firm. And if they did do brief, they would only brief senior people. So I did hope for briefs from them, but realistically speaking, I didn't think it would happen. And indeed, it hardly did happen.
Thank you. My last one, did you find the English bar to be difficult when you wrote the exams?
Oh, the exam itself, I didn't. The hardest thing about that exam was that I was in my 40s when I wrote it. And I can tell you, my brain was not interested in the detail of being a law student again. But in terms of the content, I wasn't intimidated by it. It wasn't more intimidating than the bar in South Africa, for example. The hardest thing was that. Thank you.
Very much. Thank you very much, CJ. Thank you, Honorable Breitenbach.
Thank you, sir. Honorable Breitenbach.
Thank you, Chief Justice. Good afternoon, Madam.
Good afternoon, Commissioner.
I haven't looked at how old you are, and if you say you were in your 40s when you wrote that exam, it must obviously mean you're older than 40 now, but you look around 30, so I'm having trouble with that concept. You did your articles at Cheadle, Thompson, and Haysom, which is a pretty good place to be. I presume there you learned very quickly to speak truth to power.
Yes, you may presume so. Yes, thank you.
My question is this: in South Africa, our constitution is paramount, and we must give effect to it. So, what are your views with regard to a judicial officer who has been found guilty of gross misconduct linked to underlying dishonesty, continuing to sit on the bench?
Sorry, I didn't get all of that. What are my views on
with regard to a judicial officer who has been found guilty of gross misconduct
right,
linked to underlying dishonesty, continuing to sit on the bench?
as far as I understand the process, what's happened so far is a recommendation has been made. And this commission...
May I interrupt you? I'm very, very sorry. May I interrupt you? I'm sorry. It's not a question about the Judge President of the Western Cape. It's a general question. What is your view with regards to a judicial officer who has been found guilty of gross misconduct linked to underlying dishonesty, continuing to sit on the bench? Any judicial officer, any conviction, any bench.
Well, it's relevant what stage the process is at.
Yes.
Because in terms of our system, the tribunal makes a recommendation and the commission must still choose whether or not it approves it. And even then, a constitutional process of impeachment must be followed in terms of 177 of the Constitution. And so, depending on where you are in the process, just because there's a recommendation that says a person has been found of gross misconduct, it doesn't mean the person must stop sitting, because what if the commission does not approve the recommendation? What if the charges are not upheld? So it depends where the process is at. If we were at a stage where the National Assembly had now exhausted its processes, in terms of the Constitution, that's the end of the process. But even then, there may well be court processes, I don't know. So early days before, well, sorry, I keep going back to specifics, but you saying that it's a theoretical question. The answer surely must be that it depends where the process is at, because the other thing to consider is we have their rights to dignity for people. Even judicial officers have right to human dignity. There are also rights to fair processes as well. So we need to let the processes unfold to their conclusion. That's in terms of the Constitution.
Thank you. It's probably a better answer than anyone else has given this far. But my question remains, should they continue to sit on the bench while this process unfolds? What is the purpose of suspension?
Well, it's not, I mean, has the person been suspended?
No.
Because, I mean, surely that would play a role. If the person were suspended and they continued to sit on the bench, then we might have to have a discussion about that.
No, that's not the question, and I know you're smart enough to know that. What is the purpose of suspension?
Sorry, then I think I'm missing your question, because I thought you were asking me, should a person continue to sit on the bench if there are findings of gross misconduct against them?
Yes, that is the question, and you've answered it.
Yeah.
My second question is, what would be the purpose of the process of suspension, given your answer?
What would be the purpose of suspension?
The process of suspension, given your answer.
The process of suspension is also up to the commission and then the minister, as I understand it. And the minister may decide to suspend. That's also in terms of the Constitution. The purpose is the process.
Thank you.
CJ, can I make a follow-up because this question has been troubling us here?
Please do so.
Now, advocate, in a democratic society and a country where people claim to uphold the constitution when it favors them, and when confronted with difficult questions like the one you were asked about earlier on, what becomes the most acceptable solution? Is it political expediency or a due process?
In an instance where
That question they asked you.
this last one,
No, the first question, where they say a person in the bench has been found guilty of a gross misconduct, right? And we become so excited that the person has been found guilty. What needs to be followed? Is it a political expediency or a due process? And if it's a due process, what does the due process include?
I would say due process.
Yeah.
And that is in terms of the process, the Act, the JSC Act, and in terms of the Constitution. And as I said earlier on, as I understand the process, the next step is that the Commission must decide whether or not it's upholding that recommendation. That's a due process issue, not political expediency. And then the next thing is the National Assembly process. Now, it may well be argued that that part of the process is political because politicians must vote on that. Maybe the answer is both, Commissioner, that there's due process and then politics at that point. I don't know if I'm...
No, I agree. Politics will come.
Right.
Now, what does it do to our democracy when a due process is not followed? So when people are found guilty of a gross misconduct, and for political expediency, we don't follow the due process, what will that do to our democracy? Where there's no due process, we act out of the feelings of a certain quarters of society. What does it do to the rule of law? What does it do to the right to dignity? What does it do to the Constitution itself, which encourages the due process?
It does violence to those things. And I think it would probably, if those were the circumstances, someone might well run to court and say, force them to follow due process. But until that happens, as long as the processes are being followed, there's no reason on which to get excited that someone should be taken out the process.
Absolutely. There's no need for excitement. Thank you.
Chief Justice, it's Madonsela, it's a follow-up. I just want to say that the reality of the questions which come from Commissioner Brettenbach, which have...
Is there a question, Advocate Madonsela, or is it a comment?
It's a comment followed by a question.
Let's just try to put questions to her.
Follow-up question?
It's a...
Put your question, sir. Put your question, Advocate Madonsela. I'm trying to avoid a situation where you make a statement and she now feel that it's necessary for her to make a statement. Just put your question, even if it challenges what she said, but at least let it be a question that the candidate can answer.
Is it correct for a commissioner in the Judicial Service Commission who may very well be a decision maker on the findings of about a judicial officer to postulate a situation in which a decision he or she may make in a matter which will come before him or her to say, to preempt that outcome. Would it be correct to do that?
I think I lost concentration early on in your question. There's so much theory in it. Please ask it again. I'm
Well,
really
I think
sorry.
we're talking in parables in this
Yes.
in this commission. That's a problem.
So if you don't mind,
Is it correct for a commissioner
yes.
who might ultimately be seized with the findings of a disciplinary committee
Yes.
concerning a judicial officer to postulate an outcome that might very well be reached by him or her when he ultimately considers the matter?
The question, I see. I'm sure commissioners are allowed to express themselves. Whether or not those, how they're going to decide in due course is communicated beforehand. Is that necessarily wrong? I don't know. That's up to this commission's rules of conducting themselves.
That not be tantamount to prejudging the matter.
Yes, it definitely is that. But I wonder if the commission's processes don't allow for a person to change their mind as the process unfolds. In other words, we might be getting a certain question today at the interviews, but when the commission eventually sits, a person might well have changed their minds. So it's difficult for me to say now that the person has an opinion. It's very similar to court. You start proceedings and you've got a prima facie view of the matter, but as it unfolds, well, you've changed your mind. The difference is the person has made it, is quite emphatic about which route they might take. Well, the commission might want to take a view on that.
Thank you, Chief Justice.
Thanks.
Thank you very much, sir. Was there someone who wanted a follow-up, or may I proceed?
Yes, Chief Justice.
Was it Honorable Moimang? I couldn't make out who it was.
Sir Xaba was following on
Okay.
Commissioner
Yes,
Maleba's question.
yes, Honorable Xaba.
Is it your position that political expediency that does not follow due legal process violates the principle all is equal before the law?
It might well do. That's my answer.
Thank you.
Honorable Dodovu.
Thank you. Thank you very much, Chief Justice. Advocate.
Good afternoon, Commissioner.
Good. Very, very quick. And my question is going to be a metaphor. Have you ever seen two elephants fighting?
I think only on video, not live.
Yes. They fight.
Right.
What do you think happens when the two elephants fight?
Dust, chaos.
Yes, there is a proverb that says where two elephants fight, the grass suffers.
Oh, yes, that's right. Yes.
In your case, what will you do if you can see two elephants fighting?
Run.
Now, in this case, I follow this matter quite differently. Therefore, based on what you say, is it fair for legal practitioners to be dragged into a matter that is not theirs? In that sense, for example, where two elephants are fighting, or where two individuals are fighting, or whether affections or what?
Commissioner Dodovu, I'm sorry to interrupt you, sir.
Yes.
Please pardon me.
Okay.
Just in line with our agreement and undertaking and the mandate you've given me to interrupt all of you
No problem.
without feeling embarrassed. Please test their suitability, sir.
Yes. Yes, it's okay. My question is, in case that there are two people or two groups or two factions fighting, is it fair to drag other people who are not part of that fight?
No, it's not fair, Commissioner.
Okay, thank you very much. Thank
Thank
you,
you.
CJ.
Thank you.
Thank you, Honorable Dodovu. Honorable JP Mlambo.
Thank you, Chief Justice. Advocate Mangolo, good afternoon.
Good afternoon.
This
JP.
is in response to, or a follow-up to the questions by Commissioner Nyambi. It's just to test your resilience as a judicial officer since you applying for that position. You've described that incident in the labor court, but have you, sitting as an acting judge, encountered problems of an attitudinal nature from people who are your seniors at the bar, just appearing before you as a junior judge? And let me give you an example. One incident where a judge was allocated to a matter became unavailable.
Right.
The matter was allocated to another judge who happens to be female and black. Counsel came to introduce themselves, saw her, greeted, said nothing, went back to court. When she got to court, they said, Judge, you'll be pleased to know that we've agreed to go to mediation. So I'm just giving you that background to understand whether you've had incidents like that, either sitting, presiding, and getting negative vibes towards you by people who are your seniors, and how you dealt with that. That's all I'm asking.
Personally, no, Commissioner. I mean, I had one matter in which I thought there were two silks on either side, and the matter was quite heightened. You know, it was urgent, and they were fighting about everything, even about whether to come and see me. You know, I found the behavior of the one counsel in particular to be quite insolent, but he was insolent to everyone, so I didn't take it personally. But I have heard of incidents of people deciding to take matters to arbitration, for example, because an African judicial officer has been appointed to preside over the matter. I've heard of incidents of parties, disrespecting female Africans and females on the bench as well. But me personally, no.
Thank you, Chief Justice.
Thank you, Judge President. As we part, Advocate Mango, you seem to be enjoying this interview. Just make notes so that you can include it in your biography. You're excused.
Thank you, Chief Justice. Thank you, Commissioners. I will do. Thank you.
Thank you very much, Judge President. Good afternoon, Mr. Tulare.
Good afternoon, Chief Justice, and to the commissioners.
How are you, sir?
As best as I can be under the circumstances, Chief Justice.
Well, let me help you settle down. You've got to be comfortable.
Thank you.
I noticed that not long after acquiring your BUris and LLB degree, as I asked you last time, you pursued a Master of Laws degree.
That is correct, Chief Justice.
Man, you seem to be full of energy. Why didn't you pursue LLD or PhD at the time?
I started a family in the meantime, and priorities changed. But now I am busy with my LLD, Chief Justice.
Which university did you register with?
I did my proposal with UNISA, and now that I'm in the Western Cape, I decided to join what they call the Bush, the University of the Western Cape. I'm a registered LLD student there.
When did you do so?
I did my proposal in 2019, and I moved, in the course of last year, I moved to UWC.
Wow, I envy you because I did my proposal. I registered, I think it was 1990, 1991, and dropped out. And I gave myself an excuse that I was too busy in private practice to focus on a doctoral degree. And you've been a judicial officer for many years. Can you tell us how many years?
It's 20 years.
Is it 21 years or more than that?
I'm in my 21st year as a judicial officer, Chief Justice.
Yeah. Oh, I thought it was slightly more than 21 years.
I was appointed in 2000, although I started in 1999.
Okay,
I was appointed
I was
as a
counting
magistrate.
from 19.
I was
Yes,
appointed a
carry on,
magistrate
sir.
for, I'm sorry, Chief Justice. I was appointed a
No.
magistrate for Johannesburg in 2000.
Oh, I was looking at this 1999. That's the judiciary magistrate 1999. I counted from there, so I'm not too far from the mark.
Yes, in 1999, I'm sorry.
Yes.
In
No, carry
1999,
on.
I started acting. It was at that time where you did the probation first before you got permanently appointed Chief Justice.
Okay. Oh, yes. And you've been the chief magistrate since 2016 up until now.
That is correct, Chief Justice.
And you've acted as a judge in the Western Cape Division of the High Court. Am I right?
Yes, I started in Johannesburg, Chief Justice, in
Yes.
Gauteng province.
Yes, yes. And have you had any problem in producing a sound judgment within 3 months?
Up until this point, there's only one judgment that took me more than 3 months, Chief Justice, and it was because of the complexity of the judgment. But generally, within 6 weeks, I deliver my judgments.
And is it fair to assume that you made sure that you have the permission of the judge president to take longer? You didn't just sit back.
Yes, I discussed it with him, Chief Justice.
Yes, yes. And very well, I think I'll stop there. And thank you very much, Mr. Tulare. Colleagues, let me have the names of those who have questions for Chief Magistrate Tulare. Well, maybe while they are thinking, what is your doctorate? What is the thesis intended to be on for your doctoral program?
The determination in discovery of future maintenance orders.
Okay. Are you planning to provide some guidelines as to how our maintenance system could in the process be restructured in such a way as to inject more efficiency into it?
That is correct, Chief Justice, both in terms
Thank
of
you.
process and in terms of substance.
Yes. Thank you. Are there colleagues who have questions for Mr. Tulare? Thank you. There were two voices. I couldn't make it out. I couldn't make out.
I think, Chief Justice, you can take Breitenbach first and then Singh.
Tepe.
Lamola,
Schlemmer,
Matonsela,
Penny Kane,
Mlambo JP,
Maya,
Malema,
Honorable JP Fabe, who's next?
Malema.
Mwema? Honorable Mwema?
Malema,
Or is
Malema.
that Malema?
Yes.
Thank you. Honorable JP, over to you, sir.
Thank you very much, Chief Justice. Excuse me. Thank you very much, Chief Justice. May I also place on record that I've known Mr. Tulare since his appointment as a Chief Magistrate, and that was in 2016 when we met. Mr. Tulare, just remind me, you have acted in Cape Town. How many terms altogether in the Western Cape High Court?
It was the last term of 2017.
Yes.
All the terms of 2018, the last two terms of 2019, and the first term of 2020.
So that's a total of 8 terms, am I right?
That is correct,
Eight
Judge
terms.
President.
Right. May I also confirm for the record that Mr. Tulare, when he acted, he did not reserve judgments for an unduly long time. And the judgment that he is talking about, I think he reserved it for about 4 months or so, Mr. Tulare.
That is correct, Chief Justice. JP.
And indeed, he did discuss that with me. Other than that, I have no questions for this particular candidate. Thank you very much.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice, and good afternoon. Advocate Tulare, sorry, it's Magistrate Tulare or Mr. Tulare.
Mr. Tulare suits me
Mr.
fine.
Tulare.
I am an admitted advocate of the High Court, by the way, but Mr. Tulare suits me fine.
Or Advocate Tulare, thank you very much. And good afternoon.
Good afternoon.
I think my first question, as I've asked to everybody, I'm a proud South African. I think that we have an amazing constitution. But of course, I'm a politician and I sit in one of the separate spheres where we have separation of powers. And my question to everybody has been, in our young democracy, and specifically when you get questions of perhaps where you see mandate creep between spheres. So perhaps executive powers may be trying to influence perhaps judicial, or the judiciary trying to overstep the mark in these separations. What would your comment be to that? How do you think we are faring at the moment, and do you think there are any risks in the system?
We are a great nation. I have the privilege of participating in the structures of the judiciaries in Africa and in the world. The tension between the three spheres of government is a normal tension, and it is a necessary tension most of the time. What makes us great is that whenever there is tension, it has never flared up into open conflict because of the greatness that we are. So we are a good constitutional democracy, and we are in our space. Thank you.
Thank you very much. I think, Chief Justice, in the interest of time, I will stand by that question. Thank you.
Thank you very much, sir. Honorable Nyambi.
Thank you, CJ. Afternoon, Advocate Tulare.
Good afternoon, Commissioner.
The inspiring story of being just a general manager in South African breweries and being a chief magistrate today, acting in the High Court. How has that journey prepared you for the position you are being interviewed today?
Yeah, just to correct, At the South African breweries, I was a general laborer. I
know.
was a grade 1.
Yeah.
And that is the guy that when you see a brewery truck standing opposite the entrance to a bottle store, that you see pushing that trolley with whatever merchandise from the breweries into it. So I know how to receive a box and pack it on a trolley and push it in. So that's where I come from. It is amongst others that labor that caused me to reflect. I'm born to a domestic worker and a gardener. I was a trolley pusher. Is that the line that and the legacy that I want to leave for my family? And that's what caused me to persevere. I never went to university full time. I registered with UNISA. I did both my BURIS, my LLB, and my LLM whilst working during the day and studying at night. So I don't know the benefit of sitting in a lecture room with a university professor teaching you. And that has helped me a lot. Coming back to the space where I am, it has taught me the art of formulating, basically researching, seeking the material myself, and working on it and preparing it into a cogent argument, initially whilst in prosecution and subsequently to write judgments as a judge. So working during the day and night, which is the work of a judge, it's not something that I'm going to start learning. I come with it from that history.
Thank you. Indeed, it's a really inspiring story to current and future generation.
Thank you.
Probably my last question is the one of, you know, that there are some letters supporting, but there's that objection of Mr. Amos,
Yes.
the Stellenbosch story.
I am aware.
If you can share with us, what is it all about?
The real issue is the concern of Mr. Amos about his prospects of becoming a senior magistrate for Stellenbosch. When I was appointed in the Western Cape, he was already acting as a senior magistrate. I worked there. My own assessment, because of a variety of factors, some of which he mentions in his complaint, I was of the view that he was not the right candidate to lead Stellenbosch. Amongst others, a senior magistrate's duty includes training of judicial officers. And there had been a problem. There was a candidate magistrate there, or an aspirant magistrate, who was appointed to Stellenbosch in 2013. Now, the prescripts of the Magistrates Commission is that at that time, was that within 6 months of assumption of duty, a report must be written on the candidate and provided to the Magistrates Commission in respect of the preparedness or otherwise of the candidate to be permanently appointed. I arrived in 2016. My observation was that when he went through the work of the aspirant magistrate, which is what a senior magistrate should do, he noted the shortcomings, and that was correct. But what he followed thereafter, I found problematic, because the practice is that you would call in your junior, sit with them down, and indicate to them to say, look here, you have said 300 rands or 3 months, a wholly suspended, full stop. And then you take the Criminal Procedures Act, and then you show it to the candidate to say, look, the person must know the conditions under which the sentence is suspended, for argument's sake. And I'm giving this as an example as part of the training, so that the candidate understand the shortcomings, because you prepare the candidate not to commit a similar mistake again. But what used to happen was that Mr. Amos would compile that report and present it to my predecessor. And my predecessor would formulate that in the nature of a complaint to the Magistrates Commission. So the shortcomings of the candidate were actually given to the Magistrates Commission as complaints. And I said, no, that's not how it was done. But what worried me is I was not the first person of a senior rank who made a conclusion that there were problems in mentoring the candidate. As I indicated previously in this interview, because this is the same person who objected even in the previous interview. The candidate, I lost my train of thought now, but the person, my predecessor took these complaints to the commission. And when I arrived, I said, no, you can't do that. There had been three senior magistrates who had been dispatched there to intervene in respect of the training and the production of the report. And all of them also concluded that the problem lay with Mr. Amos and his capacity to train and guide. And so I was basically the fourth voice on this question. Now, when the post for Stellenbosch as a senior magistrate permanent was advertised, I obviously discussed this question with the Magistrates Commission at the time and said, look, there's this position. And I was made to understand that that does not debar me from participating in the interviews, because it is exactly that input from the chief magistrates chief magistrates are invited. Remember, in terms of the Magistrates Act, the head of the administrative region is not part of the commission. It's unlike the Judicial Services Commission. So there you get invited, right? So you are invited precisely for that, to give your views on the candidate. And that led to my participation in the interviews. I have to state that I was not a commissioner. I was not a member of the Appointments Committee, neither the Magistrates Commission itself. But I have to acknowledge that mistakes happen. One of those, amongst others, was that the commissioners relied on the administrative component in relation to assessing whether there was compliance with the forms that were submitted. In other words, is there a letter of good standing? Is there all these requirements that are set out in the advert? All right. Now, when I came in as part of the shortlisting, we were given the list of names of those who complied. And I accepted what I was told, to say these are the people that complied. All right. And then what subsequently happened is that after the whole process was done, Mr. Amos then challenged the appointment and argued that, or requested documents, and they were given. And it appeared that indeed some of the people did not comply. That is one of the reasons, amongst others, that I was part of the advice to the ministry to say we have to concede the merits and not necessarily the substitution. So that is the background.
Thank you, Mr. Tulare, Advocate Tulare. Thank you, CJ.
Thank you, Honorable Nyambi. Honorable Breitenbach.
Thank you, Chief Justice. Good afternoon, Mr. Tulare.
Good afternoon, Advocate.
You know that many people send in comments regarding your application. I'm sure you've seen them all.
Yes.
The
Those that have been forwarded to me, I've seen, yes.
So the Law Society of South Africa thinks you need more time on the benches in an acting position, and the General Counsel of the Bar says that you're a little ill-tempered. Do you have anything to say about those two comments?
I missed the first one.
The Law Society of South Africa thinks you need more time in an acting capacity.
Yes.
And the General Counsel of the Bar says that you sometimes are ill-tempered. Would you comment on those two issues, please?
I think I am ready now. I have the experience of adjudicating. I have done some time as an acting judge. I have written judgments, most of which have been reported, which means they make some contribution to our jurisprudence. The difficulty that I had with the GCB is that their comments in relation to my temperament is that I was given no incidents, and I have no recollection whatsoever of an incident where, in fact, a senior practitioner had to come and address me about how I related to my junior. And I have to state this. In the nature of my work, I interact also with lay people, with members of the public. I have never had anyone complain about the treatment that I meted out to them. In fact, even ordinary members of the public had sometimes written to me personally and to other people commending how I deal with them. I also participate in public outreach programs. I have been on Cape Talk. I have been on many radio stations, interacting with members of the public. The person referred to in that comment is actually a stranger to me.
Thank you. Can you hear me?
Yes, I can.
Oh, okay. Thank you. I've lost my picture.
Chief Justice, can I have a follow-up? I don't know whether Commissioner Breitenbach is posing another question.
Let me first clear up with Honorable Breitenbach if she's done. Have you finished, Honorable Breitenbach?
No, I have one more. I have one more question. Sorry, Chief Justice. I've lost my picture. I don't know why, but anyhow.
Okay. Is it related to the first?
No.
All right. Please allow me to have the Advocate Madonsela SC come with a follow-up, and I'll just make a note so I don't forget that you haven't finished. Please go on with the follow-up, sir.
Thank you, Chief Justice. Good afternoon, Mr. Tulare.
Good afternoon, Commissioner.
In your acting stints, have you ever had an occasion where you were presiding as a judge and you had a heated debate with a counsel appearing before you?
No, I never had that.
Thank you, Chief Justice.
Thank you, sir. Honorable Breitenbach, over to you.
Thank you, Chief Justice. Mr. Tulare, what are your views with regard to a judicial officer who has been found guilty of gross misconduct linked to underlying dishonesty continuing to sit on the bench?
I am seated here telling the commissioners and the rest of the Republic that I am ready to be a judge. That means that I have respect for constitutional structures, that in terms of the Constitution and the law have a duty to pronounce themselves on matters that are opposite to be dealt with by them. As a consequence, I have no view.
Thank you, sir. I'm done.
Honorable, have you finished, Honorable Breitenbach?
Yes, thank you, Chief Justice.
Thank you very much. Honorable Singh?
Thank you very much, Chief Justice, and good afternoon, Advocate Tulare.
Good afternoon.
Yes. I remember a previous interview which I was part of on this commission where we asked you about certain remarks you made as outgoing president at Jawasa. I think it was in July 2019. And I think this relates to judicial temperament. And I just want to know, you made some remarks which, and if I could just quote, well, one of the things, you were quite critical of the current structure, which saw chief magistrates and regional court presidents sidelined and absent from the hands of court meetings which were convened by the Chief Justice. And amongst other things you have been reported to have said is that the office of the Chief Justice is not a, and I want to quote, judicial kingdom, close quote. Now, I just want to know from then to now, have your view changed? Are you still of that still strong view that you had then, which you made in public? If you can just let me know, please.
I have allowed myself to be led by the organization that I led at the time. And the views that are referred to were the views of the organization. So I have to state that point clearly. When I often say democracy can be cruel because it is the outcomes of the majority view. And I think listening to Commissioner Breitenbach, perhaps that's the space where she finds herself. I'm not sure where there is a democratic outcome, but you're uncomfortable with it. But the point remains, once it is a democratic outcome, you're bound to it in a constitutional democracy. So those comments were made in that light. I can inform the commission that there need be no fear of Daniel Tulare as a person, because I am of the view that yes, there is a difference of opinion which I have to acknowledge that exists between the Judicial Officers Association of South Africa and the leadership of the judiciary, which speaks to governance, and in particular, maybe just reference to prescripts, the informed from the preamble to the Superior Courts Act and the interpretation specifically of Chapter 8 of the Superior Courts Act and what heads of courts there mean, whether in fact the meaning there is the meaning in the definitions or it's broader. That's the narrow part. But the whole question relates to a single judiciary. It is a complex matter which I believe cannot even be resolved by a debate and or questioning during an interview. It is a matter, in my view, that is best left for the judiciary itself to deal with it. So that is my current view. And moving into judgeship, if I am favorably considered, I will continue the engagement, and if the majority decision, even within judgeship, is that no, the judiciary commences with the high courts upwards, the magistracy is not, that would be the environment in which I find myself.
Just as a follow-up to this question, since you made those remarks, as you say, on behalf of your organization in 2019, Have you attempted to have any discussions with anybody else on this matter? Like you say, you would like to continue discussions. Have you had any discussions with anybody?
The National Executive Committee of JOASA discussed the matter, and to my knowledge, they also wrote to the Chief Justice seeking an audience to discuss these things.
All right, we'll leave that one at that. The second question, Chief Justice and Advocate Fulara, relates to your writing. I see in one of the publications that you've got is Y24 Jesus, Zion, where indigenous knowledge meets Christianity. Now, I'd just like to know very briefly, I mean, what is the contents of this book, and will your thoughts in this book not conflict with your sitting on the bench and considering a matter that comes from a church, for example? Because I see that one of the judgments was taken on appeal involves uniting the Presbyterian Church. So I'm just trying to relate this to what your thoughts are in your book and a conflict of interest in sitting on the bench.
I wrote the book as a voice of the indigenous churches in the Republic. I think if you drive around town sometimes on a Sunday, you will see a group of people under a tree, some of them dancing around. And those are the churches that I'm speaking to, and I'm a member of that faith. And I wrote the book informed by that. But Commissioner Singh, I appreciate that a judicial officer, in my view, has got two beings. You have your private being and you have your public being. And the two are different. When you sit in judgment and ordinarily in your conduct, your public being, your judicial being must take precedence. But the manner that I pray, and whether one of the things that is in the book is reverence to ancestors. I do revere them, and I trust in God. That's my private being. All right. Even before I took the trip to this interview, I took the time to reflect and speak to my late mother. That's how I am. And that's my belief system. All right. So, but whether it will influence my thinking on the bench, on the public being, I will only be, and I've always been, influenced only by the facts and the law.
I think Advocate one is entitled to their personal beliefs, conflict with when you sit on the bench. But I just want to contend that there's a fine line between your personal being and sitting on the bench. And just as a follow-up, what is your view on corporal punishment? Did you write anything about corporal punishment at home in your book?
I don't subscribe to that. I don't subscribe to corporal punishment at all. I've raised kids. The youngest one is in university now. I've never beaten any one of them.
Thank you, Advocate, and thank you, Chief Justice.
Thank you, Honorable Singh. Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Advocate Tulare.
Good afternoon, Commissioner.
My first question, I want to, it's a bit of a follow-up to the Chief Justice's discussion with you on reserved judgment.
Yes.
And I just wanted to talk about the one reserved judgment that you referred to. Is that the matter that was an agent application that appeared before you?
No, it wasn't an agent application.
It wasn't?
No.
I seem to recall that there is an agent application that served before you, and that matter may have taken 3 months to the Smith versus NDPP. Do you have a recollection on that one?
Smith versus NDPP?
NDPP, yes. If you don't have any recollection, that's fine.
I don't.
Okay.
But I wouldn't have taken 3 months with an agent application, ordinarily.
why I wanted to raise it with you, and I just
Yes.
wanted to be sure on that.
All right.
Okay. My question to you, Chief Justice, I hope you will allow me still to ask two questions. It was just a follow-up.
Please go
but
ahead, ma'am.
Thank you.
Please go ahead.
Thank you, Chief Justice. In the letters of support, one by the Black Lawyers Association and the South African chapter of International Association of Women Judges, they talk about your training, both of judicial officers and of the legal practitioners. That seems commendable work, and I wanted you to talk about that, particularly in relation to the transformation of the judiciary, what impact that does training, particularly of aspirant judicial officers, have on the transformation of the judiciary.
That aspect is very necessary. I have both in Gauteng and in the Western Cape. I had in Gauteng, I had the privilege of serving as an acting chief magistrate, both in Pretoria and in Kempton Park. And it is during that time that I started observing that, let's say, for instance, let's talk about civil litigation. If you go to many magistrates' courts across the country, you still find that the majority of presiding officers in the civil courts still happen to be our white compatriots. And that is a historic consequence, because historically, Black practitioners had to enter the space of human rights as well as criminal litigation. So that's where most Black practitioners cut their teeth, from my observation, as a historical fact. So you find that those who are in practice have not been exposed to civil litigation. I joined the magistracy, and I joined at a station or an establishment that allowed for specialization, which is Johannesburg. And I was privileged to serve in the civil courts of Johannesburg. And therefore, I became, for all intents and purposes, a civil law specialist. And as I grew, I started also going back to do criminal law, because I came from the prosecution before joining the bench, and then also branched into the family law courts, and I led the family law courts in Johannesburg. So when I became a chief magistrate, I started working against the historical fact of Black practitioners, and even those who get appointed, feeling more comfortable in sitting in the criminal courts. And I started an endeavor to train. So it started off, and which is what I'm still doing. I do aspirant magistrates training. In other words, practitioners who aspire to become magistrates enroll with my office, and with the help of Sajay, we train them on weekends. That's where it started. And then, in order to transform the bench, I started having relationships with your advocates for transformation, ADEL, BLA, the local attorneys associations, to help me get people who are willing to give the magistracy a try, or who aspire to become magistrates. And that's how I started training them. So I am glad to say that in any given class of aspirant magistrates, at least in the last 10 or so years, you'll find that almost half the class are persons that I actually recruited. I think perhaps it's a bragging right on that one.
Thank you. You actually have touched a bit on the next question I had, which was in the GCB comments at para 4.3, it says that it appears that the candidate's knowledge of the law and his experience on the bench are mostly confined to criminal, equality, and immigration law. Do you have a comment on that?
Where I'm sitting, the magistrates court in Davidson, in order to be ready to do all work that the magistrates courts can do, it's because of my industry, including not only adjudicating in civil law, but also training magistrates to do that. That is the position also with the courts in Soweto, all of them, your Claptown, Orlando, that is, and Protea, that is also the position with Mamelodi. And you go to Cape Town now, or to Belleville, which are the greater or the bigger centers within my administration in Cape Town. You'll find that the bench there is predominantly black, and they adjudicate civil matters. I trained them. So a suggestion that I do not have exposure in civil litigation, it's simply not true. As I say, I cut my teeth on the bench doing exclusively civil litigation. And I'm not talking about just doing motor collisions.
Thank you, Advocate Tilari. Thank you, CJ.
Thank you, Commissioner. Honorable Minister.
Thank you, CJ, and good afternoon, Advocate Tulare.
Good afternoon, Minister.
I see here from this judgment of S versus Fredericks. I'm not sure if you still remember the matter, but it related to substance abuse.
Yes.
And the issue of a non-custodial sentence.
Yes.
What is your view about the application of non-custodial sentence, particularly for some of the sentences that are very short that we have here? And I know that you have also participated as a Minister of Correctional Service in some of the visits to our centers to see the overcrowding.
Yes.
So what is your view about this issue of non-custodial sentence in some of these offenses that may not really rehabilitate the offenders?
Yeah, I think coupled to that, there's another matter, Minister. I'm not so good in remembering names, but I also know that it's in my pack where I deal with prison sentences of less than 2 years. And say that in my view, they serve no purpose. Remember that the Correctional Services Act makes provision for a case management and a rehabilitation plan, but that starts after or for a period of 2 years or more. And you'd recall, I think it's the matter, I don't recall the name, but it's the matter where I said, I made reference to judicial warehousing, that people are actually just warehoused in prisons because we send them to prison for a period less than 2 years. There is no program for them. They just sit there idly waiting for their time to be released. All right. There are now there is now a commencement within the prison services to start programs for short term. But the problem is you do the planting, but you never have the opportunity to go through the process of watering and seeing the growth of your rehabilitation if the period is short. And that is why my view is that preferably for less serious crimes, non-custodial sentences should be preferred. Because you put people in prison, like for instance in the Western Cape with the problem of the gang culture, people are exposed to gangsterism and all these things within that small short period. And there is therefore competition between rehabilitation programs and the gangster program within a confined environment. And because it's for a short period, you can't even measure your outcomes. And that is why my view is, preferably for shorter periods, South Africa should be looking at non-custodial sentences.
My second question is almost like a follow-up, because I think this matter has been ventilated a bit on the statement that has been attributed to you, which you spoke in your representative capacity. And to a certain extent, it sounds like a personal kind of an attack to the leadership of the judiciary. What will you want to tell this body? What must we do with that kind of a statement that it's here, is in front of us? And I heard you saying you were speaking in your representative capacity. If I'm not mistaken, I was present in that conference. What will you want this body to do and take from that kind of a statement?
My sense is that yes, there is as I said, there is a difference of opinion in relation to the governance of the judiciary, and more specifically, the place of the magistracy within the judiciary. Where is it located? All right. Now, for me, it is important for the commission to take note of that, and perhaps to the extent possible.
Maybe I must rephrase the question, Mr.
Yes.
I think you are answering what you have already answered.
All right.
I mean, in relation to your suitability.
All right.
Yes, that having uttered that statement on behalf of that body.
Yes.
Which obviously the leadership of the judiciary, some of them might have taken it very personal because of the kind of statement that is there. Do you still believe you are suitable? And do you believe we need to separate what you have said there from you as a judicial officer? And we should not punish you as a person in front of us on the basis of what you said, representing the structure. So my question relates to your suitability.
Yes, I am suitable, and to the extent that the statement may have been hurtful or received as a personal attack, I regret that. But as I said, I am Daniel Tulare, sitting here, saying to the Commission and the Republic, I am ready to serve you. Joasa spoke, in as much as its sentiments may not have been well received, there is still room for that to be rectified. There is still room for engagement by Joasa and the judiciary. But here stands Daniel Tulare. I have, when I was invited by Judge President Blambo to come and act in Gauteng, I did not know him before then. And I think he knows me by now. And I don't think, from where I am sitting and from his knowledge, he sees the person that, or he knows the person that perhaps I am made out to be. When I arrived in the Western Cape, I did not know Judge President Hlophe. I have worked with him. I have worked under his leadership. And I don't think outside the position that he knows, and perhaps even Justice Mlambo may know, that I share the view of the difference of opinion on the location of the magistracy. All right? But the person and the temperament and the respect, I think those are two a little bit removed from the person that is before you, Minister.
CJ, with your indulgence, I forgot to ask you one question.
Please go ahead, Honorable Minister.
Yeah, on the first one, I thought you will also brag about the program you have started with the Deputy Minister of Correctional Service that leads to the magistrates training to visit the centers. I thought you would say more.
Yeah, thank you, Minister, for highlighting that. What is happening now is that observing that perhaps magistrates make orders and sign warrants of detentions to incarcerate people without knowing the conditions under which people actually reside within a prison facility. It actually started within my own administrative region. I took magistrates to the prisons within the administrative region. And I also visited prisons with my Judge President in the Western Cape, Judge President Shope. But we then moved that on, and it was in consultation also with the input of Judge President Shope that the training of the magistracy in the Republic now includes a day where magistrates are taken to prisons physically to go and see what is happening there and the circumstances under which people live. So as part of our strategy to highlight especially the human rights culture and what I call the conscience of the Constitution into their decision making.
Thank you, CJ, and thank you, Mr. Tular. You said we must say Mr. Tular.
Thank you.
Thank you.
Thank you, Honorable Minister. Professor Schlemmer.
Thank you, Chief Justice. Good afternoon, Mr. Tulari.
Good afternoon, Commissioner.
Would you mind sharing your judicial philosophy with the Commission?
Maybe just starting on my last comment, I strive to ensure that whoever reads what I have written can actually feel the conscience of the Constitution in the judgment. The rights entrenched in the Constitution, the values of the Constitution in what I write. And I would say that is my philosophy.
What is your understanding of the rule of law?
Primarily that the Constitution says it is the supreme law of the country. That's the starting point. But the values in the Constitution, and especially that all citizens are equal before the law and must enjoy equal protection of the law. And that laws must be certain. And they must be known as well. They must exist before one can be said to have breached it. That for me is the essence of the rule of law. The process, the institution, the norm.
Chief Justice, if I may follow up.
Please do.
Would you say that the system of precedent forms part of the rule of law?
It does. But in the Republic, one needs to be careful. Because remember, I I can still open a law book and find a statement that reads, memory like a woman is always unfaithful.
I think draw that.
I would withdraw that, but it is in a case law. And I'm trying to drive home the point that the cases that you read and that you apply, you must go back to the Constitution and see that it aligns with it.
If I may follow up again. In one
Please continue, Prof.
In one of the cases that you decided, it was overturned, and the judge Henny, said in that case you didn't follow the line of precedent that was valid at that point in the Western Cape. How did it then happen that you didn't follow the precedent in that case?
I have explained the position in the previous interview, and I also think in the response that I sent to the commission, I did explain. The case referred to is NGJ trading. It's an appellate division case. I understood it differently to Judge Henny. And remember, as I pointed out also in the response and previously, I was not sitting alone in the Medina case. It is a judgment of two judges. I was the scribe, but Judge Dolamo agreed with me. And we did not disagree with the precedent in NGJ trading. There is a difference of opinion as to what NGJ trading says between Medina and Mu, which is the judgment of Judge Henny.
Okay, I'm not going to belabor the point. Thank you, Chief Justice.
I can just, maybe just, if you allow me, Chief Justice.
Please go ahead, sir.
Say, that judgment taught me one thing. And that is, I always took the approach that a judgment is different from a doctoral thesis. You don't necessarily have to recite everything that you have read. You only have to cite what you found opposite in your reasoning. All right? But after I read more, I realized that perhaps I should have cited NGJ trading and also cited from it why we were saying what we were saying. But because for me, it appeared clear as to, in NGJ trading itself, that trivial offenses do not become previous convictions. I took it for granted that it will never raise an issue. But I've learned from Medina to say, when you are in doubt, put it in.
Nothing.
Advocate Madonsela SC.
Thank you, Chief Justice. Once again, good afternoon, Mr. Tulare.
Good afternoon, Commissioner.
Recently this year, we received the news of the passing away of His Majesty, the King of our Pedi, King Victor Tulare III. Are you in any way closely related to His Majesty?
I am related, but not close.
And what is your view about the role of traditional leadership in our constitutional democracy? Should we have kings and queens ruling in the enclaves of their nations?
They have a role to play in the constitutional democracy. And to my knowledge, their courts also feature in Section 166 of the Constitution.
regrettably, as other courts, not really
Yes, yes.
as a relegate of
Yes.
some other institution.
Yes, but it is arising out of an act of parliament, which is the Black Administration Act, and it's part of our law, regrettable as it may be. But so they have a role to play. Currently, South Africa is struggling, in my view, with norms and standards of behavior, especially by our young people. And traditions had ways and customs had ways of how young men were prepared and how young women were prepared for the life ahead and for the crisis of puberty. And amongst others, my view is that if we strengthen the social role amongst others of traditional leadership, we may find ourselves in a better place.
Thank you, Chief Justice.
Thank you, sir. Advocate Kennedy.
Thank you, Chief Justice. Sorry for the delay in turning on my microphone. I have been covered.
Thank you very much. Honorable.
Oh, JP, CJ, it's my turn, Mlambo.
Yes, sir. It is your turn, JP.
Thank you, Chief Justice. Bamshad.
Tovel.
It's been a long time.
Yes, it is, JP.
Yeah. My first question is a follow-up to the question by Commissioner Tsepe about the Jason Smith and Michelle Smith against the NDPP and two others. It's a judgment that it was delivered on 19 March 2020. It had to do with the two applicants requesting the unfreezing of some funds in terms of the poker legislation for living expenses. I'm trying to give you those facts for you to remember, if possible. A reading of the judgment suggests, in fact, it shows that the affidavits regarding the application were filed towards the end of November and at the beginning of December. And the judgment itself, the opening paragraphs, does say this is an urgent application. So I just wanted to check with those facts whether you remember this judgment, because if the affidavits were finalized around November, December, I would think it would have been heard either end of December or in January. You still don't remember the matter?
If you refer to a poker matter relating to the release of some property for purposes of life support, I have a recollection of that matter, JP.
Yes.
Yeah, but to my knowledge, it did not take that long. I took time to ponder the judgment, but I'm speaking under correction, but it didn't take that long.
Yeah. Okay, well, the date reflected that it says judgment delivered 19 March. I'll leave it at that. My question, CJ, is relating to the issue of collegiality or collegiality amongst judicial officers. How do you understand that term?
It means that there must be some level of respect and deference, and I don't want to say friendship, but some benevolence that one must enhance when dealing with other colleagues.
Is it an important trait in the judiciary, especially?
It is very necessary, JP.
Thank you. One of the annexures sent to us is a letter that refers to you, that inquiries must come to you. And I'll be corrected by this commission because I wasn't here in 2019. But it appears to be a statement that was issued after your interview relating to a statement that Judicial made to the president of the country about his concerns about judicial governance. I may be mistaken if I say after.
That is a discussion document, Chief Judge President.
Yes.
It never reached the president. It was never intended for anyone other than members of the National Executive Committee of JOASA. It was a collation of ideas within the NEC.
I see. Okay, so you say it was never meant for the public. So it's not an official JOASA public document?
No, it is not. In fact, if you check the further attachments, you should come across a letter from the president of JOASA indicating that that document was leaked. It's, in fact, the president goes so far as to say it is a stolen document.
Yes. Okay. Now, thank you very much for correcting that, because that document contains strong language against the Chief Justice and the Deputy Chief Justice.
Yeah, that as I say, it is a stolen document. It is a collation of ideas. Let me put it this way, JP.
Yes.
Before JOASA reaches a decision, there are what we call deliberative thoughts that comes from all quarters. And one of us is assigned to collate them into a document so that we can distribute it and start discussing it. All right. So that document is an internal document of JOASA. Number one, it was made in confidence. Number two, as I said, the first one is that it's deliberative thoughts. It's not even a decision of the NEC. The NEC had not reached a stage where it deliberates on it.
Mr. Chulare, let me allay your fears. You've explained the nature of the document, and I think you run the risk of repeating yourself.
Thank you.
You're going to tell us.
Thank you,
You've
JP.
explained to us, but if other commissioners feel I should give you time, they will say so to explain yourself. But I accept what you say about the document.
Thank you, JP.
But let me just raise, sorry, Chief Justice, the issue of judicial governance. I'm talking to you now as a colleague. We are colleagues, after all.
And as my leader, JP.
I don't know about that, but anyway, I'm joking. We've had many discussions, me and you. Even when you're in Cape Town, we talk about a lot of things.
Yes.
But do you agree with me that the issue of judicial governance under the Chief Justice, the Constitution is clear, but the institutional model, as well as the final location of judicial governance, remains work in progress? Am I correct?
Yes.
Okay. Because I just wanted to understand what the thinking of JOASA is of addressing this issue, because there may be unfair criticism when certain things are not moving.
Yeah, perhaps there's a level of impatience with the input of the magistracy into the greater framework. Because as I say, you'd recall that I made reference to Section 8 of the Superior Courts Act.
Yes.
That the understanding of JOASA is that heads of courts, specifically in Chapter 8, not in the rest of the Superior Courts Act. Because if you look at, let me start by saying Chapter 3 of the Superior Courts Act deals with governance and judicial administration.
Yes.
All right. And then Before you get there, when you look at the preamble, especially after noting that, you will see that one of the observations that the legislature makes is that magistrates were not part of the judiciary pre-1994. And one of the objects of the Superior Courts Act is to make the magistracy part of the judiciary. All right. And on the other hand, we are sitting with cases like Armsa versus the President, where the Constitutional Court made it very clear that the magistracy is part of the judiciary. All right. Now you have that. Against that background, then you approach Section 8 of the Superior Courts Act. And as I say, Section 8, yes. You will see that Section 9, 10, 11 specifically refers to the Superior Courts. But Section 8 doesn't, and it spoke to governance, which is the area that the preamble says it is the intention to address the governance of the magistracy. And now you find a situation where the heads of courts meet, less the magistracy. And it is that aspect that JWASA is concerned about. And it is there where there is a difference of opinion and perhaps a push, perhaps unfairly so at a faster pace than perhaps the judiciary can move to say the magistracy must be part of the governance because the Superior Court Act says so. Because the understanding is that the head of court in Section 8 is not as defined in the Act itself because it must make room for the preamble. So that's where the issue is, JP.
No, I understand. But
yes,
to my recollection and knowledge, I have yet to deal with a formal request for engagement by either the Chief Magistrates Forum or the Regional Courts Presidents Forum to the Chief Justice or to the heads of courts to discuss governance per se, unless I'm mistaken.
I happen to chair the Chief Magistrates Forum, JP.
Yes, that's
and
why I'm
it is a
raising
message
it.
that I will take back to the forum.
Yeah. Thank you. But do you agree, sorry, Chief Justice, that collegiality is the glue that keeps judicial officers together? It's not kowtowing or friendship, but respect for each other.
That is correct.
Thank you, Chief Justice.
Thank you, Judge President. President Maya.
Thank you, Chief Justice. Good afternoon, Mr. Tulare.
Good afternoon, President.
Just one issue remains for me. You've covered all my other concerns. All interested parties, including this commission, have lamented the slow pace of gender transformation in the judiciary, as we all know.
Yes.
Now, what I'm going to put to you is something that it's a question that was asked of me by a member of the public, during last week during these hearings. And I'm just going to paraphrase it, to package it nicely so that it's more palatable for a public forum. Now, the JSC, this is what this person pointed out to me. JSC has 23 members and only 8 of those members are women. Now, should we worry that the body tasked with facilitating the racial and gender transformation of the judiciary itself has very few women in its own ranks? As this person put it, why should the JSC be trusted to execute its mandate to bring gender diversity into the judiciary when its own house is not in order? What thoughts would you have on this?
Within the organized profession of judicial officers, the discussion has already started. And fortunately, this one hasn't been leaked. All right. But the discussion has already started about the need, even for argument's sake, for the South African chapter of the International Association of Women Judges to have a permanent seat on the JSC. And it is an initiative that I would personally support. But yes, it is indeed true that if we are to transform in truth, one of the things that we must do, and I'm saying this as a man, is to push back the frontiers of patriarchy and assert women and promote them where necessary and support them to assume positions of leadership, which includes representation at the JSC.
Thank you. Thank you, Chief Justice.
Thank you so much, Honorable President. Honorable Malema?
CJ Toben.
Tamakosh.
Lagasubat.
Christmas.
No, CJ, that issue of gender, I think Makabanega Tambo, they had it, they will attend to it because these ones who come from parliament, it's them who are distorting the composition of the JSC. So it's something that parliament will have to look into. Mara, what I wanted to say, di kwa regis bat. Di le seje ba khalabelo ba khegolo ba shale ba dilibele. Tobe.
Ke a leboga.
Thank you, CJ.
Thank you, sir. Advocate Tulara, I have a few questions. The first flows from what President Maya asked you.
Yes.
Supportive as you are of gender representation, we have two women advocates who have applied here, two African women. Would you favor a notion that instead of recommending you for appointment, we should rather recommend those two women for appointment since there are only two vacancies?
Similar to my answer to Commissioner Breitenbach, I leave it to the wisdom of the Commission, Chief Justice.
I'm sorry, sir. I know it's not fair. You are passionate about gender transformation. You are even a member of the International Women Judges Association.
Mm.
Would you, in view of your passion for gender representation, say, painful as it is, I'm going to give way to my two sisters so that they, instead of me, can be appointed?
If the JSC finds that the Western Cape deserves what the two women offer in the greater scheme of things, better than what Daniel Tulare can offer to the Western Cape and to the judiciary, I'll be at peace with that, Chief Justice.
Okay, sir. My next question, instead of reading something, I'm going to play a clip. Don't worry about the content. It's not about what you are advocating. I'm not worried about that. It is about the song itself. My question arises out of the song. Technicians, please play that song. My question is based on it. Is it
At
coming?
the next meeting of JOASA, as well as the next meeting of the SACIAWJ, I will be leading a song whose lyrics goes like this. Phakama mandisa maya, ixesha lisondele. Phakama mandisa maya, ixesha lisondele. In my view, the judiciary is bleeding and rudderless. It needs
a calming leadership. I am of the view that South Africa is ready for the first African female Chief Justice. The current most senior female judicial manager is the President of the Supreme Court of Appeal. It is the woman, I think, the magistracy should unequivocally and unconditionally and unashamedly at this stage call on for the president to look at. There is a song whose lyrics goes, African woman, why give me Korobela? I think the beginning of the lyrics should remain African woman, but the last portion we should change. Give us justice. That would be the views of Daniel Mafele Utulare, and I will, without hesitation, be expressing them when I come back from the 6th of July 2020. All the best, colleagues.
Now, my question is very narrow, sir. Is it you in that clip?
It is myself, Chief Justice.
Is it correct to say that song is a song associated with a political party, the ruling party? It is a song that was popularized by the presidential campaign of President Cyril Ramaphosa when he wanted to be president of the ANC. Is it correct to say so?
Perhaps before I answer the question, Chief Justice, let me state the following. That clip.
Sorry, sir. I'm going to be very fair to you. Can we agree that you answer my question and then I'll allow you to give whatever perspective? Let's just start on the narrow issue. I'll be very fair to you, sir.
I have heard it sung across political lines. That is correct, Chief Justice. That it was sung in political rallies, but across political parties, not restricted to a particular political party.
So it is not associated with the governing party, and it is not particularly associated with the current president?
No, not at all. And it was never intended to be.
Okay.
Yeah, but
okay.
Can I please make this comment, Chief Justice?
Okay, sir. Okay, sir.
This clip falls in the same category as the document that Judge President Blambo earlier referred to. It is a WhatsApp voice message to magistrates serving at the Cape Town Magistrates Courts. When the president announced the lockdown, I was in the Western Cape, and I took a decision to lead my colleagues from the front, being in the Western Cape during the first lockdown up until towards the end of June. I was in the Western Cape. When the lockdown eased and the country could move and the courts could open, I then took leave of absence. Now, ordinarily, this would have been a tea room discussion. It was meant for the confidence of colleagues in a tea room in Cape Town. But because I was on leave, I was here in Gauteng, I learned that the discussion around the succession within the organizations have already started. I don't think Jwasa was the only one, because although we do not formally engage, but informally across associations, we exchange notes. And the discussion had commenced within the magistracy. And the only way that I could make a contribution to that discussion was through a WhatsApp voice note. And that is the context. So it was never intended to go public. It was made in confidence. It is part of the deliberative thought processes towards decision making. That is its status. And most importantly, it was given to people who are members of the organization who owe a fiduciary duty and a professional as well as ethical responsibility to keep things confidential. And one of them breached that. And that's why it is now with the Chief Justice.
Okay. Now,
perhaps deliberately to embarrass Daniel Tulare, I do not know. But that's its status.
Okay, sir. Now, did you say, let me put it, have you ever heard this song sung outside political party circles?
Yes.
So you can sing it even outside the political, so it has been sung outside political party structures?
That is correct, Chief Justice.
Okay. Now, you were the one singing. You were the one saying the judiciary is bleeding and rudderless. It was not Jwasa. It was your message to your colleagues. What have you to say about that?
That interpretation is incorrect, Chief Justice, because I am saying I will be leading. And you don't lead unless there are people in the choir. And as I say, I was here in Gauteng when I was informed that the discussion had already commenced and people made their views known. And I also made my views known in that discussion.
Okay, sir. Finally, following from the 2019 engagement,
Chief Justice,
regarding whether the magistrates
Chief Justice
were not, sorry, sir.
Yeah, it's Julius Malema.
Yes, sir.
I don't know how this is done because it was played here in public. It's unprecedented what you just did.
Yes.
And I don't know how to handle it because I thought people write objections and then they are given to candidates and candidates are given sufficient time to prepare a response. And I view that as an ambush. And I'm very uncomfortable about it. And it was done here in public. I know we can go and take up a discussion in our own deliberations, but I don't accept that. I'm very uncomfortable about it, and I'm very uncomfortable at the way it was presented. Is never. I've been here since 2014. It has never happened. It's for the first time. So I don't know whether, in the language of lawyers, is an admissible evidence that gets to be presented in this way, or what happens, because it can be that other people should follow a certain procedure when they've got issues with the candidate that comes here, and the Chief Justice has got a special procedure which he follows, because he was supposed to be given an opportunity that you are going to be led on this so that he can prepare sufficient a response like all other people who object. I don't know how we go about it. To me, it's unfair. And I will suggest that perhaps even when we go into the private discussions, it must not arise. It must be withdrawn completely because it didn't come through the established practices.
Yes. Well, for the record, it was on the 1st or the 2nd of April that the candidate and all the commissioners, including you, Honorable Malema, were sent the documentation and the clip that has just been played. So there's no ambush here. It may well be that you didn't access it, but it was sent to everybody. Ask the candidate whether it was sent to him. It was. There is a record of that. So there's no ambush here.
No, then it's fine.
There's no
There's
no special procedure here.
If the commissioners received it and it followed a normal procedure and he had an opportunity to listen to it and reflect on it like the rest of others, then I withdraw my proposal.
Thank you, sir.
Chief Justice,
Yes, sir.
it's Singh here. And if I can recall, President Maya also gave notice to all the commissioners that she will be raising this matter at the JSC in writing.
Yes, yes. Thank you, sir. Now, my final question, sir, it is to give you an opportunity to correct, if you are so minded, the assertion you made in 2019 during the interview that on the 3rd of October 2019, then nothing was said about the magistrates, nothing was said about their performance. In the prior communication, I refer to page 31 of the annual Judicial Accountability Report that shows what the report says about the regional court and what the report says about the district courts. And even in the speech I delivered, which I attached and sent to you and the commissioners, paragraph 25 makes specific reference to the magistrates. And most of the time, I don't refer to judges, I refer to judicial officers, which includes both judges and the magistrates. So my only question is, do you realize that you were mistaken, or do you not realize that you were mistaken in your assertion that magistrates were not even mentioned? They were just sitting there, but nothing was said about them.
Chief Justice, if I recall, the context of the discussion was in relation to the performance as demonstrated in the document with regard to, and I was making a comparison of what was in the document in relation to the higher courts or the superior courts and the magistracy. It is in that context. If I gave, because I was away, as I said, I was at the meeting, I heard what you said, I had received the report, I had read it. I knew what stood in the report.
So you were aware that specific reference was made about the magistracy and about what could not be specifically mentioned.
The context, insofar as I understood the discussion at the time, Chief Justice, of my interview, it was talking to the performance of the courts. That's how I understood it. And the key, the agreement on the performance indicators is in the document. I knew that. Remember, I participate in the meetings with Judge President Musi. So I know what the situation is.
Okay, sir. Now, thank you very much, Advocate Tulare. Thank you very much, sir.
Thank you. May I please,
sorry. President Maya has a...
Thank you.
Yes.
Mr. Tulare, I'm deeply flattered that you think I could actually lead the judiciary. Thank you. But I don't want my name to be collateral damage in this tussle between you and the Chief Justice. Would you please do one thing for me and tell this commission and South Africans just what role I had, if any, with this push by Jawasa to propose that Mandisa Maya should be the next Chief Justice? Please.
Thank you. I think the Chief Justice himself would attest to that. When Jawasa has its own internal discussions around the succession of the Chief Justice, we do not consult the candidates that we identify, neither do we speak to them. I'm making specific reference to the Chief Justice because even in the letter that the President of Jawasa wrote, that has been given to the commissioners would have noted that the President of Jawasa makes reference to the time leading up to the interview of the Chief Justice for this position. So the Chief Justice is well aware himself that Jwasa does not talk to candidates. We never approached him, nor he approached us to say, I want to be Chief Justice. So the same position prevailed with Justice Maya. We discuss amongst ourselves, and as I say, unfortunately, the document was leaked, whether generally or specifically to embarrass Daniel Tulare, the jury is out, but the document was the thought process for Jwasa to make a decision. And I have to state here, President Maya was not the only candidate that the NEC of Jwasa discussed. There were other people. In fact, the other name is one of the JPs present here. All right, that was the discussion. But we were in the preparatory space. We have never discussed with anyone, and therefore we had never discussed with Judge Maya. In fact, I think Judge Maya became aware, if she received the leaked document when it went public, that Jwasa was actually discussing her name. But we don't generally discuss candidates with them or lobby them or go to them to say we are going to be proposing you. We have our own internal discussions, and once our processes are concluded, then we communicate publicly.
CJ, if President Maya is done, I want to make a follow-up.
I'm done, Commissioner Malema. Thank you very much, Mr. Tulare.
I would like to follow up on Justice Madonsela.
Yes, sir. Let me just have your name. Who comes after Commissioner Malema?
Madonsela.
Oh, I'll follow Madonsela. Commissioner Madonsela, CJ.
Nyambi will follow Todovu.
Okay.
No.
Thank you.
I just want to.
Honorable Malema, over to you, sir.
I just want to get a clarity. You said something like the current Chief Justice was discussed in the same manner Justice Maya was discussed.
Yes.
Can you take us through that process?
I'm saying leading up to his interview to become Chief Justice, at that time, as an organization within the legal profession, we also had discussions about who is going to follow Chief Justice Ngobo. We have our own internal discussions. So yes, we discussed the Chief Justice. In fact, if you can, perhaps even if I recollect correctly, during his interview, Judge President Ngwepe read out a portion of Jwasa's contribution. The Chief Justice, to my knowledge, learned about that for the first time when it was read. We never consulted him. We don't, as a matter of principle.
Did we have a song for him?
we didn't sing for him at that time.
Thank you. Thank you, CJ.
Thank you, Honorable Malema. Well, Honorable Dodovu, I've written your name before that of Advocate Madonsela, so please go ahead first. I don't want to confuse myself.
Okay, thank you very much, Chief Justice. Some few questions from my side. Perhaps can you just share with us in brief, and I'll tell you why I'm asking this question. Do you know the process of appointing a Chief Justice?
Yes, I do.
Can you just share with the Commission a bit?
The President makes a determination and thereafter discusses it with members of political parties.
Do you know that this body, the JSC, ultimately is the one that recommends to the President?
Yes.
What would be, under the circumstances, the role of Jwasa and any other interested party in the process?
To comment on the candidate, which is what we did with the current Chief Justice.
Your singing of the song was based on how you are going to present your recommendation, your comments in the process.
Yes, it's preparatory work towards a decision, and that decision then, so that by the time the process kicks up, Jwasa is ready. Remember, we are the leadership. So you prick the members to start discussing, and then the discussions of the members they become collated, and then once they are collated, they are taken back to the members for thumbs up, And once it is there, then we are in a position to make a comment.
In the song that you were singing, you were just saying to the members, this could be our view. You were lobbying them that this could be our view in supporting whoever is the candidate.
Yes.
In that respect.
Yes, and remember, the organizations are democratic, all right? I, together with those that spoke to me, spoke to a name. It could be that during the deliberations, we could have agreed on a woman, but not President Maya. One does not know how the discussions would have unfolded. But you put your head on the block and say, this is where we are going, and for people to comment. And because it is a democratic process, and commissioners must bear in mind, the very organizations, all right, made the nomination for me to say, this is a candidate to be a judge.
And then this song that you were singing, it was not intended for any of these commissioners.
No. It was intended for magistrates within their organized professions. And specifically, the song was for magistrates of Cape Town.
And you were not intending to lobby any one of us, the 23 members here,
No.
about your preferred candidate?
No.
Okay, thank you very much. I'm satisfied.
Thank you.
Chief Justice,
Advocate Madam Zelesi.
I'm covered.
Honorable Nyambi.
I am covered by Commissioner Malema, but I wanted to just.
Thank you, sir.
Thank you, CJ.
Thank you very much, Honorable Nyambi. Advocate Tulare, thank you, sir. You are excused.
Thank you. Thank you to the Commission for giving me an opportunity.
On a lighter note, maybe you should give us a song, man. Colleagues, do we need 5 minutes while the room is being cleared?
Make it 10, please.
Thank you very much, Judge President. Good evening, Advocate Basson.
Good evening, Chief Justice.
How are you, sir?
I'm very well, thank you, Chief Justice.
I want to take this opportunity to apologize to you and to apologize to colleagues from NADLEC that we have kept waiting for a rather too long period. I'm very sorry for the inconvenience that we have caused you.
Chief Justice, that's one of the similarities between politicians and legal practitioners who don't keep to regular working hours.
Thank you, sir. Thank you. You hold 3 degrees and you are now busy with a Doctor of Laws degree. Am I right? No. I'm sorry. I'm looking at the wrong thing. I'm sorry. I apologize to you, Mr. Basson. You hold 2 degrees, PLC and LLB.
That's correct, Chief Justice.
Now, what did you do upon completion of your degree? The last one.
Chief Justice, I did my BLC and immediately thereafter started a career in the civil service at the Government Employees Pension Fund. While I was working, I did my LLB part-time, and I paid for my LLB whilst I was working as a public servant.
And for how many years have you been practicing as an advocate?
Chief Justice, I spent 8 years at the Government Employees Pension Fund. I then joined the bar in 1999, and I've been a practicing advocate for 21 years now.
Yes. And I can see that you've acted as a judge, you've attached judgments here. Am I right?
I have, Chief Justice. I've acted 3 times on a pro bono basis during recess at the Labour Court.
Yes. And have you had a challenge producing a judgment within the stipulated period or the recommended period?
Chief Justice, the judgments I prepared were delivered on an average between 3 and 5 weeks after argument was heard. There was one matter which I could trace back, which was a review with more than 5-6 lever arch files, and in that matter I exceeded the 3-month norm. So there was one judgment which I could trace, which took longer.
Yes. No, thank you. Thank you very much. JP, welcome, my brother.
Good evening, Chief Justice.
JP? Yes. I have unfortunately not been given the names of the NADLEC representatives. Are you able to assist me, JP? I'm sorry to do this to you. It is the officials who should have done this.
Sorry, Chief Justice. There are only 2 persons from NADLEC. One is authorized by the other as well. The 2 persons are Mr. Kalipi and Mr. Lukele, who's a new member of NADLEC as far as the JSC is concerned.
All right. Okay. All right. Colleagues, let me have the names of those who have questions for Advocate Basson, please.
Singh.
Shlema.
Thank you. Judge President, over to you, sir.
Thank you, Chief Justice. Mr. Basson, welcome, and I just have a few issues. Firstly, we talked about judgments let's talk about the one judgment, which was reversed. That's Samenco. You know that judgment? You remember that judgment at all?
Yes,
I'll
I do.
tell you what the issues I have on that one, because there seems to be lots of debate going on from people who commented on your position here. And that is, I'll tell you what my issues are, and maybe you can respond. You pointed to here the review in Samenco. In that matter, the arbitrator had decided that of the 4 people who were charged, there were 5 people in a team who failed to carry out an instruction. 1 was acquitted, 4 others were charged, found guilty, and the arbitrator said, but we cannot dismiss them because the 5th person was not dismissed, and she was part of the team. And this was inconsistent application of the sanction. And that was the arbitrator's decision. It was taken on review, and it came before you. Now, if you remember what you decided, for some reason, on 3 occasions in that judgment, and it's very curious why you did that, but on 3 occasions in the judgment, you made the point that the 5th person who was not found guilty of failing to carry out the instruction was the girlfriend of the supervisor who gave the instruction. And then you go on and you make the decision that the arbitrator was right, but you don't talk about the consistency or inconsistency. You say, on the facts of this case, it wasn't proved that these 4 people had committed the offense. There wasn't enough evidence. Is that right?
That is correct, Chair.
And the matter was then taken on appeal on the Labour Appeal Court. And the Labour Appeal Court, if you remember, said they were in fact very intrigued that firstly, you didn't deal with the cardinal issue, main issue, which was really inconsistency. That was the issue. You didn't deal with that at all, although you mentioned 3 times that the person who was not dismissed was the girlfriend of the supervisor. And then you say on the facts of the matter, they had failed. And the LAC said they couldn't understand that because the facts were very clear and these people had failed to comply with the proper instruction. And they reversed the decision of the arbitrator, if you remember, because they also said there was no issue of inconsistency because a 5th employee was never in the team. She had been sent by one of the team members away at the time when the supervisor came and gave the instruction. Isn't that so? Now, I find the problem I have, and you can respond to that. In terms of law, sometimes there's interpretation, and if there isn't precedent, then there can be difference of opinion. But when there is a problem where the facts are seen so differently, the arbitrator and the LAC saw the facts in one way, and you saw it in a different way, and the LAC went to a lot of trouble to say why you were wrong. Now, I have a concern when an acting judge, or any judge for that matter, gets the facts wrong. What comment would you have to make on that? And I raise that because you have raised this judgment in your questionnaire.
Yes. JP, I particularly pointed out that judgment because it was the one that was taken on appeal and overturned on appeal. The facts, as it was argued during the review, mainly concerned the question whether there was an instruction given to the employees who were busy mining. There were 2 instructions, and it concerned the second instruction and whether they failed to comply with that instruction. I found on the evidence in the review that there was insufficient evidence presented by the employer to prove that there was in actual fact misconduct or a breach of their duties. And it is on that basis that I found that there was insufficient evidence and therefore that the dismissals were unfair. The issue of consistency was not that pertinently raised during the review. I see that it was in fact pertinently raised in the appeal, and that is also one of the issues that was pointed out in the report by the DGRU. It is correct. I made a certain assessment of the facts, and the Labour Appeal Court came to a different conclusion on the facts and also the issue of consistency. In my defense, and as pointed out by the DGRU, the issue of consistency was not that pertinently raised during the review.
But that was the basis on which the arbitrator had made the decision. We'd not go debate that much further, but wasn't that was really what the point raised by the LAC. That was what the arbitrator depended on, and that's why they needed some response from the judge on that. In any event, when you say that you came to a different conclusion, the issue was this, and that's what the LAC also said, that how you see the facts didn't really matter. This was a review. You had to see how the arbitrator, why did he come to that? Because the arbitrator found that they had misconducted themselves, you see. But okay, as long as we have an idea and I understand what you're saying, but those are my difficulties which are raised, then tell me about the matter of Carmichael Brown. Did you act for Carmichael Brown? I'm not sure. Or
I did, JD. Yes, on 2 occasions. There are
on two occasions. The one occasion was the issue of the subpoena. Is that correct?
That is correct, yes.
And you are, and I suppose not you, but your attorney would have issued a subpoena, and the other side objected to the issue of the subpoena, which then came to court. Am I right?
It's the other way around, JP. They issued the subpoena.
And you objected?
We objected on the basis that there's a distinction between discovery and a subpoena. The subpoena was issued against the other litigating party, and we took the view that a subpoena ought to be aimed at a witness, and that the ordinary discovery process is applicable when you want documentation from your other litigant.
Yeah, that's what I was worried about, and you're absolutely right. You need to use discovery. But the other party, was it part to the pleadings, party to the matter at least? Was it a party to the action?
Yes, the subpoena was issued by the one litigant against the other litigant. That's correct, yes.
Okay. Yeah, that's fine. And were you involved in the other matter relating to making an agreement, an order of court? I think that was before me. I don't know if you were the counsel in that matter. Which was, I think, Correctional Services or Ministry of Justice, I'm not sure. Were you involved in that one? I know there was a basson, and I wasn't sure if it's you.
I can't recall that,
Yes,
JP.
That's fine. Then I want to ask you something about your studies. I mean, I noticed that you went to university at the age of 17, is it?
Yes, my wife always joked that my parents wanted to get rid of me as soon as possible. I went to school at the age of 5.5 and completed matric at the age of 17, yes.
Did you not do your military service?
I did not, no.
Oh, okay. Then I see you have no involvement in any community issues at all, according to your questionnaire. You don't involve yourself in any community matters.
No.
I suppose you practice all the time.
Yes, that's the difficulty of being in full-time practice, is that there's not always a possibility of being involved in community service and in other organizations where you would like to be.
Okay, thank you. Chief Justice, that is all from me.
Thank you, Judge President. If you could switch your mic off, please, JP. Mr. Mkalipi and Mr. Lukele, again, I just want to apologize to you directly for keeping you waiting as long as you have had to wait. I'm really sorry about that. Who of you is going to put questions to candidates?
Chief Justice, thank you for the apology. We understand that's how these things happen with interviews. It's difficult to
thank you so much.
keep up time.
Thank you.
And from my side, from Advocate Basondi, we're fine at this. I'm fine at this stage. I don't know about Sifiso.
Thank you. Is it Mr. Mkalipi?
That's him.
Thank you, sir. Thank you very much for understanding. Honorable Singh.
Thank you very much, Chief Justice, and good evening to the JP and the representatives of NADLAC and Advocate Basson. I just have one question that I'm trying to get an understanding of from your questionnaire and your CV. I see you've got quite a bit of experience in labor law issues. But according to what I have here, you seem to have acted pro bono, which we thank you for only 12 days, from the 9th of July to the 13th of July 2018, which is 4 days, 8th of July 2019 to 12th July 2019, which is also 4 days, and then 15 July to 19 July, which is also 4 days. Now, I don't know, perhaps after you completed this form, you might have acted again, but am I correct to say that you only acted for those 3 terms and for 12 days?
That is correct, Commissioner.
Thank you, Chief Justice, and thank you, Advocate.
Thank you very much, Honorable Singh. Professor Schlemmer.
I'm covered, CJ.
Thank you very much, Prof. Advocate Basson, you are excused, sir.
Thank you, Chief Justice.
Thank you.
Chief Justice.
Thank you very much. Good evening, Mr. Ngosi.
Good evening, Chief Justice.
If you like, you may take off the mask, sir, so that we can recognize you the next time we meet you. How are you, sir?
I'm fine, thanks, Chief Justice and the members of the Judicial.
I see that you have BUris, LLB, LLM, and you're currently busy with LLD degree.
Yes,
Is that right?
That's correct, Chief Justice.
Okay. What was your area of focus for your master's program?
It was constitutional law and human rights practice.
Okay. And your doctorate, even if you are still pursuing it, what is your focus there?
It's a continuation of human rights, but focusing on UNESCO and the rule of law.
Okay. Did you get to be admitted as an attorney, and if so, when?
I started
When
practice.
did you become, when were you admitted as an attorney? Is it 97 or before 97?
It was 1995.
Or 1995?
Yes.
So you've been an attorney for over 26 years, am I right?
That's correct, Chief Justice.
And you've also been a tutor, both at UNISA and Tran University. Is that right? A law tutor.
That's correct, Chief Justice.
You've acted as a judge.
Yes, that's correct.
Okay, very briefly tell us how that has prepared you for the position you're now applying for. Very briefly.
Since I started doing articles 1994, I've been I had an opportunity to represent people in the magistrate court and the CCMA and other small, would I say, ordinary courts. Then, as soon as I got admitted, I was able to start representing clients in regional courts and other tribunals. And I was further nominated and appointed to start acting on behalf of state departments in statutory reports, various statutory reports. I may make an example, the Mpumalanga Liquor Board, the Transport Board, in various capacities, Cross-Border Road Transport Board, Transport Appeal Board as well as a deputy chairperson, and the Gaming Board. While I'm practicing as an attorney, I was able also to split my tasks to these different statutory boards. And I became also a consumer court presiding officer for a period of not less than 3 years, which prepared me to be able to understand and analyze the law. And I was again appointed in the General Public Service Bargaining Council as a commissioner, part-time commissioner. The CCMA is part-time commissioner, and Safety and Security Bargaining Council, and also the Road Freight Industry Bargaining Council, and other ordinary instructions from different clients where I was able to analyze evidence presented to me, and that made me to be able to feel that I am ready to take a position that can lead or preside over matters. And since 96, I became a commissioner of a small claims court, of which I'm still, even today, if there's any matter, they can call me. I present myself to help pro bono for that matter, because as a small claims commissioner, we don't get paid. For the past 15 years, I've been doing it.
Thank you very much. Colleagues, before the JP can come in, may I have the names of those who want to put questions to Mr. Nkosi?
Singh.
Schlemmer.
Muimang.
Honorable JP Wagley, over to you, sir.
Thank you, JP.
Thank you, Chief Justice. You're welcome. It was a pleasure to have you in court, I must say. I know you acted before in 2011. I think that was the year.
That's correct, JP.
Is that right? Yeah. Only problem I have is we've gone through all our archives and everything, and there isn't a judgment. I don't know. You must have handed down some judgments during that time.
Yes, it's true, I did.
Okay. We couldn't find it. Maybe you should let us have, just so that our archives can be corrected. All right. Thank you for that. And then we didn't hear from you, and I think the problem has been that you practice in Mpumalanga, if I'm correct, and coming to Johannesburg might be quite a problem, but as you know now, we have a high court there, and there will be a labor court situated there, and hopefully that it will run efficiently, and we'll have people wanting to do labor matters there. I raised that because I noticed that although you have a practice which must be an envy of any legal practitioner, I mean, you have the most diverse practice that I can think of, and you're involved in all things. My concern, of course, is that the labor matters don't seem to be taking precedence in your practice. And I raised that because, when you were shortlisted, I immediately phoned you and I told you, please come and act. Because I think it's very important that, especially with your CV, that you should come in and see how practice is and see if you're enjoying the labor work. And your first matter, which was supposed to be a long matter, got settled, sadly in the sense that to make an assessment of it. And then the issue came up because there wasn't any other trials, you were given lots of files to do directives. And the concern I had was this. Remember when we spoke, I told you there is no better court than the labor court when it comes to camaraderie. You can knock on any judge's door with anything and they will always assist. And most of all, if you feel you want to phone me to ask, feel free. That's one thing I always do, I answer my phone. You'll never find me not answering my phone unless I'm in a hearing. Okay, and doesn't matter what time. Now the problem I had was when you were given these directives, you didn't, you spent most probably a lot of time on it. But I think you missed it as to what exactly you needed to do. And you didn't speak. So all I need you to do for the rest of the time you're in practice is feel free to knock on any door. All right. And we think you have the potential, but we're not sure. I'm not sure if now is the time to appoint you the labor court, at this time. But you definitely would feature as someone who we need to look at to appoint in the future. I've read your CV and I've read what you've done. It's most amazing, At the same time, we just need to spend some more time doing labor work. And doing CCMA work is great, but it's not the court. You need to appear in court and you need to practice in court. Those are my issues. I don't know if you want to comment on them. Feel free.
Oh, thank you, JP. My humble view or submissions was that acting as a commissioner, the CCMA, or any parent council is practicing the law, labor law, as is, depending on which side of the soccer field are you. Are you the goalkeeper or are you a striker? So I'm practicing labor law in different ways or from different stages. The law is the law. As to whether you defend or you preside, but you're practicing the same law. We interpret the same law. We make sure that everything is done in the proper way because we are all players in the same field.
Thank you, Chief Justice. Nothing further from me.
Thank you very much, Judge President. Mr. Mkalipi?
No, Judge President, we don't have a question to ask for this candidate. I think the Chief Justice.
Thank you very much. Thank you very much, sir. Honorable Singh?
Thank you, Chief Justice. Good evening, Mr. Nkosi.
Good morning, sir.
Good evening. I'm trying to understand the information that you completed in section 9 of your application, which refers to if you have sat as an acting judge. Your answer is yes. And then I'm just going to read what you said. In which division were you appointed? You say North Gauteng High Court, 2013. Then you say South Gauteng High Court, 2011. Then you say Labour Court, 2012. Then you say Limpopo High Court Division, 2014. And then lastly, you say Mpumalanga High Court Division, different periods, 2015. Then you go on to 9.2 to say, please give the dates of your appointment. You say the dates as stated in paragraph 9.1 above are a disjointed stats of the last 8 years. Now, it's very difficult to work out how many terms, how many days, how many weeks have you acted, but I'll just come just to the labor court only. You say 2012, I don't think it would have been for the whole year. How many weeks did you act in the labor court in 2012?
If I remember very well, Mr. Singh, it's 2012, it was just 2 terms.
And a term being how many days or weeks? Sorry, I don't know if it's different from the other courts.
6 weeks plus 6 weeks.
Okay, thank you very much. Thank you. Yeah, because, saying, just giving us the years there was quite confusing. It was, to somebody else, you'd think you served for the whole year. But thank you.
Thank you, Mr. Singh.
Thank you,
Honorable
Chief
Minister.
Justice.
Thank you, Honorable Singh. Honorable Minister.
Thank you, CJ. I must mention that I know Mr. Ngobe very well. They were our seniors, CJ, in Mpumalanga when we started practice as candidate attorneys. They are the one who showed us the way, including in the Black Lawyers Association. My question, Mr. Ngobe, maybe is to take from where the JP took the question with regards to your nature of your practice and the CCMA. Maybe you could use this opportunity to tell the Commission the labor-related cases that you have handled that you think could be of benefit to this Commission, either as a practitioner or in the CCMA. What type of matters, and briefly.
Thank you, Minister. I'll just put it in this way. As a practitioner, I've been receiving instructions on unfair dismissals, unfair labor practice, and some of them are dismissal based on operational requirements, and some legal advice. And that is when I'm in the office practicing as an attorney. Some other times is when I'm sitting as a commissioner at the CCMA or parenting council or any other parenting council for that matter. We receive different matters that I had to deal with personally when I'm sitting as a commissioner. And different practitioners are coming in to present their case, to analyze evidence and make ours. Sometimes we receive instructions where you take matters on review on behalf of other people who were not happy about their disciplinary hearings or matters that are emanating from other bargaining councils. So it's a variety of cases over a long period. And since I'm not alone, my office is dealing with matters of different nature based on labor law. And I help my candidate attorneys or my PAs as to how to deal with these matters, how to approach the labor court, how to brief counsel for purposes of helping our clients on different labor issues.
Yeah, I'm also interested in this doctorate on the rule of law. What is your understanding there of the rule of law, and how do you think it could be, this study that you're doing, be beneficiary to our country?
I can't hear you well, Minister, sorry.
I'm saying I'm also interested in the doctrine that you referred to, the topic you are dealing with, on the rule of law.
Yeah.
And it has been a recurring question for most of the candidates here. So what is your understanding of that, of the rule of law, and how do you think this study that you are doing could be beneficial to our country?
Oh, thank you, Minister. The rule of law, it helps me to make our clients to understand what is required in terms of the respect of the law, and possibly if there's a need to challenge particular violation of human rights law, we are able to help and give advice and write opinions for that matter. And also training of my candidate attorneys to understand the nature of law, that you can be in a position to read and understand the Constitution and how is it applied, and the constitutional practice, how is it being done, enforcement of the law in different fields, how can it be done? Because my interest is when I started LLM doing human rights and constitutional practice, it made me to continue to finalize my studies in law, to register for the LLD as part of the law that I chose as my, I'll call it my specialty or area of interest for the purposes of practicing law as a whole. And Constitution as the main law in South Africa makes us to understand all the fields and how to practice it and to give advice where it's necessary.
Thank you, CJ, and thank you, Mr. Ngor.
Chief Justice, could I follow up, please?
Thank you, Honorable Minister. Is that Advocate Madonza?
No, it's JP Mlambo.
Oh, yes, JP, please follow up. Sir.
Thank you, Chief Justice. Mr. Nkosi, good evening.
Good evening, JP.
I'm just following up on the questions the JP asked you about your exposure in labor matters.
Yes.
You list in paragraph, I think 9.3 of your questionnaire that you've said in civil trials, criminal trials, motion court, and whatever. The JP pointed out to you that they've looked everywhere, they can't find any judgment that you've written in the labor court, yet you acted there. Are there such judgments?
Well, JP, I do have judgments as to whether they were not kept in a place where they could be found from the archive of the labor law. I'm not sure. I could not have any control after we passed judgment during that period between 2011 and 2012.
But you are asked to list cases that you think are important in the questionnaire. And since you are applying for the labor court, I would have expected you to write what those cases are and attach some of them, because that's what we've seen in these interviews. Candidates do that. Is there any reason you didn't do that?
Well, JP, it might have been an omission, mistaken omission, not to take them one by one and to put it there as an indication of these are labor matters. These are different matters on different laws of the country. But I spend time and I finalized those judgments, and they were not even taken on review or appeal.
Okay. Thank you very much, Chief Justice.
Thank you, Judge. President, Professor.
So sorry, follow up, CJ.
Okay, sir, please proceed.
Thank you. Are you able to give an estimate number as to how many of those judgments you did at the labor court?
In the labor court?
Yes.
They are not more than 5, if I may estimate now, because I've got so many judgments that I put them together as a part of the work that I've done from different court divisions.
Thank you, CJ.
Thank you very much, sir. Prof, over to you.
Thank you, CJ. I think I'm covered by the JP's questions. The second JP.
Thank you very much. Honorable Moima.
Thank you, Chief Justice. Good evening, Mr. Nkosi. The site of the site of the. Thank you. Thank you, Mr. Nkosi. I just want to get your view in terms of the importance of the right to collective bargaining as an area that is beginning to generate a lot of interest, particularly given the
I'm saying that I want to get a sense in terms of your appreciation of the importance of the right to collective bargaining, its purpose, given the current impasse between the unions and government. But I don't want you to get into the specifics because it's a matter that is currently running, but much more at a theoretical level. Do you think it has a negative impact in terms of the strides that we have made in terms of protecting the workers' rights? Thank you. Chief Justice. Thank you, Mr. Gozi.
Thank you, sir. If I understand you correctly, you are asking me about the rights of bargaining.
Collective bargaining.
Collective bargaining. Yes. Well, it's a broad question, of course, because collective bargaining help us to have at least industrial peace, because this, you'll remember in the past, the labor relations was not as it is actively seen happening right now after 1994. So many people are now unionized, and the unions are based on sectors. So they help people to understand their rights and their obligations in terms of labor relations, and to make sure that this industrial peace is all about collective bargaining, understanding each other, the needs and the obligations, so that there can be more economic growth on an industrial place which is peaceful all the time.
The second question, now where there is a sense that one of the parties is disengaging from the collective agreement, do you think it augurs well for the right of collective bargaining?
The Labor Relations Act as is help us and many people to understand what is it that needs to be agreed upon, negotiated, the changing of rights where there's a need, and amendment of new legislation about Labor Relations Act, and is continuing its jurisprudence in process. It's not something that is as an event that it has happened to stop there. Hence, we're talking about bargaining. Each time there's a new issue that needs to be arranged, bargaining will be the best tool for the people to understand each other and to allow people to have a right to approach the employers so that they can talk about things that needs to be changed or those that need to be cancelled. So things are getting better in South Africa with the new constitution and the Labor Relations Act as is today.
Thank you, Chief Justice. Thank you, Mr. Gozi.
Thank you, Honorable Moimang. Thank you, Mr. Ngobenkosi. You are excused.
Thank you very much, CJ.
Chief Justice.
Good evening, Advocate Tahani.
Good evening, Chief Justice. Good evening, Commissioners.
Chief
How are
Justice.
you, ma'am?
Chief Justice.
Yes.
It's Commissioner Tepe. I just wanted, I have no questions, but before the candidate started, I just wanted to declare that the candidate was nominated by Mr. Maineche, who happens to be my husband, and I just wanted to put that on record. Thank you.
Yes. No, thank you very much. And just to add, you informed us in advance that you were not even aware of it and sought our views on whether or not we think you should recuse yourself. And we said there is no need. Thank you very much for putting it on record, Commissioner Tseto.
Thank you, Chief Justice.
Advocate, we're sorry to keep you waiting until now. I'm sure you've been observing that this has been a trend. We're really sorry it wasn't delivered.
Apology accepted, Chief Justice.
Thank you very much. You have spent a lot of time and probably almost all your life since obtaining qualifications dealing with labor-related issues. Am I right?
That is so, Chief Justice.
And did your postgraduate diploma in labor law that you passed with distinction help you in dealing with labor matters better?
It certainly did so, Chief Justice.
So how many years did you spend with the Department of Labor?
That would have been around 7 years, if my calculation is correct.
Yes, and with BP, dealing with employee relations issues?
About 4 years, Chief Justice. And it was not only dealing with employment relations matters, it was also serving under the then CEO as his executive assistant, which gave me exposure into the business side of the multinational entity of BP South Africa.
And you then went to private practice, and you've been there for, is it for over 8 years now?
Yes, it's about 8 years and 5 months. Before joining private practice, I was headhunted to join the South African Post Office as a senior manager of labor relations, and I spent about a year with the Post Office.
So it has mainly been about labor law, labor relations.
Indeed, Chief Justice. It has been about labor law, labor relations, and I would just like to mention that at the time that I joined the Department of Labor, that was at the dawn of our democracy. I had just been admitted as an attorney at the university, at the Western Cape High Court. And it was a time of our new dispensation. There were a number of labor laws that were promulgated at that point in time. The Labor Relations Act, 1995, the Basic Conditions of Employment Act, 97, Employment Equity Act, 98. I could go on. It was a critical time, and my joining the department at that point in time gave me the working knowledge of vast pieces of legislation, including legislation operative in the public sphere, the Public Finance Management Act, and various prescripts in the public service, the Promotion of Access to Information Act, the Promotion of Administrative Justice Act. So it was a vibrant time for me, and I feel that I joined at a very good time in the sense of my growth in labor law.
But even as you served as a professional assistant, you went to a firm of attorneys that specializes in labor law, Puke Maseremule Incorporated. Is it so? Isn't that so?
Indeed, Chief Justice. That was a very short period that I spent at Maseremule Incorporated. But yes, it is a law firm that specializes in labor law.
And you've acted as a judge of the labor court as well. I see you've attached judgments.
That is so. In March of 2019, in the first term of last year, and I am currently acting as a judge in the labor court for the second term this year.
Thank you so much. Colleagues, may I have the names of those who have questions for the advocate, please?
Lukele.
Very well. Sorry, is that you, Commissioner Singh?
Yes, Chief Justice, thank you.
Was there another colleague as well?
Lukele.
I didn't get the name just almost at the same time with Honorable Dodov.
It was Schlemmer and Lukele.
Or was it you, Prof? Who else?
Lukele, my colleague from Netlet.
No, you. Okay, sir. So it will be you this time. Okay. Okay. Yours is automatic. One of you come immediately after the JP. Any other person? Any other colleague?
Did you get message?
Yes, I've got you here, SC.
Thank you.
Thank you. Judge President, over to you, sir.
Thank you, Chief Justice. Advocate, not many questions. The first question I want to ask you, I see that since your admission, you practiced as a lawyer first, then you went to the department, then you went back to practice, then you went back to the department. So you've been, and then you went to private sector. So you were public sector, private sector. But I didn't see that you worked for any trade unions. Didn't you do any employee work?
I didn't work for trade unions, JP, in the sense that in the manner in which you relate, my working with the trade unions came in. I will commence at BP, where the scope of work that I was involved in was wage negotiations. So I sat on a number of forums within BP, consulting with unions around BP policies and also around wage negotiations. I also sat at the industry level of the petroleum industry where wage negotiations happened, and as you would know, strike actions as part of that process came into play. So that was my involvement in the sense from working with trade unions.
But you haven't. And now in practice, do you act for trade unions at all?
I haven't had the opportunity for acting for trade unions, but as trade unions are representatives of employees, I have in my practice had the opportunity of representing employees, even though they were not they were not members of trade unions, but I've done work where I represented employees in that sense.
I've looked at your CV and I find it quite amazing in the sense that you've done lots of labor work, you've gone through all the legislations which obviously are applied in the labor court. But other than that, when you went into practice, I noticed it wasn't just labor work, you've also done lots of commercial work.
Indeed.
Including tax.
Indeed.
I mean, tax shop is a closed shop, tax court. Very few can make inroads into that. And I see you with your mentor, it seemed, which is, I never knew the wife of the mentor is a commissioner, but Advocate Panache, SC, and he's also the one who nominated you. See, he used you in lots of labor, tax matters. He happens to be very much like you in a sense that he's an expert both in tax and labor law, and he does commercial work as well. And you've done lots of commercial work. I don't know why you want to come and impoverish yourself to be a judge.
Yes, JP. When I went into practice, I wanted to diversify my practice, given that I had spent approximately 12 years in the labor relations field. My first brief as a counsel was in tax law. And how that brief came about is because I took a decision to join a group at that time that was male, senior, and predominantly an Afrikaans group. I took a decision to go into that group because I wanted to learn. There is a saying that says, when the student is ready, the teacher appears. And because of my disposition, I attracted people who wanted to bring me under their wing. So most of the briefs around tax were handled by a white male senior counsel. So they brought me in and there was a skills transfer. I also wanted to further diversify and do other aspects of law, and that includes medical negligence matters. That includes matters of the RAF from the point of view where I was appointed in about 3 cases as a curatrix for persons who had been injured in motor vehicle accidents. My practice is diverse, JP. I have done commercial work, as you have said. I've also done a bit of trademarks and a general practice of an advocate.
And you've acted in the labor court on 3 terms. Do you still find that you still have passion for labor work? I thought you might by now want to diversify and go somewhere else.
I have passion for labor law. When I first walked into the labor court for my initial acting opportunity, I felt at home. My visits to the labor court was when I was still a manager in employee relations at the Department of Labor. And also when I was at Masermule Incorporated, I had the opportunity of visiting the labor court. So it is a court that I enjoyed visiting and practicing in. So coming in as a judge, for me, with my experience, working experience as an attorney, understanding how to bring a matter to court, the importance of serving documentation, the importance of the conduct of proceedings in court. Later on, as a legal advisor, a manager, and a senior manager in employee relations, understanding how at the cold face where I was involved in disciplinary inquiries, hearings, incapacity hearings, consultations, wage negotiations, and then coming as an advocate and learning the practice of an advocate assisted me greatly. So when I sit in the labor court, I feel that I'm at the apex and all my experience comes together, and that is the way in which I make a contribution as an acting judge because of my working experience.
The last thing I want to say is that I know and I've seen you've done more than 20 judgments. I've seen about 20 of them. And you said none of them on appeal. There is one on appeal, which is going to be heard in 2 weeks' time. But they have been reasonable. Thank you. I have nothing else. Thank you, Chief Justice.
Thank you, Jason.
Thank you, Judge President. Mr. Lekela.
Thank you, Chief Justice. Advocate, you spent only a year at the post office.
That
Is there a reason why you spent just 1 year?
Yes, there is a reason. When I just want to take it back a little bit. When I finished at university, I had always wanted to be an advocate. I had a discussion with one of my lecturers at the time who discouraged me from joining the practice of an advocate. At the time, pupillage was 6 months. And his words to me were, "You are black, you are female. If you join the bar in the Western Cape, you will go hungry because nobody will brief you. So rather pursue the profession of an attorney." I took on articles at an all-Jewish law firm. I was the only Black professional, albeit a candidate attorney at the time. With the greatest respect to attorneys, I did not enjoy the practice of an attorney. When I qualified, when I was admitted as an attorney, I began to think of other ways in which I can use my skills that I had acquired. And that is when the opportunity came to join the Department of Labor. And I've explained my role in the Department of Labor to the committee. I joined BP. I was headhunted at the post office. While I was at the post office, that nudging came to me. I was about 38 years old at the time. And I had a conversation with myself that I don't want to live a life of regret. If I don't join the bar now, before I turn 40, I never will. And so I took that decision. And I just want to mention at this juncture that there's a Nigerian poet called Chimamanda Adichie who says one should be careful of a single story. So I took the decision to be an attorney because I had a single story. I now have been enlightened by a book that I have read by advocate Tembeka Mugaitobi, The Land is Ours, where he gives a detailed historical account of the challenges that our forefathers in law faced in the early 20th century, where a conversation was also had with one of the forefathers, Poswayo, who didn't stay long at the Cape Bar because of racial discrimination. And when he wanted to join the Grahamstown Bar, he was told by an attorney, do not join the Grahamstown Bar because it will be economic suicide. So I was startled that a conversation that had happened in the early 20th century was the exact conversation that happened in the late 20th century with me. And had I known this second side of a story, I would have taken a decision when I left university to join the bar, to change that narrative. When I look at the woman that I have now grown into, I am a vehicle of change, and I make it a point to move into areas to begin to break stereotypes and change the narrative that Black females cannot be successful as an advocate. So to answer your question, at the post office, I took that decision, and I'm very glad that I did, because I am where I am today before an esteemed committee as this to now apply for a position as a judge in the labor court.
Chief Justice, I'm not too sure if I could then just ask this one last question of the candidate.
Please go ahead, sir. Please go ahead.
Thanks, Chief Justice. Advocate, the reason I'm asking, and I have understood the fact that you had a calling and that's where you were going. But here is a struggling SOE or a government-owned post office. They had hunt you.
Yes.
They really are desperate for your help, and you agree to join them.
Yes.
And then you only stay a year. I'm sure it was tragic for them to lose you just like that. And I understand that you're looking at your own path.
Yes.
But couldn't you just stay a bit more to add more value? I don't want to sit here and start talking about what the post office itself has gone through in the last years or so. Couldn't you just stay a bit to repay their faith in you as a person after being headhunted?
Commissioner, indeed, I was headhunted. However, when I joined the post office, the message that I received was, we do things differently here. And I just want to mention that one of the first tasks as a senior employee relations manager I received at the post office was to investigate a case of alleged sexual harassment against a male. I did the investigation. I spoke to the male concerned. I spoke to the female concerned. I spoke to persons who would have been witnesses. I produced a report. My report found that there was no sexual harassment. Irregardless of my report, the man was charged and dismissed. He then approached the CCMA on the basis of an unfair dismissal dispute. I was subpoenaed as the investigator, and in my place of employment, a conversation was had with me, which was the following. It is either you do not go to the CCMA, or you go to the CCMA and you do not disclose what your finding was. And I said, I can do neither. I went to the CCMA. I answered the questions that I was asked to answer. The commissioner at the time gave a very scathing report about what had happened. The gentleman concerned was exonerated. And I had a conversation again with myself. I am a person of integrity, and I did what was right. Yes, it was very uncomfortable for me, but the point is I didn't leave at that point in time. I still stayed on, and it was only the following year that I decided, as this knock was still knocking on my door, to join the bar as a pupil.
Thank you, Chief Justice.
Thank you very much, sir. Honorable Singh.
Thank you very much, Chief Justice. Good evening to you, Advocate.
Good evening, Commissioner.
Good evening. Just to confirm for the record, we've received your tax clearance certificate. So just to say that you did send that.
Thank you.
Good. Thank you. You know, what's been troubling me for a while, and I think it's troubling South Africa, is a very high unemployment rate, particularly amongst our youth. You know, very, very high percentage of youth are unemployed and really desperate. Now, you've been involved with the Department of Labor since its inception, or nearly since its inception. There are commentators who would say that our labor laws are what is preventing people from getting jobs. Although my belief is we must treat everybody fairly and provide them with proper wages, etc. What is your view? What can we do, you know, to shift this unemployment to employment, particularly of our youth? Is it the laws that are preventing us from doing that, or is it something else?
I think it's broader than that, Commissioner. What I have observed being a mother of a young child who is, well, a young adult who is now in her second year of university, is that the youth think differently than we do. So the traditional jobs of being a lawyer, being a doctor, being an engineer, the youth have moved away from that and are looking for ways in which they can express themselves as they are in their chosen areas. And it's vast areas that youth are looking at. Now, the entry into entrepreneurship opportunities is very difficult in South Africa. And if we could look at ways in which we can listen to the youth, hear what it is that they want to do, and begin to have programs to assist them, I feel that we will start making strides in the right direction to get the high number of youth unemployment down.
Just as a follow-up, will you be prepared to give that advice to the authorities that be?
Indeed, I'm always happy to help and to look for solutions. I think when we communicate and we are open-minded, solutions then come about.
I think young people are looking for torchbearers, and I hope that you could be one of those torchbearers.
I would be
whether you're
honored
appointed.
to. I would
Thank
be
you.
honored.
Thank you, Chief. Thank you, Advocate. Thank you, Chief Justice.
Thank you, Honorable Singh. Honorable Dodovu.
Thank you, Chief Justice. Good evening, Advocate.
Good evening, Commissioner.
Firstly, I want to express my appreciation from what I hear, and I admire your assertiveness and your conviction in terms of dealing with the issues as you explain them. Now, my question is in relation to the work that you have done. You indicate that you appeared severally on the dispute resolution mechanisms that are created below the labor court, like your CCMA and your bargaining councils. In your view, what are the impediments that makes it possible that matters that necessarily need to be tackled at those levels, at those dispute resolution mechanisms, to be taken to the higher courts or to the labor court? What could be the problem? Because in my view, other matters could be best be settled at those levels. In your view, what are those challenges and limitations?
The challenge, Commissioner, begins where the problem starts, and that is in the workplace. When you have clear policies and procedures on how to deal with issues of misconduct, issues of unfair labor practices, your disputes about promotions, your disputes about harassment, your disputes about victimization, disputes about poor performance, incapacity. When we have clear procedures on how to deal with those, they will not escalate to the next level, be it at the bargaining dispute resolution fora. And I say that because the work that I did in the Department of Labor was to ensure that presiding officers, line managers knew how to handle discipline, for example. It didn't necessarily have to lead into a disciplinary inquiry. A conversation could be had. If it is a matter of progressive discipline, well, that is where it ends. But should it be a misconduct hearing or a grievance hearing, clear procedures. The employees need to know what are their rights. The person who's presiding needs to know, the flow of the conduct of the proceeding. I put together a manual for training for presiding officers to handle grievances, disciplinary hearings, and incapacity procedures. I also put together a template as a report, because your report also needs to be clear. You have to set out the evidence that explains the reason that you have reached, and that will eliminate issues around appeals. You can never stop appeals. People will sometimes appeal because they feel that they were not heard or something was amiss about the process, and that is all well and good. But if you sort out those structures at those levels, those processes, they will not necessarily elevate. Now, at the dispute resolution level, where matters should not be there, I think they should be cut out. So issues around condonation or issues around the incorrect type of dispute that is being lodged at the CCMA or bargaining council, I think there has to be a point where staff look and see, is this something that belongs here, and advise the people so that it doesn't end up at a hearing and you find that you have no case.
Okay, I heard that. Now that you're talking of the presiding officers, in your view, what are the capacities of commissioners who preside on cases, especially on conciliation and arbitration? Do you think that those dispute resolution institutions attract people or recruit people with the necessary capacity, skills to can preside over those particular matters?
From the reviews that I have had to deal with at the Labor Court, my view is no. A lot more training needs to be done for the commissioners to understand what their role is and understand the nature of the dispute that they're dealing with. And in that case, that would eradicate the number of unnecessary reviews that end up at the Labor Court.
Yes, just my last question as CJ. In terms of the jurisdiction, I've noted that when there is a dispute between employers and employees, especially around issues of contract of employment, people prefer going to the High Court than going to the Labor Court because they think that matters will be expeditiously resolved at that level. What could be the reason so that, because this is a specialized court to deal with labor dispute, that what is it that can be done to ensure that such matters are handled at the level of the Labor Court without, so that they mustn't burden the higher courts, which are also pressurized in terms of the volume of the matters that they handle?
Yes, litigants have a choice in terms of Section 77 of the Basic Conditions of Employment Act. If it is a contractual issue, they may choose to either approach the High Court or approach the Labour Court. The Labour Court enjoys the very same jurisdiction. As you say, it is a specialized court to deal with labour issues.
Thank you very much. Thank you, CJ.
Please add me, CJ.
Follow up, CJ.
I'm adding you, Honorable Sigogo, who has follow-up colleagues.
It's Matanzela.
Please follow up, sir.
It's not Sigogo.
It's not Sigogo, it's Malema.
Oh, okay.
CJ, do you have me on your
I'm
list?
sorry.
I think I might have fallen off.
Prof, you are here.
Okay.
You are actually next.
Okay, thank you.
Okay. So it's follow-up SC. Please go ahead.
Thank you, Chief Justice.
Advocate Madonsala SC. I thought you had a follow-up.
Yes, a follow-up, CJ. Just on what Commissioner Todov has just conversed with you about jurisdiction. You know, I'm always amazed about the amount of technical points that come up of the labor court environment. You know, when the LRA came into force in 1995, we had such excitement about the process that was going to be quick fix for employees. But when you go to the labor court, I'm surprised about points, technical points, jurisdiction, local standing, non-joinder, prescription. You get hit with all of these technical points. And I wonder what's your point, what's your view about these jurisdictional points that get taken in the labor court and all the technical arguments that get raised time and again in the courts, and they don't seem to achieve the purpose for which the LRA was initially conceived. What's your view on that?
Thank you, Commissioner. Yes, a number of preliminary points are raised, not only at the Labour Court, but also at the High Court. I feel that if there is merit in raising the preliminary points, then so be it. If a pleading is excipiable, it is excipiable. For example, if a matter was not lodged, for an example, at the Labour Court, if a matter was not brought within the prescribed time frame for review, well, that is a point that must be taken with the greatest of respect. I don't think that preliminary points that lack merit should be taken just for the sake of being taken. I agree with you on that. But where there is merit in the preliminary point, by all means, it is within the litigant's right to raise those points.
That's exactly my concern. You know, that court is usually frequented by unrepresented people, non-lawyers, union members, who sometimes get overwhelmed by this. I mean, I as an advocate get sometimes overwhelmed with the amount of technical points, and I just wonder how much the unions can bear with this, and individuals can bear with technical arguments that keep on get raised by usually employers against poor litigants in that court, and I just find it just very odd.
Yes, Commissioner, might I add that my approach to self-representing employees or union members where there is a lack of understanding on the court rules is to advise them to approach either a pro bono office, and I make it an attempt to explain the procedure to them. For example, yesterday I was confronted with a situation where a self-representing litigant didn't know how to oppose the application that was served on him. He just wrote a letter saying what his side of the story was. So I made it a point to let him know that there are rules that need to be followed in order to oppose. And what he would need to do is to approach the pro bono office. Very fortunately, his opponent was not obstinate, and they agreed that the matter could be postponed for the purposes of him seeking the correct advice in order to oppose that particular matter.
Thank you, Chief Justice.
Thank you very much, SC Professor.
Thank you, CJ. Good evening, ma'am.
Good evening, Professor.
I'm very impressed to see the type of work that you are doing at the bar. And I was wondering why you have not considered putting your name forward to act in the normal court and not only in the labor court. Will you not get eventually, well, fed up with labor matters? You have a fairly diverse practice, it seems. And also when I look at the appointment to the Payments Association of South Africa's panel, that's also quite exciting new work, which you might not be able to continue. I don't know. If you were to be appointed to the Labour Court, would you mind commenting on that?
Yes, to start with the last one, Commissioner, I was appointed at the end of last year in October, and the first work only came about in March, towards the end of March. And then I had an acting appointment. So yes, to your point, that opportunity would have been short-lived. I have sought to work in the, acting appointments in the High Court in Gauteng. That didn't come to fruition. However, the door that opened for me to act was at the Labour Court where I was invited. And as I said, I enjoy that work thoroughly. I wouldn't get fed up or should this panel see it fit to appoint me. What I would like to do in a number of years after I become settled is to seek acting appointments in the different high courts so as to expand the experience that I have already acquired as a counsel.
And what is your judicial philosophy when you sit in the Labour Court?
My judicial philosophy is, and it really comes from my upbringing, is to always have in the forefront of my mind the democratic values of human dignity, equality, of freedom in the manner in which I conduct the court proceedings and in the manner in which I pen my judgments. And when I say it is from my upbringing, it is because as a very young girl in the 1980s, my family, and this was the vision of my father, who is late now, decided that the family should live in a neighborhood that was all white because he saw himself as equal, as dignified, and he believed in the value of freedom even back then. So those are the values that are naturally inculcated in me, and that is my judicial philosophy.
Thank you, ma'am. Thank you, CJ.
Thank you, Professor. Advocate Mpofu.
Thank you, CJ. Good evening, ma'am.
Good evening, Commissioner.
Thank you. Well, I've been covered on the issue of jurisdiction. Firstly, happy birthday for yesterday.
Thank you very much, Commissioner. I'm
Yeah.
still feeling celebratory. Thank you.
Well, yeah, keep it up. Thanks. No, I'm just worried. There's the issue that Commissioner Madonsela is raising. The background of the Labor Relations Act and the skewed bargaining power, which is inherent in the system, because you're going to have, you know, Anglo-American or the biggest company versus a cleaning person in that company. And as you say, some of the people don't even know what is a notice to oppose and all those kinds of things. So the system is directly skewed against employees. Given your background, should we be worried that because you come from the corporate sector, so to speak, that you might not deliberately have a bias, and maybe bias is not the right word, a leaning, yes, that's a better word, a leaning towards employers. You know what I mean? Inherently. In other words, your first, there was a debate we had here, for example, that prosecutors might have a leaning towards the state as opposed to accused.
Yes.
So it's that kind of question. You get my question?
Yes, I do, Commissioner. My stance is the following, that in Department of Labor and in BP, employment relations gave advice to managers, to the employer, as well as to employees. So in instances where it was clear that the employers were being unfair, advice was then given to the employees as to what their rights are to resolve whatever issue it was at that given point in time. So I am not inclined towards, because of my work experience, towards, you know, corporates. I think that would be grossly unfair.
Thank you very
And
much.
given that the Constitution says that everyone has a right to fair labor practices, whether you're a big company or a cleaner.
Thank you. Thank you, Chief Justice.
Thank you very much, SC. Honorable Malema.
Good evening, ma'am.
Good evening, Commissioner.
I thought I was not going to ask, but let me ask this. This thing of justice must not only be done, but must be seen to be done. So what does it say about you and all of us that you get nominated by a husband of a commissioner, and that commissioner sits here in her right conscience, sit here, and this commission appoints you? Do you think people will think that this was a fair process where husbands and wives nominate and appoint and nominate? Is it a fair thing to do?
Commissioner, I think I heard my sister commissioner saying that she did not even know, if I heard correctly. And I was not only appointed by Advocate Manager SC, I was also appointed by a firm of attorneys, another senior counsel, and an attorney who does work on her own and for our church as well. So my view on that is that she has made the disclosure, and I believe I heard her say that she made the disclosure even before I appeared before you.
No, but when you took that seat, she knew, she knows. She was sitting there, she's sitting here, she's going to be voting. Her husband nominated you. In the all fairness of judges and judiciary and neutral people, is it fair from a layman's perspective who's watching this from public that husbands and wives are nominating and appointing like that? They don't have that detail we're talking about.
Yes.
Of attorney and all of that.
Yes.
Is it sufficient to just declare and sit there and proceed like nothing is happening in the right conscience and in the eyes of the public?
I'll start with my conscience. I didn't even know the commissioner was married to Advocate Manager, and this is not an appointment of a husband and a wife. This is an appointment by Advocate Manager in his own right. And Commissioner, I don't know your processes here when a decision is taken. She has made the disclosure. I would respectfully leave it up to the Commission to decide at the point when decisions are being made whether she's a part of that or not. But for me, I certainly did not know, and I take your point about justice must be done and must be seen to be done.
Thank you, CJ.
Thank you.
Thank you very much, Honorable Malema. Advocate, you are excused. Thank you so much, ma'am.
Thank you, CJ, and thank you very much, Commissioners. I appreciate it.
Good evening, Chief Justice. Good evening, Commissioners.
How are you, sir?
I'm very well, thank you. I'm a bit nervous, but I'm also grateful to be here and excited that this process is quite close to its end.
We apologize to you for keeping you waiting until now, sir. We should be done by now according to our program.
Thank you, Chief Justice.
Thank you, sir. Just to help you out of nervousness, you are a holder of a BA Law degree, Bachelor of Laws degree, and a Master of Laws degree. Am I right?
Yes, that is correct, Chief Justice.
And you got them all from the former Rand Afrikaanse University, now known as the University of Johannesburg.
That is correct, Chief Justice. My master's degree revolved around the unfair labor practice. I obtained that degree in the mid-1980s when the unfair labor practice was quite new to our law. And I got a particular interest in employment law then, and I've, yes, been in labor law almost exclusively for the last 25 years or so.
Yes, the title of your dissertation was The Influence of Unfair Labor Practices on Rights and Obligations Deriving from the Common Law Employment Contract.
That's correct, Chief Justice. I remember one of the... Yes, sorry.
Yes, carry on, sir. Carry
I
on.
remember one of the articles that were written in those days by prominent lawyers or academics said, the sacred cow has been tethered. So management prerogative was seriously curtailed by the protection against unfair labor practices.
Yes. And I take it that you based your dissertation on the then Labor Relations Act to the extent that it dealt with unfair labor. Was it unfair labor practice? There was something about unfair labor practice there. Remember that that concept was articulated by the likes of additional member Bulbulia, Landman in the early days.
That is correct, Chief Justice. I started my litigation career in the old industrial court.
Yes. Yes, carry on, sir.
No, so those names I know quite well, not personally, but I've had dealings over the years as a legal representative appearing in the various tribunals. Yes, I was also very academically interested earlier in my career in the sense that I wrote some academic comments. I haven't had time to do so in the last 20 years or so. Thank you.
Thank you. And you have spent almost the whole of your working life dealing with industrial relations, labor relations related matters. Am I right?
That is correct, Chief Justice.
Thank you. You've acted as a labor court judge. I have noticed that you've attached some judgments here. Am I correct?
That is correct, Chief Justice.
And is it fair to assume that you found it easy, given your area of speciality, to function as an acting labor court judge and to write judgments without delay?
That is correct, Chief Justice. It wasn't difficult for me to adapt to those circumstances. I have some 20 years experience as a statutory labor arbitrator, also referred to as a commissioner and a senior commissioner for the CCMA and various bargaining councils. So I think I must have written, I would say, over 1,000 of awards and rulings over a 20-year period. When I wrote my representations or my response to the comments from the various law bodies and sent it to this commission early in April, I did not have the numbers, but I have received some information in the last 2 weeks that suggests that of those many awards and rulings that I've written, 120 of them were taken on review of my Johannesburg commissioner work was taken on review, and one in the Western Cape. So according to my information, there's been, say, 121 review applications against my awards and rulings, of which 13 appears to be pending since 2016, of which 4 were withdrawn, and of which 6 have been successful.
Thank you very much.
Thank you, Chief.
Yes. Okay, I hope I have helped you out of your nervousness. You seem to be much better now.
Thank you very much. Yes, Chief Justice.
All right, thank you. Colleagues, let me have the names of those apart from the JP and either Mr. Mkalipi or Mr. Lukele would want to put questions to Advocate Van der Merwe. Thank you. Judge President, over to you, sir.
Sorry, Singh.
Okay.
And Dodovu, CJ.
Thank you, sir. Thank you. Judge President, over to you, sir.
Thank you, Chief Justice. Mr. Van der Merwe, you now live in George. Tell me, do you do any labor court work at all? Because I'm in Cape Town and I've never seen you appear in the labor court at all.
Judge President, I moved to the Garden Route area in February of 2018. For the remainder of 2018, I remained a member of the Johannesburg Bar. I commuted regularly. I continued also to do my senior commissioner work. 2019, I resigned from the Johannesburg Bar and I joined the South Cape Society of Advocates. We are associate members of the Cape Bar. I've tried to expand my practice because there is, of course, no labor court building in that area. The closest is Cape Town and Gqeberha. But I've continued to receive briefs and I've continued to appear in Cape Town and in Johannesburg. But yes, the work has been less.
When last did you appear in Cape Town?
I appeared in Cape Town, it would have been in 2018.
And yeah, do you think doing work for the CCMA and writing awards is like writing a judgment in the labor court?
No, I recognize, Judge President, the difference in status and to an extent the...
Status has nothing to do with it.
I apologize, I couldn't hear you.
It's not an issue of status.
Yes.
I'm saying, do you recognize that that arbitration award and a judgment are vastly different?
Yes, no, they are different in the sense that the work the court does, I think, is to an extent a bit more complex. But I am faced very often as a commissioner with conflicting arguments, even conflicting judgments, precedents. And most of my awards are very, well, all of them are well reasoned, but I always do the best I possibly can to make the document look like a judgment in the sense of a proper arbitration award, reasoned and motivated.
Yeah, but that's not what the law requires, does it? That's not what the law requires, does it? I mean, the Labor Relations Act asks of you to do something quickly and with as little formalities as possible. Isn't that the reason perhaps why more than 120 awards of yours have been taken for review? I mean, it occupies judges. 120 reviews would take over a month for a judge to deal with. So you keep a judge occupied for over a month to reviews which you spend time doing very thorough judgments. Whereas, don't you think if you had done short, good judge awards, which is what an arbitrator is required to do, maybe they might not have been so.
Judge President, my awards are not long awards. They're well written, well motivated. I take cognizance of different arguments as far as they are presented to me concerning the law or different precedents. And I don't waste time, Judge President. I do my work very quickly. I haven't had a late award in 20 years. I have to issue them within 14 days. They are succinct, but they are well motivated and well written.
Thank you. I also wanted to ask you, you're a counsel, you're an advocate. I found it quite surprising. I think you're the only candidate that I know in my years of sitting here in the commission, and I don't know what the other commissioners' experience is, You're the only one who hasn't been nominated by a practicing advocate or an attorney. You've been nominated by a co-commissioner, isn't it? By Timothy Boyce.
That's correct,
Yes.
Judge President.
Okay, thank you. I have no further questions. Thank you, Chief Justice.
Thank you, Judge President. Is it going to be Mr. Mkalipi or Mr. Lukele?
Lukele. I don't know if
Over
Mr.
to you,
Mkalipi.
over to you, Mr. Lukele.
Thank you, Chief Justice. Just two questions, Advocate Pandarmele. You don't seem to have stuck to any job other than when you are self-employed. Is this a true statement or not?
Commissioner, I was employed early in my working life by different corporations or organizations. I soon in my life preferred to be self-employed, initially as a labor consultant. So I've worked, yes, for a number of institutions, but I was employed for periods up to 2 years, I think, and then became self-employed.
Yeah, that was my worry, that you didn't seem to stick anywhere at all, but that is all right. My second and last question would be, what role has the Constitutional Court played, in your view, in the labor market and in labor jurisprudence?
I'm sorry, I couldn't hear the question fully, Commissioner.
The role that the Constitutional Court has played in the labor market and in labor jurisprudence.
Yes, the Constitutional Court have, of course, decided a number of important issues. For example, the labor broker issue. When I do my work, I make sure that I apply and decide matters on the basis of the labor laws, and of course, all of them subject to the Constitution. And the Constitutional Court is the Supreme Court. They decide these matters, and of course gives much